Guys, how is everybody doing? So we haven't started yet, so I thought this would be a good time to go over our calendar of upcoming things. Tomorrow is February 7th, so there's going to be Diamante Kendrick, and now this case, his name is spelled wrong. It's spelled as Kendricks with an S. It's his probation revocation hearing. It's going to be in front of Judge Melanie Leftridge. That's at 9:30 a.m. tomorrow, and Law and Crime said they will record it, but they have to upload after the proceeding is done per orders of this judge. So, there will be a camera feed, but it won't be live. So we'll get to that maybe on the lunch break for the ASAP Rocky trial tomorrow. We also tomorrow have the pretrial conference, probably the last one, who knows, in front of Judge Paige Reese Whitaker. Now, I believe this one will be, there's already Rule 22 in place. So we could probably watch that live. We'll hear some motions argued and get the last little tidying up done before we get ready for jury selection. And then tomorrow also Courtney Clenny motions hearing at 10:30 a.m. And this is going to involve a motion to compel the deposition of the lead prosecutor. Because what else is new with these prosecutors these days? And then all the way moving forward to February 2021, remember we're going to have this property seizure proceeding, a hearing, in relation to all the property that was taken from Jeffrey Williams. And then that same week, Diamante Kendrick, his case management for the case that relates to, the jail fight. While he's been in jail, he got in the fight. And that's going to be in front of Whitaker. So that's a catch-up of hearings to look forward to. There's like a whole block of stuff to pay attention to tomorrow. We'll jump around and get to whatever we get. We might do 2 different streams. I know. Nicola says Jeff was so looking forward to Courtney Clenny. I was like so excited to chop it up with him about that, because I don't think he ever saw her personal journal notes. So that was one thing I was thinking, he really missed. I can just imagine Jeff going through and reading, she documents some stuff in her journal that relates to the relationship and the case, and it'll be like a sad story that she's documenting. And then the very next journal entry will be like a shopping list for things she needs for an OnlyFans skit she wants to do. And every time I would read one, I would think of him. So, rest in peace to Jeff, Legal Vices. Hey to Fun Size. Trikisha says, hey to the collective. Welcome, welcome. Jenny, yes, you were first, Jenny. You win the chat today. Kendrick, this was super, super nice. Kendrick says, Kat, your podcast is absolutely amazing. One of the best, hands down. You're very intelligent and make the viewing of what we're watching very interesting. So this is super kind. Thank you so much for saying that. Thanks for hanging out. Chat, thanks for not scaring Kendrick and others away. Thanks for being super welcoming. Hey to Rasomi. Hey to Tamra. Hey Asia. Violet's here. Violet's ready. Today, you guys, so the state is supposed to be resting their case in chief. I saw it said one more witness, and I don't know if that just means Detective Flores is the last one. We still need to get this ballistics person in, who's going to say that the casings could have been fired by a Glock 43. Right? So I imagine we're getting Flores, getting him off the stand today, getting to this ballistics person, and then the state will rest. At that point in time, the defense could motion for a directed verdict. I personally don't expect one from this judge, but there's others that think that because Relly has made undeniable, inconsistent statements, that maybe a judge could find that no reasonable person could think the evidence presented supports the charges. So we'll see. I personally would love to hear the arguments for the directed verdict either way. I think they'll be a little sassy. And although maybe they'll be delivered by not Joe. But I don't expect them to be granted. And then we'll get to the defense's case in chief, and it seems like 12E's first on their list. So that's going to be... I'm looking forward to seeing him testify for sure. Also saw it reported... Was it Mel? I don't have it pulled up, and I saw it 2 days ago. But it was said that Ben and Camille weren't in the courtroom all of a sudden after being there every day. Now, they might have just had a calendar conflict. They might also just not be showing up every day. I don't know what to make of it, but just relaying that to you guys. Good stuff there. And, you know, I don't think it's unusual for them not to start right on the dot. And, you know, in Law and Crime, they don't have any tweets updating that there's a delay or anything like that. So hopefully we'll get started soon. Also, for what it's worth, if you guys didn't see my community post, Linda and Michael, they're standing by their reporting that the judge did make a statement to the prosecution team, like, are you sure you can ethically continue this prosecution? They are standing by it and say they have 2 sources that say it. So there's that for an update there from a rant I went on in the middle of the stream 2 days ago. And oh, we've got one other thing that's really relevant to this, you guys. Let me pull up the picture. And this is not, oh, the picture, the video itself is crazy. It's only crazy because of Relly's own testimony. So you guys heard me shout out Goku Fan the other day, because Goku Fan found that interview with the attorneys, Brian Hurwist, and I don't know the other attorney's name, but they were like, well, we actually haven't even seen the video yet, but we hear it captured the whole thing and supports what our client is saying. Goku Fan 6661 uncovered that. Also pulled up this gem. Now, in this clip, you see Relly over here holding a starter gun, a starter pistol, which, whatever, that wouldn't be a big deal. But what did Relly tell us on the stand? What did Relly tell us? He doesn't know anything about that. Never known Rocky to have one. Here we go. So, it's just another one of those things that makes him inconsistent. So, what else is new? Also, hey to Minnie Perkins. Hey to Amber Lee. Hey to Raylyn. Hey to Lamar. Lamar's like, let's get it. No more holdups. Let's get into it. Let's see. Gwendon says, was supposed to be Karen Reed tomorrow, but they wrapped it all up today. Oh, I didn't know that. I know that I thought that was going to be... I don't know. Did the tide change a little bit? Because we had a 2-day Daubert hearing for the medical expert, the one that was going to say the bites were what she's used to seeing with dog bites. And that ended up being 2 days. Are they suddenly like, all right, we're not going to drag every single little thing out anymore? So I think that's good. I think that's good that they got it all done. But, oh my goodness. The Karen Reed trial is something else entirely. Yeah, Brittany Gibbs has never heard of one. Relly said he's never heard of one. Let's see. I see someone asking Chloe about rugs. What are we doing? Gotta get my rug sales up? What are we doing? Rugs are expensive. Rugs can be real expensive. And going in with the update, there's Brady violations that have been revealed. All right, so that would explain new need for a motion to dismiss. I'm telling you, the Karen Reed cycle is like the Sisyphus boulder story. You know, Sisyphus is like doomed to be going uphill forever while also pushing a boulder. Just forever and ever and ever. And that's kind of, to me, what the Karen Reed trial feels like. Yeah, everyone's very excited for that. Darissa says excited for that, the second trial. And you know, these second trials too, you've got the YNW Melly going into a second trial. You've got Raven Liberty, the attorney. Also, and again, another Florida case, another defense attorney, defense team, making motions to compel the deposition of the lead prosecutor on the case, just like in the Courtney Clenny case. So hot messes all around. It never ends, especially when it comes to Florida cases. I think there's a little bit of extra attention. A lot of the cases are pretty transparent. You know, it's pretty easy to get records. So for what it's worth, even though prosecutors still can't seem to just, like, in my opinion, they could win their case and defeat Courtney Clenny's self-defense claim without any funny business, but they chose to engage in funny business anyway, and it's a whole mess. It's a whole mess. They didn't need to do that, but they did. So, oh my goodness. Shout out to I'll Say When says this is the best channel. Big part of that is because of the chat and the community. So, Who said it the other day? The ASAP mods. Big shout out to the ASAP mods. Here comes drama. I almost said genre. Thank you so much for gifting. Now, I am glad you were in the chat because I have been looking, and you got to find someone's name to be able to do this. But everybody give a warm welcome to Here Comes Drama, now part of the ASAP Mods Collective. So you won't see the wrench on screen, but the next time I catch her comment, we'll catch her with a wrench. Let me see. Oh, not there yet. Maybe next time. Maybe this was before I just gave her the wrench. Okay, so they're filing into court now. Let me refresh it, you guys. And let's get some love in the chat. Not only is Here Comes Drama part of the ASAP Mods Collective, but also just gifted 5. So make sure you're saying thank you. I'm so glad you're hanging out with us. Here Comes Drama. And there we go. Now I see the wrench. So big congrats there. Big congrats. You don't actually have to do any modding things, but if you ever need to share a link, again, you know, at the end of these streams when we're looking for somewhere else to go, drop whatever link. Am I freezing again? Am I freezing again? And you know what? Let me open Court TV. Because I think Court TV started their feed a little bit earlier the other day. Court TV. Okay, they're like up, but it's just their logo and music playing, so they're not live either. They're like live, but it's not the courtroom. All right, if I freeze, I just hope it's in a good frame. So big thank you here again to Here Comes Drama. Thank you so much for the gifting. Chloe Albert's Revenge says, hit the like, then head on over to the merch store for your Relly rugs. They come in black and blue, going fast. Get your Relly rugs, that way Relly can lie in your home too. How did you think of this whole, like, rug and lie thing for Relly? Oh my goodness. Oh my goodness, Chloe. Put some clap emojis in the chat for Chloe, the resident comedian here. I don't even want to say resident comedian because the comedy travels wherever Chloe goes. Oh my goodness. Yeah, that is a bar. Leah's dad said that's a bar. Oh, I love this. I need the belly laughs today. My morning was a bit hectic. This is a great laugh. And shout out to Flesh of the Gods coming in here, dropping 5 as well. Drop some goats in the chat for Flesh of the Gods. We've got the court feed live. We're going to thank our stream sponsors, pretend that they got this court feed going. We're going to get into it. And you guys check out Flesh of the Gods channel.
Detective Flores, we're still on good mode from when you were here last time. This is Tacopina, his questioning, and this is Tacopina Flores.
Thank you. Good morning, Detective Flores.
Good morning.
I'm just going to rewind for a few questions, just to reset the context. You can start talking about the surveillance videos, okay?
Okay.
All right. So the sequence surveillance video overlaps video from 1616 East Del Mar with video and audio from 6200 Hollywood Boulevard, correct?
Correct.
All right. And you agree that 1616 East Del Mar video has no sound?
Correct.
But the video from 6200 Hollywood Boulevard does.
That's correct.
So you overlap the videos from each location trying to show when the shot would have occurred during the 1616 East Del Mar video.
Correct.
Of course, we agree on this already. If your overlap is off even by a fraction of a second, the shot would not have occurred during the precise moment shown on the overlap 1616 East Del Mar video.
That's correct.
And in order to determine when the overlap in order to determine when to overlap the shot heard on the 6200 Hollywood Boulevard video with the 1616 East Del Mar video, you need to first figure out when that shot took place in relation to the 1616 East Del Mar video.
Yes.
So you use a visual benchmark for both videos, something that you could see in the surveillance videos from 1616 East Del Mar and 6200 Hollywood Boulevard.
Correct.
And that was the floodlight turning on.
Yes.
And you saw the floodlight turning on in camera 2, and just to be clear, camera 2 is file. The file number, like based on these filings, was file 18221-716 from 6200 Hollywood Boulevard at 10:17 and 26 seconds.
I believe that's correct.
Now, but even seeing that floodlight in both videos, there would have been only 2 ways to use that benchmark to determine when to overlap the 1616 Beast of the Mar video and the 6200 Hollywood Boulevard video at the early moment when the shot would have occurred in the 1616 Beast of the Mar video, correct?
I'm sorry, sir.
Yeah, I gotta do that one again.
I didn't understand.
A lot of words in that question, but I'm not sure.
Yes.
We still don't know how to ask it. But even seeing that floodlight in both videos, the one we just discussed, that benchmark, that floodlight going on, right? Okay.
Is that yes? Yes, I'm sorry.
But even seeing that floodlight in both videos, there would have only been 2 ways to use that benchmark floodlight to determine when to overlap the 1616 Beast Del Mar video and the 6200 Hollywood Boulevard videos at the earlier moment when the shot would have occurred on the Beast Del Mar video.
I'm sorry, I think you lost me, sir.
So, the two videos, again, the benchmark for that was floodlight.
Correct, one of the benchmarks, yes.
What did you use to determine when to overlap the 1616 Beast Del Mar video and the 6200 Hollywood Boulevard video?
Again, it was just the totality of the videos, looking at the sequence of the floodlight, the individuals on the video running from one point of the camera to the other, just kind of looking at it in sequence over and over. Everything seemed to coincide with the sound from the 6200 camera.
Okay. Correct me if I'm wrong, I think there's 2 methods, and tell me if you use one of these 2. One would have been to rewind both videos simultaneously to the exact moment, right? Or, let me rephrase that, to rewind both videos, 6200, 1616, simultaneously the exact amount, 30 seconds, for example, right? Would that be one way?
That would be one way. I mean, anticipating that each individual camera system sometimes has its own time. It doesn't mean they're all automatically set at the first exact second or coincide with each other. But again, roughly looking at the light with the individual persons on those cameras, watching them in sequence, it's the best way I can explain it to you.
Okay. And the other way would have been to determine how much actual time passed on the 6200 Hollywood Boulevard video between the floodlight and the shot heard, and then use that same actual amount of time to rewind the 1616 Beast Del Mar video, right?
Yes, roughly.
Which of those 2 methodologies did you use?
I think we explored every option, just to try to gauge the best possible, but I can't tell you which one I believe was more accurate than the other. Again, I just looked at the totality of all these things to see that they coincided.
Well, my question really more is, which one did you use? How did you do it?
I mean, I looked at both. But I think the one that stood out more to me was, I think, the light, the floodlight.
I understand that, but I'm saying you rewind both videos, the 6200 and the 1616, to the exact same amount?
I don't recall whether it were rewinded to the exact second, but to the point where it coincided with the sound. And so, yes, I mean, to answer your question directly, roughly, yes, about the same time.
Oh, there was been once. I'm gonna play you a couple of clips, I'm make sure that we're ready, but when creating the sequenced surveillance video, it wasn't the exact science, right?
No.
Okay. Meaning, the overlapping was done by hand, right?
Correct.
In fact, I think that 55 seconds into the sequence surveillance video, you could see that little cursor being moved by hand in the upper right corner. Did you see that?
I don't recall that.
All right, we'll show you that.
Sure.
Which exhibit is this?
Is this people's 15 or we're using our own? This is people's 15 already. We'll use this one for this.
Let's see him explain his methodology.
Fifteen was thumb drive.
Okay, just switch it then. Use it.
I'm just saying it's 15, that's fine, you download it.
Although if you aren't looking at your screen and you want to take a quick peek, at the bottom here you can see how they're splicing different clips and overlaying them, and you can also see gaps between clips that are on the same track. So that's a little interesting if you guys want to take a look at the screen real quick. We'll keep it up for a few seconds here. Right here, what I'm talking about is this track at the these tracks at the bottom of the screen are how the different layers of video and maybe audio are being compiled manually by the prosecution team to make this compilation video.
That's fine, you download it.
We're using 15 now?
Same one, we're using
Anyway, once we get all this figured out here, at 55 seconds on that video, you're going to see hopefully, see if you can look at the upper right hand corner and actually you can see that little cursor being moved by hand, the upper right hand corner, at 55 seconds.
Okay.
See that? Cursor?
I do.
Okay. See those balls over there, those little round things? Did you see it moving around?
Yes, sir.
Okay. So that means obviously it's being moved by hand, by someone.
That would give me an indication that it is right.
And as you said, you saw the floodlight turn on in camera 2, which again we identified as files 18221-716 from 6200 Hollywood Boulevard at 10/17/26.
Okay.
And you heard the first shot on camera 2, different file number, which is 182220214, at an earlier moment, which you believe to be 30 seconds earlier based on the timestamps. Correct?
Sir, I'm not sure I understand your question. The two shots in different...
No. The first shot on camera 2, which was filed, well, 182220214. That's the name of the file number that I have to identify.
Okay.
You heard the first shot on camera 2 at an earlier moment, which you believe to be 30 seconds earlier based on the timestamps, right?
Correct.
So you figured the first shot would have occurred 30 seconds earlier in that same surveillance video in actual time.
Sir, I'm not
Okay.
understanding your question.
Did you, well, you agree that you said you went back 30 seconds, or 30 seconds earlier is when you heard that first shot, right?
Again, in comparison to the videos, as far as what the times they reflect.
Oh.
Yes.
And that's 30 seconds earlier than what the first video, camera 2 showed?
Correct.
All right. And use that same exact amount of time, 30 seconds, to go back on the 1616 piece of market.
I believe so.
You'd agree if the floodlight turned on less than 30 seconds in actual time, after the shot was heard on the 6200 Hollywood Boulevard video, that means you went back too far on the resale market, right? If the floodlight turned on less than 30 seconds.
Again, sir, this is, I mean, it wasn't an exact science,
No,
but,
I'm not criticizing.
so I'm not sure about the exact seconds that you're pointing out. So
Well, again, you just.
roughly, yes.
Right, what I'm saying is you just said you went back 30 seconds early based on the timestamps and what you observed.
Correct, just roughly within that period.
Right. So my question was, and again, I'm not criticizing your methodology, I'm just asking. If the floodlight turned on less than 30 seconds in actual time after the shot was heard on the 6200 Hollywood Boulevard video, that means that if you went back 30 seconds, that would be a little too far, right?
Could be, yes.
With regard to the 6200 Hollywood Boulevard video, you extracted 3 sets of videos from 3 different cameras maintained by the residents at that location.
Correct, that was what was provided.
And your understanding, those cameras run in actual time.
Yes, live.
But each camera, I think we've already discussed this last time we were here the other day. In fact, each camera is off from actual time by a different amount, between 2 to 3 minutes.
I'm not sure if it's that camera that was off.
Check that it misstates the stipulation.
What's the stipulation?
That's
Reread it.
35, remember?
Go over it with Mr. Siegel.
They won't approach, we do that.
Right, you first need to clarify something. You're on. All right, this does not need to be on the record. Come on up.
All right, so while they approach, I do see this News 12 thing. If this goes for a long time, we can read into it further, but it says there are calls for a full-blown investigation following a turn to terror report that the lead prosecutor in the Robert Durst murder trial, that's John Lewin, vacationed at the Hamptons home of Durst's widow. Oh my goodness, we might have to pull that deposition. At least that part. That's crazy. Emily C., my goodness. Prosecutors, man, prosecutors. That's why it'll be interesting to see if the ASA in the YNW Melly case, the lead prosecutor in Courtney Clenny case, both cases, there's motion to compel their depositions. So, oh my goodness. All right, wait, there's a little more we can jump forward. Pretty long sidebar. Sometimes they go up and then they come right back. So, okay, it's only a short clip. Let me open the article and see. This is calls for it, so let me find a more recent article. Because if they're calling for it, they didn't do it yet. This one's May 2024. Wait, was the deposition of Lewin or of the widow of Sheraton? Oh, what? Yeah. It looks like there's a deposition clip in here from the widow, from Deborah. So I'll keep this up if you guys want to like check it out now. Linking it in the chat, but we can look at that on a lunch break because I feel like as soon as I play it right now, they're going to come back from the sidebar. Really all right, so both of them. Okay, so I think the article I have has information from both. I don't know if it has clips from both. But if you guys are tuning in late, they're at the bench duking it out about something. We have Detective Flores on the stand still. It's cross-examination, and Tacopina is getting into not just whether or not the different pieces of the video surveillance footage that the prosecution compiled together, or the police department compiled together and the prosecution's using as exhibits in this trial. What's the methodology they use to make sure they align with the correct timestamps? We have video clips, we have audio clips, all taken from different cameras. And if you go back like 5 minutes in the stream, you can get a freeze frame and see how it's spliced and diced in an editing software to align and line things up. And he's drilling down into the methodology and concerns that, you know, you might have lined it up to make these floodlights turn on at a certain time that you're saying is pretty instantaneous with when you're claiming the two sounds that sound like gunshots occurred. But if there's even a slight inaccuracy, those floodlights could have came on for a different reason. Those floodlights could have came on because someone started to step foot in the area, and it could have been before shots were fired. So one of those things where a lack of precision, a difference of 30 seconds makes a huge deal. Heck yeah, Emily, see, that's really it, too. Just thought it was hilarious. Clearly, Tacopina decided to do some digging into Lewin. You can picture him, like, reading it, rolling his eyes, and going, this guy. Oh, my goodness. Good to see you, that guy, Nick. Have a good day. Yeah, and this is what's confusing to me, Teresa Trice, and it's kind of like, you know, there would be foundation issues, there would be issues asking this detective if it wasn't actually him that put it together. But he's allowed to ask him, so Flores has put it together. But Flores keeps saying we, us, and speaking generally. Now, does that mean a team of 2, 3, 4 people sat around the entire time this was being done? Or is Flores trying to use general language to, like, distance himself from the inaccuracies and not wanting to state factually that, yeah, this could be wrong, or there could be this discrepancy, or there could be this difference, or we can't exactly line this up, or know for sure if we've lined it up correctly or not. But did they really sit with, like, a pool of 3 people, or was it just Detective Flores? And really, what's his qualifications for doing this, if so? Yeah, Peter says the latter.
Let's just do this. Let's just play these a few videos for you, okay?
Okay.
The first video, and this is again, I want to show you about the timing. This is camera 1, which is file 18220-237. You hear the first shot at 10:15:53. Tell me if you agree with that. Go ahead. Okay.
That's correct.
Right, okay. That's it. So you heard the first shot on that camera at 10:15:53.
Yes, sir.
Okay. Now I'm going to play camera 2, which I'm going to identify again by file number, which is 18220214. And you hear the same first shot just over a minute later on this camera at 10:16:56. Tell me if you agree with that after listening.
Yes, sir.
Okay. So that was 10:16:56 on that camera, which is over a minute later from the first camera.
Correct.
And on the third camera, which is file 1A221240, you hear, hold on a second, right? You hear that same first shot 4 seconds after that last video at 10:17 on the dot. Tell me if you agree.
Yes, I do.
Okay. So a reason that the times would be off from each other is because at least 2 of the clocks are running faster than the other.
That could be a reason. Yes, independent systems.
Okay. And a reason that a timestamp on a camera would be faster than actual time is because the clock for that camera would be running faster than actual time.
Yes, sir. Just like here in the courtroom.
good example, just like here in the court. With that in mind, let's look at one more. Let's look at a video from camera 2, just before the flow light goes off. And now I think the defense is difficult to show, right?
DD.
DD, Your Honor. This is from 6200 Hollywood Boulevard. Again, I read the file number, I'll read it again. It's 18221716. The first, before I play, hold on a second. The first timestamp shown on this camera is 10:17:17.
That's correct.
Okay. And the video itself is at 0 seconds because, hold on a second. I just want to make sure we're in the same video here. We do have, in fact, the same video. Okay. So, I think you just agreed the video itself is at 0 seconds because it has not started yet, correct, sir?
That's correct.
10:17 and 17 seconds.
Yes, sir. On the clock, lower clock.
All right, let's play the video until the floodlight is on. 9 seconds later at 10:17:26. Go ahead, please. Okay, you see that?
Yes.
Floodlight on?
Correct.
I'm sorry?
Yes,
Okay. And it says 10:17:26.
it does.
And how many seconds faster than, how many seconds later from 10:17:17 is that?
9 seconds.
9 seconds. Yeah, how many seconds right off the clock?
8.
So that's something's wrong there, right?
Yes, I mean,
Okay.
whether or not it would stop right at 8 between 9, I don't know how to explain it.
Well, okay. The clock says.
Not helpful.
So it's 10:17:26 seconds, which is 9 seconds after 10:17:17 seconds. But
Lisa.
the video only ran 8 seconds, you can see that, correct? And the floodlight isn't back on, right?
That's correct.
All right. So this would indicate, at least here, that the video is about 1 second past here.
Could be within 1 second, correct.
Yeah. And given that, it's fair to say that the shot heard on 1616 East Del Mar should have been about a second later than shown in the sequence surveillance video, right?
It's certainly not my area of expertise as far as the way sound travels and light travels. I know they travel at different speeds, but that would be within my expertise. But that's correct.
Okay, that's correct. Okay. You put this together, the sequence surveillance video, right?
No.
Who did?
What?
I believe it was somebody in the district attorney's office.
Okay.
This is even worse. Why is he testifying to this if it wasn't even his department? Like his team. He said someone else now entirely put this together. Why is he the one testifying about this?
Off of this stuff now. Just 2 more things. And we're done. Now you can. You earlier testified
Yeah, you
about
did have
police
foresight.
officers who arrived at the scene on November 6th, 2021. Remember those 7 officers?
Yes, I do.
They were there for approximately 20 minutes, more or less?
I think more or less.
20 minutes, yes, okay. And one last thing, you submitted, I guess in January of 2024, evidence to the ballistics lab for testing in this case, right?
Thereabouts, yes.
And the testing was done, oh, I'm sorry. It was done it was submitted in December of 2023, right?
I believe that's correct.
I can just refresh.
I believe when the return came back, it's a different date than when it was submitted.
You're right. Just take a look, make sure. On the same page.
Yes, sir.
So that report was, I guess, finalized in January 8th, 2022.
That's correct.
And that was given back to you, this report?
Yes, it was submitted to myself and one of my partners.
But yet, that report was not given to the district attorney until about 2 weeks ago, for the first time, correct?
Yes, that's my understanding.
Over a year since the report was given back to you or one of the parties.
Correct, that's my understanding, yes, sir. I believe it had been given, but I could be in error. Correct.
Well, obviously, the district attorney represented that they got it the first time, 2 weeks ago.
Correct.
The DA, was the DA even informed of its existence, do you know?
I'm sorry, what point?
Now, at this point, it's going to be a 3-2 against the court standard.
That's it. Okay, thank you for your time.
Sir, motion to strike whatever answer was given. I don't know, was there an answer?
I don't think you gave an answer.
The question is stricken, and if there was an answer, that's stricken as well.
So
Mr.
the last question, correct?
The last question? Yes.
Okay, thank you.
Mr. Zolman, do you have anything?
I do, Your Honor.
Okay, go ahead.
Detective, when you were testifying, I believe that was on Tuesday, you were asked questions about the latent fingerprint examination of the fired cartridge cases in this case. Do you remember that?
Yes.
And as a detective, you said you have almost 30 years of experience as a police officer, correct?
Just past my 29th anniversary. Yes.
Okay. If I round you up 1 year, we call it just approximately 30 years.
I appreciate it.
Fair? Okay. Do you have an understanding of what could potentially impact whether or not you would find a fingerprint on any kind of object?
Yes.
What are some of the factors that you're aware of?
Time in which it was processed, the exposure to the elements, rain, water, foot traffic, cars, depending on where it's at, wind, other weather events, anything, other people going through the area or touching vehicles. It just depends on where the item is going to be processed, with conditions it's found in, and how long it's exposed to those conditions.
What about temperature? Is that one of the things that would be potentially affected?
Yes.
Objection to leaving.
Would exposure of a fingerprint to something of high temperature potentially impact whether or not it's able to be located later?
I think so.
You also said you've had extensive experience firing firearms, in your throughout your law enforcement career, correct?
Yes.
When a gun discharges a fired cartridge casing, when it first comes out of the gun, is it hot?
Yes, on a semi-automatic specifically, when it ejects the cartridges, just from personal experience, I've had them land on me. When we go to the police academy to shoot a qualified, we're on a line. So oftentimes the casings are ejected as the next person next to you is firing. So I've many times felt that the casing landed in my neck or in my collar, and they're hot.
In your nearly 30 years of experience, 29 years of experience as a police officer, can you personally recall any cases of yours where fingerprints were developed in the fired cartridge case?
None that I can think of.
And you said you've worked on homicide cases, correct?
Yes, sir.
A fair number of those involve firearms.
A good majority, yes.
Can you give the jury any idea of how many cases you think you've handled over your career?
Between homicide cases or cases involving firearms, as the lead investigator or assisting in investigations, probably to date, I would say probably in excess of 2,000 cases I've assisted or led.
You were asked similar questions about DNA evidence potentially on the fire cartridge case, correct?
Yes.
And based on your background and experience, do you have any idea of things that could impact whether or not DNA is present on an item?
I mean, along the same lines as fingerprints, exposure to the elements, contamination, anything from human contamination, vehicle, wherever it's exposed to, weather.
Could temperature also potentially impact it as well?
Yes.
In your almost 30 years experience as a police officer, can you personally recall any cases where DNA was developed on a fire cartridge case in one of your cases?
Not that I can think of.
After the cartridge cases are booked, in your experience as a police officer, can they be made available to the defense if the defense wants to conduct their own independent testing?
Yes.
In this case, could the defense have done their own DNA testing?
Yes.
On cross-examination, you were specifically asked if you observed any video of Mr. Ephron returning to the crime scene the night of this incident. Was there any video in this case that you ever had possession of that was captured after 11:20 p.m., capturing specifically that intersection of Vista Del Mar and Selma?
No.
I want you to assume, for purposes of a hypothetical, that victim in a case returns to a crime scene at 11:45 p.m. Would the video that you recovered that only goes to 11:20, would that video have shown that person's presence at the scene?
No, we would not.
You were also asked about Mr. Ephron's girlfriend returning to the scene. Assume the same hypothetical that she came back with that individual at 11:20. Would the video that you collected in this case, would it even show her?
At 11:20?
Sorry, if she returned with Mr. Ephron at 11:45, the video that only goes up to 11:20 show her?
No.
Okay.
Objection, Your Honor. This is the fact, not an evidence. It would just mean that they didn't have
Overruled.
the video.
No speaking objections. Overruled.
Okay. On cross-examination.
No, stop. No editorializing by anybody. Ask another question, Mr. Brazil.
Just one moment, Your Honor, trying to organize this stuff. In cross-examination, Mr. Tacopina asked you questions about your prior testimony at the preliminary hearing, and specifically read you a passage regarding whether or not you asked Mr. Ephron if he had firearms back in November of 2021. Do you recall that?
Yes.
Okay. In your testimony prior to that, were you asked,
Page 9.
page 269,
Which
line
volume?
5,
Which volume?
volume 2, Your Honor.
2?
2, yes.
Repeat the page, please.
269. I'm going to first go 5 to 11, Your Honor.
Can you read the question back?
Judge is getting lost.
On cross-examination, Mr. Tacopina asked asked you questions about your prior testimony of the preliminary hearing and specifically read you a passage regarding whether or not you asked Mr. Ephron if he had firearms back in November of 2021. Do you recall that? Answer, yes. Question, in your testimony prior to that, were you asked, do you have a page number?
All right, what was the next question you were going to ask?
As you read the question he was asked at line 5, and go through his answer.
That's not a prior inconsistent statement from what he said. Your question was, did he ask Ephron? That's not what this question asked.
Now, I wasn't offering as a prior inconsistent statement.
Why don't you just ask the same question that you asked the preliminary hearing?
Did you ever look to see what firearms were registered to Mr. Ephron
Yes,
at the time of the incident in November of 2021?
yes.
And what did you discover when you searched for any guns that would be registered to him at that time?
We didn't find any firearms registered to Mr. Ephron.
Okay.
Now, does that make you more confident or less confident that, Relly's story is truthful or fabricated?
Okay. In your nearly 30 years of experience in law enforcement, have you ever conducted an interview with a significant witness in a case and either not recorded your interview or not taken notes and not written a report?
No, not that I recall ever doing that.
As an investigator, can you tell the jury why you either record your interviews or take notes and then write a report immediately following your interviews?
I like to record because it's 100% accurate. And the reports are done generally for our purposes as a summary, kind of as a refresher, to identify key points that were made during the interview. But again, my preference has always been to record because that's always 100% accurate.
Would you ever interview a witness and not record your interview or not write a report or not take any notes of that interview in your experience as an investigator?
Objection, Your Honor, relevance, whether you would or would not.
Make an offer of proof. Well, the first question is a significant witness. Now you're asking any witness.
Okay, I
So, any witness, that question's irrelevant. The answer would be irrelevant.
Sure. Imagine a scenario where you interviewed somebody months prior. Hypothetically, you did not record this interview, you did not write a report, and you did not take any notes. Then months later, you go back and try to summarize what that witness told you. Is that something that and that witness is a significant witness in your case that you're investigating, is that something that a trained police officer such as yourself would ever do?
Objection, Your Honor, with cold speculation.
No.
Why not?
I mean, it's just not accurate. Again, my preference would be to record it, just because it's 100% accurate to go off that for any kind of summary.
Okay, in addition to going off of the summary, if you record your interviews in a case, are those also given to the district attorney?
Yes.
Would those also be given to the defense?
Yes, no.
Would anyone involved in the case then have the opportunity to hear verbatim what questions you asked and what the answers were that were given?
Correct.
Likewise, if you record your interviews, you said after you conduct an interview that you will summarize your interview in a police report, correct?
Yes. Typically in a police report or as part of the case, yes.
In this case specifically, did you speak to Mr. Ephron the day that you were assigned to this case?
Yes, on the November 9th, 2021, yes.
And did you record your interview with him in any way?
Yes, that was recorded, but it included myself, Detective Flores, and Detective Matthew.
Understood. But when you say it was recorded, was it an audio recording?
That was an audio recording because it was a telephonic interview.
And did the audio recording capture your voice and his voice?
It did.
Okay. When you later went back and, or not you, or when your partner, I believe you said, went back and summarized that interview, summarized it into a report, correct?
Correct.
And I believe that you testified that there were a few sentences in the report that had some inaccuracies, correct?
That is correct.
But that was the inaccuracies in the report, not, those were not things that Mr. Ephron specifically said in the report. Were those inaccuracies in the report, or were those things that Mr. Ephron said to you in the report?
There were inaccuracies in the report. Summary.
Okay. I believe you were specifically asked about whether after the shooting, Mr. Ephron contacted an attorney before he returned to the scene to recover the gun casings located at Selma and Vista Del Mar. Do you recall that?
Yes.
And did Mr. Ephron ever make that statement to you that he did things in that order?
That is not my recollection.
If Mr. Ephron testified that he first collected the cartridge cases and then he contacted an attorney, did he ever tell you anything directly contradictory to that?
I'm sorry, I don't understand.
Yeah. If Mr. Ephron testified that he first went to the scene and collected the cartridge cases and he contacted an attorney at some point after that, did he ever say anything to you that was different from that order?
No.
I believe you were also asked about the line in a report in which it was written that Mr. Ephron said that Hills had a knife. Do you recall that?
Yes, I do.
Did
This
Mr.
is not
Ephron ever
software.
make that statement to you?
No.
Was that just an inaccuracy in the summary of the report?
That's correct. It was an inaccuracy.
When you were also asked if you, that essentially you knew that there was that inaccuracy in the report prior to your testimony today, correct?
Correct.
And you were asked if you ever went back to correct that police report, correct?
Correct.
Did you testify under oath at a prior hearing in November 2023 at the preliminary hearing to that inaccuracy?
Yes, I did.
So did you tell the court, the DA, and the defense that that line in your report that Hills had a knife was not correct?
That's correct.
Has Mr. Ephron ever identified anybody else other than Mr. Phillips, who we've been calling ASAP 12B, as the person with the knife outside of the parking lot?
No.
On cross-examination, a little bit on Tuesday and into today, well, I believe mostly on Tuesday, you were asked about whether you reviewed individual videos, and based upon those individual videos, you could tell certain characteristics about the gun. Do you recall that?
Yes.
When you review evidence to determine something like whether a gun is operable, if you have multiple videos, do you view those videos individually to make that determination, or do you view them collectively to make that determination?
Collectively, obviously, look at them individually, look at them as a whole, and obviously try to put them in sequence with events collectively.
Okay. And I believe you said when you reviewed the video from the parking structure, that individual video, you couldn't say it was an operable gun, correct?
Correct.
But when you review the video collectively, is it your belief that the gun that we see in the defendant's hand was operable?
Objections made.
It is.
When you viewed the videos collectively, what was your opinion regarding whether the gun was operational?
That it was an operational firearm.
How did you come to that determination?
I mean, in the totality of the circumstances of the first view of the weapon, followed by the second view, the reaction to the incident as the four individuals in the distance in the camera are scrambling, as you can see that something's going on, in conjunction with the sounds of the shots heard from the other camera, and then the fluidity of everybody running through the cameras over to El Centro. That along the lines with the information provided by Mr. Ephron, that was my opinion that it was an operable firearm and shots had been fired.
Okay. When you reviewed the sequenced surveillance video, were you reviewing whether or not they were sequenced? What were you using to determine whether they were sequenced accurately?
The totality is just the movements of the individuals in the cameras. Again, along with pieces of lights, but a lot of it has to do just with the sequence of events, walking around from one side to the next, and just kind of following the individuals in the video, and obviously in conjunction with the sound. So it sounds more difficult than it is, but it's just kind of collectively putting it all together and watching it.
Okay, from what you were just describing, it sounded like you were using audio and visual cues in the videos, correct?
Yes.
Did you specifically use the timestamps in order to determine if they were sequenced correctly?
No, not exactly. Obviously, I understand from collecting a lot of videos, in a lot of cases, that individual surveillance cameras systems are all different, and they all can be off by seconds, hours, depending on how they're maintained and kept and updated. So again, a lot of it has to do with just kind of finding certain markers within whatever crime, whatever we're looking for at the time, to try to kind of establish what happened when you're dealing with more than one camera that captures different points of view from different areas.
Okay, when you collect a video in your cases and you're checking the timestamps for accuracy, are you checking it down to the fraction of a second?
I mean, it's captured, and we take that into account. We try to determine how far off it may have been. Again, the other factors include that we can't control the maintenance of it, how it's been updated, when it's been serviced.
But to the fraction of a second, that's what you're checking, or are you checking minutes, hours, things like that?
Generally checking minutes, hours, and events captured that coincide with other markers that we do have, whether it's from another camera or a witness or something else that kind of puts us in that right time frame that we're looking for.
As to the videos from the residents on Del Mar, the one that had the audio, council kept using the word rewind. Were those physical tapes that you or your partners collected, or was that digital video?
The camera from 6200 residential is all digital.
Were any of the surveillance cameras in this case captured on manual analog tape, or were they all digital recording?
Now they've all been computer digital.
Okay. At the beginning of his questions of you, Mr. Tacopina asked you about whether or not you had spoken to 12E. Do you recall that?
Yes.
Do you know for a fact that 12E, to this day, still refuses to be interviewed by law enforcement?
Objection, that assumes a fact, not supposed to be there.
No, no speaking objections. It's the objection sustained. Ask another question.
To this day, have you been able to interview 12?
No.
Have you ever been
Nodded
present
yes and
when
said no.
12 was asked if he would agree to an interview?
Yes.
And what was his answer when asked if he would agree to an interview by law enforcement?
No.
It's gonna be great. 12E didn't want to speak once he was finally asked.
Similarly, you were asked about whether or not you'd talked to Mr. Levin. Did you have any indication that before January 20th of 2025, the day before jury selection, that Mr. Levin had any role in this case?
No, not any direct role, no.
Once you were made aware of that he could possibly have anything to say, did you take any efforts to try to interview him or talk to him?
Yes.
Were you successful in those efforts?
No.
Have you been present when Mr. Levin was also present and asked if he would specifically agree to be interviewed by law enforcement?
Yes.
And what was his answer to that question?
No.
As to both 12E and Mr. Levin, did those questions as to whether or not they would agree to an interview with law enforcement, did those occur in this courtroom?
Yes.
Did you or your partners attempt to speak to Mr. Mayor to defend?
Yes.
And were you or your partner successful in that effort?
No.
All right, Your Honor, I don't have anything.
Tacopina?
Yes, just briefly. Detective, we're almost done. You asked a bunch of questions by Mr. Sloman just now about a host of inaccuracies on fairly significant issues in
Your Honor,
your reports.
the question is argumentative in itself. It's statement of access, not an evidence.
Okay. Agreed.
Just a minute, just a minute.
Mark?
I don't believe that the question is argumentative.
Oh,
It
okay.
assumes facts, not an evidence as well, Your Honor. And the question you read back,
Read the question back.
Detective, we're almost done. You were asked a bunch of questions by Mr. Preslovic just now about a host of inaccuracies on fairly significant issues in your reports.
look vague.
Okay. You asked questions about, let's generalize it first, inaccuracies in police reports, right?
Correct.
Okay. One of those, for example, were who had the knife, right?
Yes.
That's a significant issue, isn't it?
Yes, in the report, yes.
One was whether Mr. Ephron was instructed by his attorney to go back to the scene and pick up the shell casings or not. That's a significant issue, isn't it?
Correct.
Okay. And those two issues in the reports were inaccurate, correct, according to you?
Yes.
And those could have been corrected at some point, right?
Yes, they could.
They never were they?
I mean, as far as generating a new report, other than what's been explained in court, no.
Right. So the reports today are still inaccurate on those issues.
Correct.
You were asked about one other thing. Let's start with this. 12. You were asked if you would agree to interview, if 12 would agree to be interviewed by you, and you said, he said,
Andrea.
no, he wouldn't. Are you referring to, correct, sir?
Yes.
Okay. Are you referring to 2 weeks ago in court here?
Yes.
Is that the first time you tried to interview him?
Yes.
So, in January of 2025 is the first time you tried to interview 12B about an incident that occurred in November 6th of 2021, correct?
Correct. Me personally, yes.
How about anyone else from the police department?
Yes. No, that would
No.
be the first one, correct.
Now, you would then ask questions about whether the firearm was operational. Remember those questions just now?
Yes, sir.
You testified already on cross-examination that the video from the garage, you can't indicate if that's an operational firearm or not, correct?
Correct.
You testified on Tuesday that the video from 1616 Vista Del Mar, that from that video you said, that video alone, there's no evidence of a shooting, correct?
That video alone, no.
Correct. But then you said the totality of the circumstances lead you to believe that the firearm was operational, remember, just now?
Yes, sir.
Okay. And the totality of the circumstances relative to testimony.
The physical evidence, the video, collectively, yes.
Well, the video, you just said both videos don't add to the fact that it's operational or not.
Collectively, as a whole, not the two that you decided, the entirety, all the videos involved, yes.
Well, which video shows you the firearm was operational? Which video?
Sir, as you put them together with the sound, with the sequence of events, along with the physical evidence and the statement from Mr. Ephron, that is just my opinion, that it is operational, and that's why I believe it.
Well, take out Mr. Ephron for 1 second, because he's the one who recovered shell casings, right?
Yes,
And he's the one who gives you the narrative on that video that you can't tell what happened, the 1616.
correct. I mean, he provides narrative of the sequence of events, the initial encounter, the gun that was displayed to him, what he believed to be a gun.
All right.
Whether it's operational or not at that point, I can't tell you. But the sequence of event as they evolved to Selma and Biscomore, the cameras there, the incident that took place as far as what I can describe as a scramble during some, obviously, the events that occurred there, what Mr. Ephron described as being shot at was consistent in conjunction with the audio from the cameras. Again, this is just what I'm looking at, what I'm trying to rationalize and give my opinion as to why I believe it is the gun that was fired.
I'm sorry, you're done?
Yes, sir.
Take Mr. Mr. Ephron out of the equation for a second.
Okay.
Take him out of the equation. You don't have Mr. Ephron. And therefore, his shell cases that he remembers, which we talked about the issues with that on Tuesday. Without Mr. Ephron and his narrative or version of events, with those two videos that you said independently, you do not tell it's an operable firearm, and the second video you said you can't see there is a firearm.
It's an improper hypothetical which relies on evidence.
Yeah, the answer would be ignores evidence. Objections sustained.
You want to use that to respond?
No,
Okay, okay.
taking something out of the equation then makes the hypothetical irrelevant. So ask another question.
Is your conclusion based on the fact that Relly's narrative is truthful?
It is consistent up to the point of what he describes occurred, based on what I've been able to see in connection with the physical evidence that has been provided.
So let me break it down this way. Video 1 alone, you don't know if the gun is operable.
Correct.
Video 2, that's 16 feet still more, or so what? You don't even know if there's a gun based on the video.
Specifically, just looking at that, not looking at anything else, no.
You then hear sounds that appear to be a gunshot, right?
Correct.
Aside from the gun, what else could make those sounds? An operable gun, I should say.
The sound that I heard off that camera, a firearm, some kind of replica firearm potentially, but distinct sound of the firearm. Then again, my belief it was a firearm.
Right. Thank you.
Mr. Solomon, anything?
Would you agree that you don't need Mr. Ephron's truthful testimony in order to determine that a shooting occurred at that location?
Now, the question was
It's
asked.
a different question. He's asking a different question.
Can I get a question in your mind, please?
Yeah, go.
Recross.
Would you agree you don't need Mr. Ephron's truthful testimony in order to determine that a shooting occurred at that location?
So taking him out of the equation. That's number one. Number two, it's leading. The leading is from me.
Yeah, the court's ruling, we're getting more speaking objections.
Stating my words.
Those are not moving around, other speech.
Read the question again.
Would you agree you don't need Mr. Ephron's truthful testimony in order to determine that a shooting occurred at that location?
It would be a proper question if the question ended with occurred. But when you say at that location, then I believe that calls for speculation.
Would you agree you don't need Mr. Ephron's truthful testimony to establish a shooting occurred?
Yes.
I don't have any answer.
I do now. So without Mr. Ephron's truthful testimony, what leads you to believe a shooting without Mr. Ephron's truthful testimony? So I guess he's now out of the equation. What would lead you to believe a shooting occurred?
Again, just looking at the video, the first incident where guns displayed, he obviously follows through with a scramble, I think that's described.
That's not.
Is it?
He needs to answer questions, ask a question.
You asked a question, let's finish.
Okay, so.
So again, it just comes down to, sir, is looking at everything in combination, even without Mr. Ephron's statement, if I were an investigating officer just responding to investigate a shooting scene where maybe there was some evidence found, and establishing what had occurred without a potential witness would be to obviously look at the same video, listen to the same sound of gunfire. Again, it's just factors that would be known at the time. But it would still lead me to believe that there had been some actual shooting short of a recording witness being present. I would still believe that.
Okay. So you first cited the fact that the gun was displayed. That was the first thing you just cited, right?
Correct.
Which you already told the jury. The gun that was displayed, the only time you could see a gun in any video was the part you brought your gun.
Correct.
You already told the jury, by that video, you can't tell if it's operable, right?
Correct, because it was not fired at that point.
Well, you also said the sound could also have been made by a non-operable firearm. You just said that before.
Again, it's in the realm of possibilities.
Okay.
From what I've heard, again, based on the sound, again, this is just my opinion, my expertise, and my experience. I believe it to be a firearm.
You also heard, you would hear when the police officer's body cam from the scene was played, right?
Yes, sir.
And you heard the police officer say there's no evidence of a shooting here. You heard that, right?
Yes, sir.
Okay.
Now we heard.
All right, thank you, Detective Flores.
That's the end of
Step down, next witness.
Detective Flores' testimony.
This is Mr. Biraimah.
The last witness?
It is.
All right, this must be the ballistics guy we're getting, because they haven't gotten that in yet. This ballistics report. And I'd imagine it'd be pretty quick because they analyzed 2 casings.
No, sorry. No, 15 minutes left. Let's use it.
The judge said, make it quick, let's do it.
Trying to make a lunch line out there.
Just raise your right hand for us, please. Thank you. You solemnly state that the testimony you may give in the cause not that before this court should be the truth, the whole truth, and nothing but the truth so help God.
I did.
Would you please take a seat and witness stand there?
Thank you.
Please state and spell your name for the record.
My name is Fadil, Biraimah. First name Fadil. Last name Biraimah.
Thank you.
Sir, will you tell the jury who you work for?
Yes, for the Los Angeles Police Department Forensic Science Division.
And how long have you worked for LAPD?
Just shy of 20 years.
Are you a police officer?
No.
Where do you work within LAPD?
So I'm a civilian employee. I'm a criminalist employed at the Forensic Science Division, essentially the crime lab.
Is the laboratory that you work in a accredited lab?
It is.
And what's your job title at the laboratory?
I'm a criminalist 3.
How long specifically have you been a criminalist for?
For 19 years, almost 20.
The entire time that you worked?
Yes.
What unit are you currently assigned within the lab?
Within the lab, I've actually just recently been assigned to the toxicology unit. It's a very recent assignment. I've been in firearms for about the 20 years prior to that.
Okay. You say very recent. When was that transfer made?
January 13th.
Of this year?
Yes.
Okay. Your entire time before that, you said you worked in the firearm analysis unit?
Correct.
Okay. Can you give the jury just a broad idea of what your job duties entail when you worked in the firearm analysis unit?
So a criminalist in the firearms unit, we are primarily trained to perform work within the laboratory. That's where we spend most of our time. We perform the analysis of firearms and firearm-related evidence. This is the type of analysis that's commonly referred to as ballistic comparison. We call it firearm identification. In addition to this, we respond to the field in order to process crime scenes, particularly shooting scenes and officer-involved shootings are our main field obligations. We generate reports regarding these analyses and testify about them in court.
When you're specifically analyzing firearms and firearm-related components, can you give the jury an idea of what some of those items are that you're looking at?
Yes, so we are trained in the operation and structure of a wide range of different firearms. A firearm for us is a device that propels a projectile by means of combustion. So this wouldn't really include airsoft guns, things of that nature. But firearms, which actually fire live cartridges or ammunition, during the discharge process, they will actually cause marks to be impressed onto those ammunition components. So this is a large part of our responsibilities, is to perform the microscopic comparison of fired ammunition components. These can be bullets or cartridge cases, with the aim of determining what types of firearms they might be compatible with, or actually continuing to determine whether two items have been fired in the same firearm or were eliminated as having been fired in the same firearm.
Can you tell the jury about your educational background, any training or experience that you have that qualifies you to perform those functions that you just described in the lab, of comparing firearms and firearm-related components?
Yes, well, entry-level criminalists have a natural chemistry, natural science background. I have a degree in biochemistry. This prepares you for most of the work in the crime lab, but to perform the analyses in the firearm analysis unit, we complete another lengthy training program. This is the firearm examiner training program. It has a duration of about 2.5 years. It includes lecture, literature review, and live fire exercises. By these means, we learn about the structure and function of ammunition. We learn to operate a wide range of different firearms. And we actually spend about an 18-month period training on microscopes in order to perform the comparison of discharged fired components. I completed that training program in 2009. I spent the following decade as a full-time firearm examiner. Each year of that period, I was tested by an outside firm in order to maintain my qualification. I am also certified by the Association of Firearm and Tool Mark Examiners. This is the premier professional organization in my field, certified in the area of firearm examination and identification. In the course of my work there, I've performed the examination of more than 3,600 items of evidence, logged more than 600 hours in the processing of crime scenes, and about 6 years ago I advanced to the position of Criminals 3. So in addition to the duties I've described, I also do training of other firearm examiners. I work on special projects and research for the firearm analysis unit.
Do you continue to attend professional organization meetings to maintain your proficiency in firearm analysis?
Yes, during that period, under our accreditation requirements, it's encouraged for us to have continuing education. So I've completed, I believe, about 575 hours of additional coursework outside of the actual department. This includes workshops and training from some of the leading professionals in my
Super hard backspace.
as well as certain agencies such as the California Criminalistics Institute, which is operated by the California Department of Justice.
You mentioned that you were tested by an outside vendor, outside of LAD, right?
Yes.
Are those commonly called proficiency tests?
Yes.
And are they required to maintain your accreditation?
Yes, the lab is accredited, and requirements for that, you must participate in proficiency testing by approved vendors outside of our actual agency.
And are those tests graded? Those proficiency tests?
Yes, they're evaluated.
And have you successfully completed them?
Yes.
Approximately how many times do you think you've testified in court about firearm and tool mark identification?
I'd say over 60 times. I testified around 75 times in total. That includes testifying about field work as well.
Okay. In a general sense, what was the, let's start with, you were assigned as a criminalist in this case, correct?
Yes.
And what was the task that you were assigned to complete specifically related to this case?
I was tasked with the analysis of 2 ammunition components. These are cartridge cases, discharged cartridge cases, or a type of examination that we call type and caliber determination.
Your Honor, I'm going to move into a different area. Do you want me to start that? Or?
Well, it's close enough. We'll break that.
Sure.
They're going to take a break.
We put it on time for a second before you go through what come back.
Okay.
I don't know what Joe was asking for there. Let me make sure I spell it's Biraimah. Okay, so this guy, I don't know why he's saying that we're going to switch topics. Maybe he just means we're going to get into the actual examination of these 2 shell casings. But essentially what this guy is here to tell us is that these 2 shell casings, the type of weapon that could have fired them, one type of weapon that could have fired them is a Glock 43. So, and they want that because they found this Glock 43 magazine in Rocky's home when they searched his home 6 months later in April of 2022. What's interesting is you kind of heard some like pissed off attitude. Did anybody catch that when Mr. P was finishing up his Recross, or maybe it was just redirect with Detective Flores? You know, you asked when were you finally able to ask Lewin, Leavin, if you could sit down and interview him? Leavin is the manager who there was a firearm in Rocky's home. There were 3 firearms, and at least one of those firearms was actually registered legally. All 3 were legal, and one of them at least was registered to Leavin, right? And then this magazine that was in the home, Leavin is also going to testify that that magazine is his. And it had different types, a different brand, different manufacturer for the ammunition that was loaded into that magazine. But that magazine looks like it belongs to a Glock 43. So the prosecution's got to say, look, these shell casings could have been fired by a Glock 43, and there was a magazine that a Glock 43 could use. 6 months apart. So that's their circumstantial evidence there.
No electronic media. You got to please continue to keep an open mind about this case. We'll see you at 1:35.
Oh, they're taking lunch. I wonder if they're going to argue something, or just... So because it's currently noon in court in Pacific time, and they said see you at 1:45, so it sounds like they're going on their lunch break now and scrunching that break into the lunch break. So we'll keep this up to see if they jump back in over the next minute or 2.
Is it
Attorney arguments?
Biraimah or Biraimah? B or D? First letter of your last name?
B as in boy.
B as in boy. All right, jurors have left. What do you want to bring up?
Your Honor, there was a question we asked the detective on the stand, and the question involved video hearings and my co-counsel. The question involved whether or not there was video that was available that would have shown the given the time that was involved.
Right.
And the court indicated that they showed up after the video stopped.
Right.
Mr. Siegel said, the court sustained objection, but I believe I heard Mr. Siegel say, that doesn't mean they didn't have the video. Now, if, listen,
Right?
yeah,
That's not what I said.
okay, so I just asked, again, because of my short hearing, I'm not the best reporter of this, but I just want to ask, if the court reporter can check if that line is in there, because if the jury heard that, if I heard it right, and if the jury heard it, that's
Repeat
wrong.
what you think you heard.
I thought I heard him say, in reference, that doesn't mean they didn't have the video. Meaning, in essence, that we would have had a video.
Hold on, I'm writing that. That doesn't mean they
Didn't have the video. So, and again, maybe I heard it wrong because I don't hear right, but I mentioned it as soon as I heard it. I objected. I couldn't make a speaking objection, so we had to bring it up after the jury was gone. So I would just ask the
Right, so I can understand. The question was, would something, if the video stopped at 11:20, would something that occurred at 11:45 appear on the video that stopped 25 minutes early?
It was during one of those couple of questions involving Mr. Clement. He asked about the victim. He also asked about his girlfriend. I believe it was the question about the girlfriend in the video. And
All right, can you look for that? Do you, was that the question? That wasn't the objection. So, can you just look for those words?
Thank you.
All right, see everybody at 1:45. And Mr. Brisbane said, Mr. Biraimah said, we're right here. Period. Yeah, thank you.
Good, good. Your Honor.
Right, so let's talk about that. So Lewin waited until we already have another witness on the stand going through his CV letter, his history, his experience, and then waits for a break because I can't make a speaking objection. You could have asked to approach. It seems like you're trying to think of something late that you didn't think of in the moment to raise an issue with something that could look really bad for your case. Lewin's argument is that the defense's questioning made an implication that you could have had video, and Lewin's probably going to argue that that's improper for them to have said that. But the problem is, think about the timeline here. We have this incident happen on November 6, 2021. It's the role of the state, and the state includes the DA's office and the police department. It's their role to do the investigative work, to look at 911 calls, to look for witnesses, to look for surveillance. The defense can do those things too, but these are things that the police should be doing and they should be turning over to the DA. You have this incident happen on November 6th. Relly goes to the police station on November 8th. He comes back on November 9th to stay with the detectives for the interview. No later than November 9th. The November 9th is the absolute latest. November 8th, he says to the guy at the desk that we heard on the stand before Detective Flores, Anderson, Relly tells him he grabbed these 2 casings and brings them to the LAPD. November 9th, you have him interviewing again. By that point in time, the detectives have heard the story of how Relly went back to the scene, got the shell casings, and what have you. So they're looking at this video. There's either 2 options here, and none of them are really great for the state. The first option is they were satisfied with this video of the man, whoever it was, in the white t-shirt around the scene, at 11:06 or 11:09, within an hour after the incident. They were satisfied with that. Relly said at some point, more than once, that that was him. Police officer, Detective Flores, they thought that that was him too. Maybe now today they don't, but at some point they did. The other option is you already knew that there was supposed to be a timeline. So if at that point in time it didn't make sense that that video was Relly in a white shirt going back to the scene, as he said, with his girlfriend and picking up these shell casings, you had all of the opportunity in the world to go and capture more surveillance footage, longer clips of it, subpoena more, ask for footage from another angle. But they only went and got footage from X timestamp to X timestamp. Just because it was November 9th doesn't mean they couldn't have gone back and gotten additional footage. But yet they chose not to. So again, 2 options. They were either satisfied that white tee was Relly, or they weren't, but they failed to go and do more investigative work that they could have done. So if you ask me, it's not improper for the jury to be considering, why didn't they look for longer to see if we could get some footage of RiRi doing the thing he said? Because RiRi told all of this to the officers in November of 2021. So that's what's going on there, and Lewin is having a delayed fit about it, but we'll see what the judge does. Yeah, still stuck on the last witness there. So, yeah, Miranda, this is exactly it. Miranda, this is so... W's in the chat for Miranda. Miranda says it much better than me. If the time-stamped photo of the casings, the one that RiRi took, he says he went back to the scene, he takes these 4 photos of the 2 casings at the scene, according to him. If the metadata, if the timestamps on these photos say 11:45 p.m., why are you not getting footage from 11:45 p.m.? So... yeah, so big W's in the chat here for Miranda. Miranda is on it, like, just crazy. So the defense has every right to suggest, the police could have done something, but they didn't do it. They didn't do it. And what's even crazier about that is, I forget the specific, was it requesting DNA? Was it requesting like a DNA sample or to test for something on their own? Because we found out that the state they got the subpoena for DNA, but never tested Rocky's DNA, and maybe they were suggesting that the defense could have done DNA testing on the shell casings. Whatever the conversation was on Redirect with Detective Flores, Mr. P just got into this whole thing of like, well, the defense could have asked to do that if they wanted to, couldn't they have? You just made the same implication in front of the jury that Lewin is now raising a fit about a witness later. So, yeah, Detective RiRi, you guys. Oh my goodness. W's in the chat here. Yeah, this chat, you guys as a chat, I think in 5 minutes could have pushed an investigation like this in a much better and more productive direction. Shout out, I see Tat Cloud saying, what up, Taylor Gang? So I'm assuming we have a raid here. Shout out to Taylor Gang, Taylor Umbridge in the chat. Make sure you guys go check out Taylor. Taylor streams a lot more cases than I do. His great commentary, super sharp. Make sure you get over there. Yeah, Chad Diggy too with the Taylor Umbridge raid with the alert symbols. Thank you so much. StreamYard doesn't tell me someone's raided, so I rely on you guys. Also, speaking of other creators, I see Amy E in the building. And I learned very recently why I couldn't pull up Amy's channel. Her actual YouTube handle is Love Amy E. So you guys make sure you are hopping over there. I'm going to drop, let's see. We've got Amy E first. Let me get Taylor's link. And I think we're going to look at this story of the Robert Durst trial and John Lewin going on vacation at his widow's house. I think we'll look at that during lunch. But you could also go check out stuff from Taylor and Amy E during the lunch and come back and hang out. And there is Taylor's link in the chat. But yeah, just a lot of mess. I didn't really expect that much more to come out of Detective Flores. I knew we were going to get into trying to line up different videos from different cameras with this audio and any possible discrepancies there. I didn't really think we'd see so much attorney squabbling already. Oh my goodness. So this is the last witness that the state is calling. We pretty much know what he's going to be able to tell us. The casings could have been fired by a Glock 43. And then this is it. They're going to rest their case. And I'm not saying that a defense witness couldn't say some stuff that might be bad for the defense, right? That can always happen. But I honestly think like the most damage to the case has already been done by their star witness. I don't know. And there are people that disagree. There are people that think that RiRi, is very helpful to the state, very damning for the defense because he's able to keep certain details consistent. I don't personally believe that because, I've been in situations where people repeat a couple details and they memorize instead of, it's not from memory, it's memorization. And memorization doesn't mean, truthful recollection. It's just what you've flashcard studied for your test and are able to spit back out when you need to say it, right? So to me, I look at Relly as he did some memorization and isn't really speaking from memory, except when he says that he was upset or had hurt feelings or just couldn't help but follow behind the group of 3 friends. I think he's actually speaking from memory when he's talking about the emotions he was feeling. But other people, their perspective on this case is that he's speaking from memory and it's consistent and it is helpful to what the state is saying and that it doesn't look good for Rocky. So 2 sides there. And I know this chat is certainly, consensus is certainly, sometimes we've had some split chats, but I think with this case where this chat is pretty much a collective over on the green light side here, thinking this looks good for the defense. Let's see here. One thing that always is annoying about StreamYard, when I pull these up on the screen, it's not going to show it to you guys, but I do believe it should show some of them pinned at the top of the chat. So big thank you to Derek Croissant here, who is sending over a coffee with the word tired on the coffee cup. I feel that, when court starts back up, I've got my water here, but I'm going to get my stream caffeine as soon as we have court going again. Get me through the 3 o'clock itis here on the East Coast. So big thank you here to Derek. Thanks for showing the love. And then Lacey Ann came in over here. It's a sign that says nope. So I wish, I need a prop. I need a prop sign that just says nope and yep. And I can just toggle them depending on what's going on. Oh my goodness. So love that. Thank you so much for the sticker here, Lacey. Let's see. If you guys have been listening, I believe, it's my guess here, Peter Ortiz, we were coming up with acronyms as a joke in honor of FFS, and Peter Ortiz said Fat Frog Society as a suggestion for FFS, and we've got a tree frog in his profile picture now, so love the update. I think this is an FFS reference. And then boom, 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 time for motions for dismissal or directed verdict. Now, what's going to be fun about that, these motions for directed verdict, if the defense chooses to argue them, essentially once a state rests their case in chief, since they have the burden of proof to not just prove what they say happened, but specifically they need to make the case and present evidence for each of the elements for the charges that they're charging the defendant for. Here, Rocky's being charged with 2 counts of the same charge under 245B, assault with a semi-automatic firearm. Specifically, a firearm, it's inherently deadly, right? Big difference if there's a fact question of whether or not this is actually a firearm or it's a starter pistol, which is classified in California as a less than lethal weapon. So different elements, different statute if you're trying to charge with this object specifically. So it'll be really interesting to see if, I feel like most cases I watch, the defense will motion for a directed verdict without really much expectation that it'll be granted, but it's almost like a formality. They make the argument anyway, and the prosecution will, orally argue back and say this is why you shouldn't grant the directed verdict. And I do hope we're able to watch that. I don't expect that it'll take all that long, probably 30 minutes each side. But they do contain some interesting arguments. So we'll have to see how they summarize it. It'll be a bit like a miniature closing argument, just not including anything that the defense is waiting to introduce at this point in time. But anyway, Peter says, time for motions for dismissal or directed verdict. I mean, do you guys think that type of granting, do you think that that's a possibility at all? I think it's so uncommon to see directed verdicts. I thought it was great, but surprising we got that directed verdict in the YSL trial. It was shocking breaking news to hear. On one hand, it was shocking news we got directed verdicts in the Jackie Johnson trial, but I think the non-surprise was that the issue of contention for the 1 count was a flawed indictment and Brian Steele made the argument. So in my head, you can't bring a flawed indictment around Brian Steele. He's going to make an argument for it every single time that he can. So, let's see. Who's saying Peter's gotta chill? Oh my goodness. Touche also says Judge Sua Sponte has calmed down a bit, thank God. Yeah, until that little, like, redirect and recross moment there, like, everybody was talking over each other. Even though, I don't know, that was, like, less than 10 questions total. There were, like, 3 miniature squabbles in it, so... but the judge is like, forget it, we're just gonna go to lunch now. So, it lasted for the morning, Touche. It lasted. Chloe Aperture Ben says, hey, if anyone is unemployed, now's the time to move to California and start your own ambulance company. But the thing is, he didn't go to get treatment until he was back in New York. So maybe, coast to coast, whatever coast you choose to land down on, start the ambulance company. We could franchise it, get it going. I do love that, and I always think of the SpongeBob episode with, like, the Weenie Hut Jr. and, like, the slipping on the ice cube. SpongeBob. Makes me feel old, because that show's more than 20 years old at this point. Thank you, Chloe. Lacey Ann is out here sniping away with the gifted memberships. Let's get Lacey up in this banner. And apologies, by the way. I kind of, like, I try to follow the name capitalization that people choose, but then when I do banners, sometimes I just butcher it. A big thank you here to Lacey Ann. Lacey Ann has also great commentary and some comedy in the chat today, so glad that you're here with us. Thanks for supporting the channel. Chloe says, hit the like and receive a limited edition Relly CSI kit. It was just like a National Geographic, like, DNA identification kit. Includes 2 9mm shell casings, 3 extra small size band-aids, a Dunkin' Donuts bag, and magnifying glass. Oh my goodness, free shipping for the next 180 seconds. You better be quick, you better be quick. We need a white tee. We need a white tee and a plastic bag also, because we don't know what bag we actually used here for this nice shell casing collection. And then Classy Beats, holy moly, dropping 10 gifted memberships in the chat. I'm behind on it, so you guys are already, I'm seeing Classies flood through the chat. So big thank you here. Let's see, lots of love. There we go. You guys are always on it. Appreciate you so much, chat. Classy B. Classy with the Y. We're using the adjective. I like it. You guys already know the drill, and with Classy, it's one of those things I feel like I'm telling people to subscribe, and they're like, we're already subscribed, we can't subscribe any harder. But just in case you're not, there you go. Link to Classy Beats is in the chat. I know the mods have been dropping it as well, so big thanks to them. Make sure you go check Classy Beats out. Really does a show every single morning. Always something new to follow. And really good, like, in the middle of his show, if news breaks, he'll, like, pull it up and start reading and talking about it. So I think you guys will be into that. Make sure you go check that out. T. Will here says, how do you get a membership? All right, so the easy way if you're not using an Apple device is if you click the little icon next to where you type in the chat, you can, it's like a gift or money, I think it's a money symbol. It'll say gift settings, and you click that and you can toggle on a setting to allow gifted memberships. You'll never be charged unless you choose to manually continue subscribing as a gift, as a member to a channel. It'll expire on its own after the 30-day gift membership window. But you do have to turn it on to be able to receive gifts. And once you set it once, it works for any channel. There is a link. There is a link that Chad Diggy just dropped. I think, yeah. So thank you, Chad Diggy. Sometimes with Apple devices, you have to, like, go to the community or membership tab on somebody's channel and then, like, toggle on the option to allow gifts. So it's a little bit goofy. It's a little goofy. Yeah, this is exactly how I feel, allegedly, maybe. Be surprised if anyone here isn't already subscribed to Classy. But you never know, you never know. Nick Starro, big Nick Starro, says, if that toolmark analyst even breathes the possibility of the spent casings from Relly can be matched to the unspent cartridges in the manager's magazine, then this scam science needs an intervention. I hope they don't even try to go there. I think they're letting it remain circumstantial. They're not, I think it'd be so wildly improper for them to suggest a match, because it's different make of ammunition, different shell casing found at the scene. And what they're going for is just the jury connecting the dot that there was a magazine in Rocky's home in April that was capable of firing 9mm and working in a Glock 43 type firearm, model firearm. And the shell casings could have also been fired. Not that that's the only make and model that could have expelled these shell casings, but it's a possible make and model that could have expelled it. And the prosecution expects that the leap can be made, that the jury will say, you know what, just because it could have been, it must have been. I really think that that's what the prosecution's going to expect here. I really don't think they have any closer connection than that. Also, holy moly, all of a sudden I'm seeing a flood of Peter, all the Peters and the Booms in the chat. And I look up, and then look at this. This is super generous. Peter just dropped 50 gifted memberships, so if you are not at your screen, you might want to check, because Peter probably just helped you join the collective. That's what we're calling it for this trial. Your name will be green. You've got 30 days thanks to Peter. Make sure you're saying thank you to Peter. And it looks like it's still moving in the chat. It's still trying to find people to give the memberships to. Like, it's just flooding super fast. So, Peter, from the bottom of my heart, thank you for always supporting this channel. And look how much excitement you bring the chat. Jazzy teases Peter doing it big. Yeah, and Designbox Media, make sure you turn on that gift setting, because you've been in here a lot. So, from my experience, it always seems like YouTube tries to figure out who's subscribed, who's been in the chat, and like try to gift to people that have been here recently first. So make sure you have that setting turned on, because I know you hang out with us a lot. Get in that algorithm to get a free gifted membership. Thanks to Peter Ortiz. Let me update this banner, get Classy and Peter in here. And with these 50 gifts, we've got a joke that it's catering, so I don't know what we're having for lunch, but Peter gets to decide. He's catering for the whole chat. And I think, I don't know, Peter, is this a nudge to get into the tea? Might be a nudge to get into the tea here. Let's see. Oh, this kind of has a lot of videos, and I'm not going to know which one's an ad. All right, this one looks relevant. So let's rewind it and...
Yet another sensational twist in the ongoing saga involving the late...
All right, so is this John Lewin in the back? That's not John Lewin, is it? I mean, he just kind of has the same head shape, but he looks way younger. So
serial
let's see.
killer Robert Durst. The Turn to Terror team uncovers evidence that the star prosecutor who convicted the New York real estate heir took a free vacation at a Long Island mansion owned by Durst's wife just months after the trial. It's a trip that is now coming under the microscope. Our senior reporter Tara Rosenblum has the exclusive details.
Back in 2021, Los Angeles Deputy District Attorney John Lewin did...
Oh, I didn't mean to skip. But 2021, this is John Lewin in 2021.
Back in 2021, Los Angeles Deputy District Attorney John Lewin did what no other prosecutor in New York or Texas could.
Guilty of a crime.
Convince a jury to unanimously find the scandalized New York real estate scion Robert Durst guilty of murder. The high-profile conviction instantly turned Lewin into a household name.
I was the lead prosecutor on the case.
There were TV show cameos, podcasts, and even luxury stays in the Hamptons. The Turn to Terror team has learned that just a few months after Durst was found guilty and subsequently died in prison, Lewin had a sleepover at this beachfront mansion estimated at $17 million, owned by none other than Robert Durst's widow, Deborah Sheridan.
Has John Lewin ever been to your house in Bridgehampton?
Yes. In this videotaped deposition obtained exclusively by News 12, Sheridan was questioned last fall about the nature of Lewin's stay at her pricey Long Island estate.
Did he sleep over?
He did.
Was anyone else there?
No.
Were you there?
Yes.
A few
what?
months later,
Hold
under
on.
oath for
How do you say no and then say yes, I was there? Look at this lady. Let's go back to where she first says he went to the house, and she does this like head turn. Depositions are so messy.
Has John Lewin ever been to your house in Bridgehampton?
Yes.
In this videotaped deposition obtained exclusively by News 12, Sheridan was questioned last fall about the nature of Lewin's stay at her pricey Long Island estate.
Did he sleep over?
He did.
Was anyone else there?
No.
Were you there?
Yes.
A few months later, under oath for a wrongful death suit brought by Durst's first wife, Lewin is also asked to explain the overnight encounter.
Did I spend the night at... So my daughter and I, on a vacation to New York City, made arrangements. Bob Durst was long dead.
Why would you add that? I wish we could see it because it looks like it was spliced, so I don't know if those are two separate questions. But the widow didn't say that there was someone else there, the daughter. She said nobody else was there, and then were you there? Yes. So unless they're splicing this weird, it seems like the widow was saying it was just him and her, the two of them. And then Lewin is like, yeah, it was me and my daughter on a vacation, and it was long after the guy was dead.
Only Durst wasn't long dead. He died in January 2022, just a few months before Lewin vacationed at his widow's mansion.
My daughter and I had a lovely, I think we spent not one night, if I recall, I think it was two nights there. I can't remember for sure. It's nothing that is in any way unethical.
But not everyone agrees.
In my mind, this does not pass the smell test. It just strikes me as so foolish.
Peace law professor and former Manhattan prosecutor Bennett Gershman said Lewin's Hamptons excursion has the potential to not only complicate the legal battle over Durst's estate, but also Lewin's own standing at the DA's office.
You know, prosecutors shouldn't be in a situation where their judgment, their conduct may be called into question. He made a terrible mistake in terms of judgment, and are there going to be any consequences?
We reached out to the Los Angeles County District Attorney's Office to find out, and all they would tell us was they were aware of the allegation, but couldn't comment further on personnel matters or pending investigations. Tara Rosenblum, News 12.
And to catch up on Tara's coverage of the Robert Durst.
Oh my. This is probably why he aged in this like 4-year time frame, like maybe 3.5, maybe 4-year time frame. Wow. I mean, maybe it was just gravy, but we have two different stories from the two people that are talking about the vacation. So, I mean, chat, you be the jury. You decide. You decide. Is it sus? And yes, this is that day that they were squabbling back and forth. Joe Tacopina said, go back to Durst's house. Oh my gosh. Yeah, and this can all be true too. Like, Durst was a scary man. You know, one of those perhaps two things can be true at once. Very, very crazy. Very crazy. Let's see. Oh, this is just a like recitation of it, I think. I think it's just broken down in words. Because it looks like the same thing we just heard. Okay, wait. She says she knew Lewin was coming with his daughter, and that there was no one else there at the time but Sheraton. So, there is a mention of the daughter in the article. Quoting what we heard. Lewin went on to say the original plan was for 2 other people to join them, but he claims the other guests couldn't make it, and the daughter, they had a lovely time. That's where we hear him say he thinks he spent one night, nothing unethical. And then the quotes from Gershman that we also heard. So, But I heard that there was, some rifts between Lewin and the DA that, I think he lost his election. But there was a rift between them, and that's why Lewin is in the division trying this case now. Rather than he was moved out of the cold cases division, and now he's doing trials like this. And he was like refusing to take pictures with the DA office team because the DA was in them and they were beefing. So yeah, I think this is that, this is the stress aging. Yeah, Violet says daughter was a smokescreen. Could be. Could be. Very messy. Very messy. Thank you for sharing this and talking about this earlier in the chat. I just thought the line from Tacopina was like, I don't know, a reference to the case in general. I knew that Lewin had done a sit-down interview with Durst, so I thought that was like a comment about that. It was like a 3-part interview series that he did one-on-one with Durst. So I thought it was like a reference to that until this is it here. Oof. Has he run for district attorney? Let's see. Wait, hold on. Let me see if this article's about John Lewin, because if it is, we might read it. Because it's saying 2 prosecutors. What is going on? This district attorney's office is messy. All right, this is paywalled. Let me get the full article because this is just a summary. Are you guys following the Menendez resentencing stuff? Or did you follow it? Okay, let's see. Prosecutors who pushed... Oh god, what is with this ad? All right, let's read it. This has to be the weirdest ad ever. There used to be like a read-only mode. Well, ignore these ads, guys. 2 Los Angeles prosecutors who supported the release of Eric and Lyle Menendez announced that they plan to sue the new district attorney for harassment, discrimination, and retaliation. So there's a ton of drama in this office. Brock Lunsford and Nancy Taberge, Taberge, both worked in the Los Angeles County District Attorney's Office under former DA George Gascon, who lost his re-election bid in November to Hochman. Lunsford oversaw resentencing cases, and along with Taberge, I don't know, the pair pushed in October 2024 for the resentencing of the 2 convicted murderers based on new evidence. When Hochman took over, he said he'd look into the case, but since he took office, Lunsford and Taberge claimed that they'd been demoted to lower positions as alleged retaliation for their position. So what happened? In a letter obtained by the LA Times, we've got this weird ad over there. The attorney representing Lunsford and Taberge, Justin Shagarian, these names are beating me up, my bad, guys, said that the 2 career attorneys were just punished, adding that they felt that the law said the Menendez brothers should be resentenced. These were 2 individuals who were just doing their job. Well, I mean, I don't know if that's a great excuse or great reasoning. Lunsford, who has been with the DA's office since 2000, was reassigned to the position of calendar deputy. Taberge was sent back to the alternate public defender's office. While the LA Times noted that it's not uncommon for a shift in the staff when a new DA takes office, is it not scrolling for you guys? My bad. I didn't share the screen right. At least you guys didn't have to see the weird ad going on. While the LA Times noted that it's not uncommon for a shift in the staff when a new DA takes office, Lunsford and Taberge claimed that their reassignments went further. The letter stated their intention to sue Hochman and Deputy District Attorney John Lewin for harassment, discrimination, and retaliation following their recommended resentencing of convicted murderers Eric and Lyle Menendez. According to the letter, Lewin allegedly posted defamatory comments about Taberge and Lunsford, allegedly saying of Taberge in a social media post, Well, this is all right. So was this like Lewin's own social media? Because where I'm going back to the ASAP Rocky trial right now, there's a gag order in place. John Lewin asked for a gag order. The judge made it apply to both parties, but John Lewin did ask for it, and that's why we're not hearing statements from them to the media. So interesting to hear John Lewin, who's not afraid of asking for a gag order against the other party, making social media posts and now being sued for it. That she had no interest in justice, wanted to let criminals out of jail, and was dishonest in her filings with the court. Lewin had also allegedly referred to Lunsford as a kiesling, a term that is generally seen as an accusation that someone is complicit with Nazis. Lewin was also outspoken about resentencing the Menendez brothers, whose case was reinvigorated by recently released TV shows and documentaries that provided an alternate narrative about their motivations in the 1989 double murder of their parents, Jose and Kitty Menendez. The veteran prosecutor also sued Gascon. He was one of 20 prosecutors who sued after Gascon was reassigned staff when he took office, and Lewin said he was demoted from his position in major crimes to the position of calendar deputy. So Lewin sued Gascon for reassigning him from major crimes to calendar deputy. And now these other two individuals are suing because they believe they were wrongfully reassigned to calendar duty. They're suing John as being part of why that happened. So like we're like just going in circles here, just weaving back and forth forever and ever. Oh boy. Let's see. The position to which Lunsford was reassigned when Hockman took office. Lunsford and Thabert said in the letter that they intend to seek more than $250,000 in economic damages and over $5 million in non-economic damages, according to KTLA. In an email to KTLA, Shagirian, the lawyer, said Nancy and Brock are committed public servants and accomplished attorneys who followed the law. The law they believed required them to advocate for the resentencing of the Menendez brothers. The harassment and retaliation that followed was politically motivated, illegal, and devastating. And they're saying that this first appeared on Law and Crime. So, I know the resentencing stuff was I saw a lot of people talking about it, but it wasn't something I was following along with. But that just seems like a lot of drama in this office across the years, through the years. So what are you guys saying? Especially if you guys followed the Menendez stuff. For Always, Forever, for Life says I follow when I see it. Honeypot says Gascon was the absolute worst. I keep wanting to say Gaston. Like, I don't know, these names are messing with me. Let's see. Allegedly, maybe says he doesn't need a gag order. I gag every time I hear his voice. Let's see. Sheriff Chuck says I hate calendar duty. Yeah, a lot of the comments are just like Lewin is irritable. He's itchy. He's itchy. He's itch. And I didn't see, so Skylar, I didn't actually see anything that he was running for district attorney. There's just this hullabaloo. Yeah, I think this is kind of it. What a mess that office has. So, are there any other interesting articles on that? A lot of the results seem like they're talking about this lawsuit, so. Oh, is this about the social posts? Oh, okay, so this is, I don't know if this is a blog. We're just gonna look at it, guys, grain of salt. But this could be the social media post in question. So, I guess Gascon didn't ask me anything. And then Deputy District Attorney John Lewin appeared on Instagram with 8 pointed questions for LA County District Attorney George Gascon. So he does an AMA and John Lewin shows up with 8 questions. Lewin raised some tough questions, especially considering that Gascon awarded Lewin Prosecutor of the Year, and then, in a dramatic turn, banished him to an obscure corner of the office. So take a tour through some of Gascon's biggest scandals, or sit back and enjoy watching LADA's cold case expert take on his own boss, a lawyer who has never tried a case. All right, so here this looks like a screenshot from John Lewin. John.Lewin.165. George, I have a number of questions which I'm sure you will refuse to answer. One, you guys can put this in his voice if you want to. I know you were trying to pretend as if you had no involvement in the Torrance police officer voluntary manslaughter case that is being handled by your hand-picked $1.5 million, quote, special prosecutor. Oh my God, we have big contracts, big money to special prosecutors coming into play. But I assume you've had the opportunity to review Judge Oda's PowerPoint and the transcript from that absolutely embarrassing hearing where he had to instruct your, quote, special prosecutor that the law he used to charge those police officers was not the law in California at the time of the offense. Please explain how you could charge somebody under a law that does not exist, ? I will ask the questions one at a time so you don't lose them. Let's keep going. What do you think? You want to keep going? We've got some time. Here, Lewin is referring to Gascon's indictment of Torrance Police Department officers Anthony Chavez and Matthew Concannon. Have you guys ever had coal cannon? It's like delicious mashed potato with like a volcano of butter, and there's like sauteed cabbage and onion all up in there too. Coal cannon, it's real good, real good. I look forward to it every St. Patrick's Day. But anyway, Matthew Concannon for the fatal shooting of Christopher Mitchell. The officer shot at Mitchell during a traffic stop after he refused to exit his vehicle and reached for a gun in his lap. The gun was an air rifle. So this is some footage from this incident. And I guess that's what they're showing was in his lap. Although LADA had already reviewed the shooting and found it justified, Gascon indicted the two officers in March of 2023. So, what are these posts from? Did they give a date on when these Instagram... Alright, this is coming in on June 24th, 2023. So sometime between March and June is when this Instagram and AMA are going on. Rumors have been swirling that the indictment was based on a law that was not in effect when the crime was committed. Both officers are charged with voluntary manslaughter. And some laws can be retroactive, but not always. So that's important. The indictment is based on the argument that the force used on Mitchell was not necessary since the gun was only an air rifle. This is so interesting because this is like, an air rifle is classified as currently, less than lethal weapon. So, or maybe even less than that. Maybe it's not even considered a less than lethal weapon. But the classification is coming into play here, and we have a classification conundrum over in the Rocky trial too with John Lewin on the other side of the prosecuting from what he's complaining about here. This theory would work under the current state of the law. Today, peace officers may use deadly force only when necessary in defense of human life. Section 835A also toughens several other standards around the use of force by police officers. For example, the standard is now objective. It no longer matters whether the officers subjectively thought that deadly force was necessary. Today, the officers will have a harder time defending themselves by saying they thought the air rifle was a real gun. However, at the time of the crime, the law was less strict. Back then, the standard was subjective. I thought the gun was real was a defense when the shooting happened. And back then, the force used by police only had to be reasonable and not necessary. Now again, these posts from John are in 2023. And we see him like fighting tooth and nail. We've got the ballistics guy getting up there on the stand right before we take this break. Tooth and nail that this had to be an operable firearm. John Lewin is on the other side of the fence for this one. This is a different case. I don't really know if this is exactly about the case or a broader beef between the previous district attorney, Gascon, in LA, and John Lewin, the deputy district attorney that is prosecuting the ASAP Rocky case. But we're looking at 2023 Instagram posts where John is asking questions when Gascon didn't ask me anything session. This ban is taught as a basic fundamental feature of American criminal... Oh wait, I missed a sentence. Okay, why is this a problem for Gascon? He's trying to use the new law to prosecute the old shooting. You can't do that. The law that applies to the shooting is the law in place at the time of the shooting, not today's laws. Trying to use today's laws to punish yesterday's crimes is an ex post facto law. These type of laws were banned by the Constitution. This ban is taught as a basic fundamental feature of American criminal law. Observers, especially prosecutors, have been shocked that Gascon made such a basic error. So this is the second question John is asking in this AMA. At the same hearing, Judge Oda discussed setting a hearing to show cause for your, quote, special prosecutor, to explain why he did not present Johnson evidence. Since I know you've never worked as a lawyer, Johnson evidence is exculpatory evidence that needs to be presented to a grand jury prior to them issuing an indictment, as is legally and ethically required. You love to talk about how ethical you are, but what have you to say for the conduct of your special prosecutor? What was your involvement in the case? What do you know about it, and when do you know about it? What actions have you taken? You know, I'm kind of getting the impression that John Lewin he can probably win something that might not be the right thing to win, and he can probably win something that might be the right thing to win because he'll just be relentless until he gets through to the finish line. Right? And like, when it lines up with the right outcome, maybe that's a good thing. But when it lines up with the wrong outcome, maybe that's not a good thing. So that could explain why we see him on all these different sides of different issues. Whatever he starts at, he's just going to keep going and going and going and going. He won't give up. Won't give up. Questions about the Mitchell shooting continue. Lewin is referring to the rumor that Gascon Special Prosecutor Lawrence Middleton failed to present exculpatory evidence to the grand jury. So, you know, sounds like a lot of, we hear that a lot, right? Grand jury doesn't get to hear everything, even the things that they're supposed to hear. Then they make the decision to indict somebody. This is required in state court, but not in federal court. Many have speculated that Middleton was not aware of the rule requiring him to present exculpatory evidence because he only practiced in federal court, where the rule does not apply. The rule requiring exculpatory evidence, called the Johnson Rule, is universally known among Gascon's deputies, making Middleton's blunder especially embarrassing. So, oops, too bad we didn't know, being used as an excuse. It has been on the books for 48 years. Even worse, Middleton is being paid $1.5 million a year and still making basic mistakes. Gascon's office is full of prosecutors making $200,000 a year who have no problem obtaining indictments without violating state law. Now, what do you think of this? I mean, this isn't the first time we've heard mess about special prosecutors. I don't know what Carrie Morrissey was getting paid over. I mean, the first thing that comes to mind is Nathan Wade because of the finances. The finances were an underscored issue. But I'm also thinking of Carrie Morrissey. You know, she was a special prosecutor and she came in and, you know, she violated rules of evidence. The judge was like, this is it. Dismissed with prejudice. Mistrial. So, doesn't seem to be that rare of an issue. This bungled indictment is the only criminal charge Middleton has filed in the 2 years he's been on the payroll. So here's question 3, you guys. Here is question 3. John Lewin says, 3, you unethically, yet again, gave a public statement about an active case where you told the press that you did not believe that the defendant officers could have seen the gun as they claimed. Is that a professional opinion as the DA, and what is it based on? Are you aware that when you make public statements that directly accuse charged defendants of lying in their statements, that you are jeopardizing their right to a fair trial? Sorry, just thinking about that whole thing about everything being caught on video and how, according to Relly's attorneys, that's information they got from the DAs, even though they didn't see the video. It was their understanding because of what they were told. Maybe you simply don't care because they are police officers. Are you so unethical that you're willing to do whatever is politically expedient, no matter the consequences? You would never make comments like that about a charged gang member, but that doesn't seem to be much of an issue, since you refuse to charge any gang member with any gang... alligator? We're spelling allegation like alligator down here, but, you know, no matter how serious their crime. So Lewin is referring to Gascon's statements during an April 2023 news conference on the Mitchell shooting. From my own personal review, I question whether the officers were able to see the gun before the shooting, Gascon said. He continued, we know even the prior review indicated that there was no evidence that Mitchell was reaching for a gun. The statements are significant to Lewin and many others because they seem to violate the state's bar of professional conduct. Specifically, Rule 5-120, so this is California, governs trial publicity and provides a member who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that a reasonable person would expect to be disseminated by means of public communication if the member knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative matter proceeding in the matter. In other words, don't talk about ongoing cases in the press, especially if a potential juror may hear you. This rule explicitly applies to prosecutors. As with Middleton, it was likely that Gascon, who has never tried a case, much less a media case, simply did not know what his ethical obligations are. And we're spelling homicide wrong, too. Let me link this to you guys, in case you want to read along, because I think some of it is pretty small on the screen. This is a great example, I really think this is the type of person that will fight. Like, as soon as you pick a battle, you're going to be relentless about fighting it. Seems a bit drama queen, and maybe that's for the better in certain... happens to be good in some circumstances, maybe for the worse in others. But there's already, like, all these back and forth. Lewin is doing one thing here, and then he's doing something opposite in the Rocky trial. Or Lewin's calling someone out for ethics and not passing the smell test, but... you were vacationing at a widow's house while prosecuting... Like, I don't know. I don't know about that one. So... and it's also like, this isn't to say that whoever he's sparring with is in the right, but just some of the arguments John Lewin is choosing to use to spar with that he doesn't stick with when it's a different situation seems like a bit of a flip-flop. Let's see. Honeypot says, I told y'all he funny. It gets better. All right, we're on question 4 of 8, right? Of 8. And they're on lunch. Court is on lunch until 1:45, so we have like 50 minutes, 50. All right. Do you understand the law of homicide, spelled incorrectly, at all, by your own statement that the officers never saw the gun and are therefore apparently lying about it? They would be guilty of murder, not voluntary manslaughter, based on your imperfect self-defense. I would tell you to ask your chief of staff, Iniguez, but considering he's never handled a homicide, okay, that's spelled right there, and lost 2 of the 4 felony cases he tried, I doubt that it would help much. You could also go to your top advisor and chief spokesperson, Tiffany. LAPD is a barbarian occupying army, and prison is obsolete and should be abolished. Blacknell. Okay, look at the middle name he gave this lady. This is the name. We're gonna start here. Chief spokesperson Tiffany, quote, LAPD is a barbarian occupying army, quote, and, quote, prison is, double quote, obsolete, quote, and should be abolished, end quote, Blacknell. That is the name that Lewin is giving Tiffany Blacknell. But given she's never prosecuted a case, I doubt she could help much. I would be more than happy to sit down with you and explain to you the law of homicide. You can find me in the Inglewood area office running a calendar as a result of your retaliatory transfer. So he mentions that he's on calendar duty. Here, Lewin correctly points out that if officers shot Mitchell without seeing the gun, yeah, then you'd really have you can't even subjectively say we shot because we thought he had a gun. They would be guilty of 1st or 2nd degree murder, not manslaughter. The theory of imperfect self-defense, I thought he had a real gun but I was wrong, would reduce murder to manslaughter, but only if a jury believes that the officers really thought he had a gun. If Gascon is right and the officers shot him without seeing a gun, imperfect self-defense is not available and the right charge is murder. Although Lewin focuses his fire on Gascon, this is an equally valid question for Middleton, his special prosecutor. Question 5. How much money have you spent from our DA budget on legal assistance from the elite and very expensive law firm of Shepard Mullen? That is a very big law firm. In an attempt to dig up dirt on me to support the bogus claims of your radical ex-public defender advisor, Tiffany Blacknell, We got a lowercase on her name. I don't know if that's intentional disrespect. And former advisor Alyssa Blair, who have weaponized the Board of Equity to challenge that my legitimate criticism of their outrageous comments on my social media on my own time was somehow racially based, ? What knowledge and or involvement did you have of their complaints against me? If you don't want to answer those questions right now, that's fine, but remember, eventually, you will likely have to answer those questions under oath with 2 exclamations. Whew. Gascon demoted Lewin and other experienced prosecutors when he took office. 2 of Gascon's top deputies, both former public defenders, filed equity complaints against Lewin based on his social media posts. The office hired white shoe law firm Shepard Mullen to investigate Lewin for equity violations. Many, including Lewin, believe that this was done in retaliation for the criticisms of Gascon's policies. At least 10 high-ranking members of the district attorney's staff have filed lawsuits alleging they were removed from their positions because they voiced disagreement with Gascon's policies. Gascon has also weaponized the county's equity policy to suspend prosecutors who've been critical of him. Lewin's comments could be an indication that Gascon is using the same tactics against him. So we get to question 6. This all seems so messy, you guys. This is so messy. John Lewin, question 6 says, why are you the only DA in my 3 decades within this office who refuses to acknowledge my name, the individuals who win... Oh, let me restart because I messed that up. Why are you the only DA in my 3 decades with this office who refuses to acknowledge by name the individuals who win the cases that you issue press releases about? And I don't want to hear that you're somehow trying to protect their security when these are public cases. And when you went on TV and told the public where DDA Sean Randolph landed after she won a $1.5 million verdict and proved you to be a liar in her trial. So why aren't you naming the names? Lewin is referring to Gascon's practice of taking credit for his deputies' convictions. For example, Eric Holder Jr. murdered rapper Nipsey Hussle. Holder was convicted by DDA John McKinney, a veteran prosecutor who has been critical of Gascon. The press release celebrating the conviction completely omitted McKinney, who did all the work. So they include the press. You know, I like that this website, and maybe we got to look at the end for a name if they give us like a person who wrote it. But they're like including, and then it's easy to follow. Nipsey Hussle was a beloved member of our community. He showed a commitment to improving schools within his neighborhood and investing in underserved communities. He also used his platform to advocate for gang violence prevention and to ensure we create thriving communities. His legacy will continue to inspire our work. Today, we secured accountability for the loss of his life and will continue to work alongside so many others to realize a brighter future. We know there's no way to replace what was taken from his family, friends, and fans who loved him, but we pray this verdict will move them one step closer to finding peace. Signed by District Attorney George Gascon. So, you know, there's wheeze, but there's no like nod to McKinney, who was the prosecutor that did the work. Now, the issue here seems to be that the names are named sometimes, but not others, right? If it was just nobody ever named the names and it was always just like a general the office did this, fine. But the accusation here, the implication here from John is you name the name sometimes, but not when it comes to giving the shine to the person who did the work. Sean Randolph, who was also mentioned by Lewin, won $1.5 million after Gascon retaliated against her. So somebody successfully litigated against Gascon for retaliatory movement in the office. She proved that Gascon demoted her because she pointed out that some of his policies were illegal. Oof. And you know what? It's kind of nice he's doing this Gascon guy. If he's doing all this crazy stuff, some of you guys in the chat have mentioned like Gascon was messy on other days before we looked at this. And I don't know the background until reading this stuff, but taking this stuff at face value, it's nice to hear that he didn't win re-election. So, because sometimes people just keep getting reelected. Question 7. Does the law of Brady, you guys know Brady, and the rules of professional responsibility have one meaning for everyone and another for your chief of staff, who was outwardly told the LA Times, so speaking to the media, he possesses a video of dirty cops and refuses to turn it over under law? So, telling the press that we have a video that shows this thing. Are you investigating him under Penal Code 141? Is it okay for other DAs to withhold Brady evidence? I guess that's the end of it. So, Joseph Inguez, a 4-trial prosecutor, so it's not his first trial, he's tried 4, jumped the line to chief of staff after endorsing Gascon during his campaign. Inguez was arrested for being drunk in public at a fast food drive-thru. Oh my god. Oh my gosh. Wasn't there a recent story of like I think it was like Cobb County. Because I think Deerwood Christian, I think it's DeKalb, maybe it was DeKalb County. I think DWC lives in the same county. But a sheriff got mad at the drive-thru because the order was wrong and got like all pissy and started talking to the manager. And they had to confront that sheriff about that. So I don't know what's going on with these drive-thrus. Although the police did not press charges, Inguez sued the officer for impeding him as he attempted to videotape the encounter. Inguez says he captured the entire incident on video. He also claims that the video proves the police officer made an illegal arrest and lied about it. Inguez has never released the video, even as the allegedly dirty officer has continued to do his job and make arrests. This is a problem. If Inguez is telling the truth, his failure to release the problem has allowed a dirty, dishonest cop to remain on the beat. That's a violation of his obligation as a prosecutor to provide defendants with the evidence they may need. Specifically, if you were arrested by this officer, you could hold up Inguez's video and say, this officer's a liar. You could do that if you had the video, which you don't because Inguez wouldn't produce it. If, on the other hand, Inguez is lying about the officer who really didn't do anything wrong, then Inguez's actions make sense. He doesn't want the world to know he's lying. So it's a catch-22 situation for this prosecutor. John Lewin, question 8. We're at his final question, you guys. George, was it a conflict of interest when you asked defense attorneys to write the policy for the DA's office while they were defense attorneys and had ethical duties to represent their clients? Michael Romano, Alyssa Blair, Tiffany Blacknell, Paula Mitchell, and then the policies they wrote directly benefited these clients. When Gascon came into office, he gave a sweetheart offer to a criminal represented by a campaign donor. Moreover, the offer was negotiated by Gascon by Tiffany Blacknell, a public defender. That means that Blacknell, and this is spelled differently, I think. So we're getting Tiffany spelled this. I wonder if John's been getting it wrong the whole time. That means that Blacknell was negotiating for Gascon while working against Gascon on behalf of the defendant in this case. This is an obvious conflict of interest. Although this was a particularly egregious example, prosecutors have noted many others. The largest apparent conflict was Gascon's decision to allow his policies, like his ban on the use of any enhancements, to be written by public defenders. In other words, the criminal defense bar got to write policies that benefited their clients at the expense of the public, who wasn't even at the table. And then ending this write-up out, it says, do the answers matter? George Gascon began his career as the district attorney of San Francisco County. He could easily fire prosecutors he didn't like in San Francisco, but the rules are different in Los Angeles. It is much harder, if not impossible, to fire John Lewin, which gives Lewin the freedom to ask these hard questions. You can tell that Lewin is angry by the tone of the questions. The most important question of all is whether Los Angeles is angry enough to oust Gascon in 2024. So, related. Yeah, so this is just coming from this blog here, linking it again, but it's not giving a name of the writer. But it is interesting to look at some of these Instagram posts. And on one hand, I think it's great to be able to question policy. But on the other, I feel like maybe we're talking about details of a trial that's about to come up. And in some way, this is also kind of an extrajudicial statement, at least specific details that could impact the jury on, 2 of the different cases that he mentioned in these posts. But overall, like, holy messy, you guys. Oh my goodness. Let's see. Yeah, messy. Yeah, pot calling the kettle black. And that's the thing, I think it's like, You know, some people are career prosecutors. They're in the prosecution office for so long, and I always think it'd be pretty difficult if, you know, there are cases that you believe in, you want to prosecute, you want to get justice for XYZ, whatever happened. But what happens when you're a prosecutor and your boss is like, I need you to prosecute this case, and the case could seem like the wrong prosecution? So I think it'd be pretty difficult to be a career prosecutor, because I can't imagine at any point I would just be, I don't think I would believe in every case I was supposed to prosecute. And to me, there's a difference between defending when everybody has the right to a defense. And sometimes defending someone isn't defending them saying that they're innocent. Sometimes criminal defense work is things that would mitigate sentencing, right? But on the other hand, as a prosecutor, prosecuting because it's your job and your boss decides to take a case and you're the one handling it or co-chairing it, what if you don't agree with it? What if you don't agree with it? So, hold on, wait, what are we talking about? Pickles. Hey, Biff. I like pickles. I like pickles. A pickle allergy. Seeker says Lewin is psycho. I not only would have moved to the other side of town, but all the way back to New York City. Let's see. Leah's dad says being a prosecutor must be fun. Just lie on someone well. Annalise Keating was spitting. Oh, I guess. Sorry. I was thinking of Instagram because we were just looking at Instagram posts. So, lots of mess, lots of mess. And even though it's messy, I don't know, I kind of like the infighting, because at least some stuff could get called out or brought to the attention. I don't know how to parse through the specifics of it, but the messiness kind of makes it come to the surface a little bit. It makes it a little bit more transparent. Let's see. I always like to check. Let's see if we have any updates from anybody hanging out in the courtroom. Oh, so this is a sidebar conversation, you guys. So Joseph Papp with AJC, Atlanta Journal-Constitution, shares this. He's been working on this story about two different men on Georgia's death row that were intellectually disabled, yet they were left forgotten for decades. I'll grab this link if you guys want to read this article real quick. But it actually had me thinking, in a conversation thread with, maybe I can find it, with Sapphire Ridge News and Mighty Litigator. It might be buried down in mentions. But we were, the thread was about like death penalty cases and integrity of judges, prosecutions, and overall convictions. And I think it's Mighty Litigator. She suggested that sometimes like death penalty, and I never really thought of it, but the way she said it, it makes a lot of sense. As the victim's family members with the death penalty, because there's such an appeals process, years and years, decades and decades of appeals and stuff in the news. Sometimes things that in some states prosecutors have to contact the victims for their input on, decision to give someone the death penalty versus life in prison could mean periodic interruptions and reliving the horrible tragedy for the victim's family, because as the appeals proceed, they're brought back into it, or the stories in the news headlines again. And I never really thought about that before. But seeing this article here about, two death row inmates forgotten for decades, same thing. Imagine like the victim's family members are now seeing this headline, and because it's death row versus life sentence, where they're sentenced to life, but they don't make headlines. The family's got to live it over and over again. So I thought that was like some interesting food for thought to consider. In Cali, it is 1:10 p.m. 1:10 p.m. So they will be coming back at 1:45. Oh yeah, it does say. I didn't realize it was on the banner either. But 1:45, so in like 34 minutes, 34 minutes. This is a good point too. C. Carrera says LA is definitely more political than most outside individuals. Yeah, I think so too. It's high profile. Elections are probably bigger news, probably a bit more competitive with the campaigning, which is why there's like allegations being thrown here on these Lewin Instagram posts about, you promote this 4-trial person, he's done 4 trials, you give them a chief seniority role. Because they supported your campaign? Backed your campaign? Ooh, Biff says LA City Council's wild. Yeah, I can imagine. Tons of squabbling. Would you say they squabble? Yeah, Nem, I think this is great. I think that's what lawyers do. They train to write an argument and then they orally fight against their own argument. I think in a way, like as just like a general exercise, I think this type of way of thinking can be helpful for everybody to do, right? Why, somebody's upset with me and I don't really get why. Well, if I try to reverse argue about myself, maybe I can work backwards and figure out why somebody else might be upset when I don't get right now why they would be upset. And it can help with just all different things. Because really a lot of law schools, like philosophy, arguments, and again, that stuff can be helpful just for daily life, and interpersonal relationships. I might have. No, I didn't. I'm sorry. I've been yapping. It's over here. My bad. Rashawn Powell. Let's get some W's in the chat. My bad, Rashawn. Hey, Kat, for 2 cases in a row, we've seen the state fail from not prepping witnesses. Slime Life Shorty and now Relly. What are your thoughts on this? And don't forget. I mean, maybe they didn't think they needed to prep Dennis because he's testified a bajillion times, right? He's no stranger. He's an officer. He's a detective. You get called. Half your job is testifying in court. But he messed up there too in the YSL trial. But as far as them not prepping, I feel like they didn't prep Slime Life Shorty. And that's Fulton County. But here, I don't know if they prepped Relly or not. I feel like there's a possibility they prepped Relly and it just didn't stick. He didn't listen. Or they tried to prep him but didn't really know how to prep him. So I don't know, I think there was a bit of a conundrum there with Relly because it's been about 3.5 years. He gave a certain story when he first went to the police station. His stories had to not contradict things that he'd already texted and planned to give over, right? In his mind, when he would turn over his phone, he thought all that would be turned over would be the things that he didn't delete, right? So he gives one initial story that's consistent with what he thinks will be able to be uncovered. Then as he's watching these videos a couple days later, November 9th, now he's got to mold his story, adopt new details, and maybe refine some other details based on what he's seeing on these videos. All the way through to the preliminary hearing in November 2023, which, quite frankly, the only article I can find from it is a Megan Kuniff article that Relly himself reposted and tweeted in November 2023. So he's aware of the article, he read the specifics, but with an article, you only get the details that somebody was able to capture and chose to write about and memorialize when they published the article. So he's clearly aware of that article, and now he's using those details of the preliminary hearing that were documented in this one article to keep his story straight when he testifies today, right? So I feel like he's on his own lane, thinking he's got this himself. And even if they tried to prep him, he might think he knows better. But at the same time, they could have just dropped the ball and not prepped him at all. Or he could have refused the prepping. So that, I think personally, it could have gone any way. And I don't know if I believe him when he says this. Because he'd also flip like, you know, I wasn't mad about losing money because I don't need anybody for money, but then I also lost everything, and I lost my money because of all the stuff that went down. So I can picture him saying, I didn't prep because I didn't need to, but I can also picture him prepping. So it's just like there's no clear answer specifically for RiRi. Let's see. Shauna, good to see you. Shauna says, hey fam, I'm sorry I missed all this time. What did I miss? So on the lunch break, we've been on a combined 15-minute and hour-and-a-half lunch break. They've been gone for like an hour and a half at this point. They will be back at 1:45 Pacific. We were just going over some drama with the LA District Attorney's Office and John Lewin and just a mess. But before that, with trial, we finished up with the cross, the redirect, the recross, the RiRi Direct, and the Recross of Detective Flores. Got a lot of, how did you line up this video footage and this audio footage? How are you certain that they're accurately and precisely lined up to timestamps? Is it proper syncing? What was your methodology? I think that fell apart a little bit in the defense's favor. The detective was like, well, I don't really know, or it could be. It was a lot of uncertainty about the timing of the sounds that sound like two shots are being fired, when the floodlights are turning on. It looked like Tacopina called out one part being timestamp was 9 seconds fast, but in the compilation, something was clearly not 9 seconds offset to correct for that. Also, the 12E issue. I think one of the bigger issues was 12E. We heard a bit about this yesterday with 12E. We heard today specifically that the detectives, they never even asked to interview 12E, who's supposed to be one of the first witnesses the defense puts on the stand if they get to that today. January 20th, 2025. They finally, we should ask to interview 12E. 12E doesn't want to be interviewed. He has the right to decline. And prosecution will cross him on that and try to make him seem biased for turning that down. They can do that too. Isn't that something though? We've had this fighting over the accuracy of the report. The defense is saying, well, officer, detectives, the report is flawed because you memorialized this statement from Ephron from RiRi as him telling you Ills had the knife in this report. You made this report back in 2021. But it was incorrect, right? And they're like, yeah, but if you go back and listen to the November 9th and the December 17th interviews where he sat with us while we were watching the videotape footage, you hear him say that it's 12E with the knife. And RiRi, when he was testifying last week, said it was 12E with the knife. So it was a mistake in the report. Well, if you're so insistent that it was just a mistake, but he did tell you 12E these other times, why didn't you one time say, hey, maybe we should go speak to this 12E person or look into who he is? So it's a catch-22 scenario. You either had inaccuracies, which is a problem, or you didn't do an investigation that you could have done. And we left off with this lunch break. John Lewin was getting kind of upset about this implication that the police, detectives, defense said, well, if you wanted more surveillance footage beyond, the 11:20 timestamp, you could have gotten that, but did you? No. And after another witness, we get the ballistics expert on the stand, introduces his resume, lunch break starts. The camera comes back to the attorneys arguing because John Lewin is raising an issue with the defense making an implication through that line of questioning that the police could have gotten more footage if they wanted to, but they didn't. But to me, it's fair game. So I think that's pretty much what you missed. A lot of back and forth on the inconsistencies, but do the consistencies really matter? A little bit of squabbling too of Tacopina was trying to say, if you take Relly out of the equation, if you don't have Relly, what's there for you to believe that a shooting occurred? In other words, you never would have looked at this as a shooting case if Relly didn't come in and bring you these shells himself and tell you that he was shot. You contextualize everything else because you started with that point. But if you don't have that, then what? And it was kind of a long-winded answer, but the detective did kind of recover a little bit and say, the sounds sound like a firearm, but I guess they could have been a replica gun that made that sound. The video footage, and then he tried to insert Relly, and Tacopina had to be like, no, like without relying on Relly. So, Miranda, yeah, this could be it too. He testified he didn't prep, and it's the only part of his testimony, I believe. I still think he prepped on his own. I mean, if he didn't do formal prep with the prosecution at any point in time, I still think he was rereading this one article over and over to get the details right. Because there's some specific details in there that those are the things he was able to repeat over and over. Yeah, Brittany, why wouldn't they get 30 more minutes of footage to catch these things? I don't get it. Lacey Ann, there was one 911 call when the, what's her name? Missy Elizabeth. She had like 4 names, but she took the stand. She was the one that had the balcony. She was the one that made the 911 call. And they played it briefly. They played it. But it was really short, and she was really calm on it. She said she thinks she heard 2 shots or something after seeing people fighting in the street. Oh, yeah, Lacey Ann, this too, the burden shifting with the DNA. So, again, the hypocrisy of John Lewin to raise this argument delayed after another witness takes a stand about, oh, they shouldn't be allowed to imply that we could have gotten more evidence and didn't. Well, yeah, that's true. And you have better subpoena power and the duty to do so. But then previously in the questioning, Mr. P, the other prosecutor, I think on redirect, he asked Detective Flores, he tried to make the same type of implication, but in the direction of the defense. Well, did the defense ask you for this thing so they could do their own DNA testing? No. Again, the implication being they could have done the testing, but they chose not to. So why is it okay for the prosecution to argue that the defense could have done something but didn't, but now John Lewin is having a fit, quite frankly, that the defense implied the same thing about the prosecution, who has the burden of proof here. So, let's see. Yeah, that guy Nick says, I've been surprised at how weak Relly's storyline was and how bad his testimony was. Some of his assumptions are so wrong. Quote, I didn't delete it to hide anything. Come on. LOL. And that was the thing, like, the prosecution had a plausible explanation. You just deleted everything from that moment and before. And whether you believe that or not, it's a bit more believable than, I specifically deleted these messages and don't know why I deleted only those messages. And really kind of didn't pick that up as the prosecutor was trying to put it down. Prosecutor had to ask the questions like 2 or 3 times before he got it. Oh, crazy. Nick says Taco was preparing for his motion for directed verdict. Yeah, I'm pretty sure that that's going to be... Oh my gosh. I feel like, and these motions for a directed verdict, the jury's not going to be present for. Oh, so they've got a long break. They've got a long break. So the jury will be doing whatever. But they're not supposed to be there, and I really wonder if we're going to get a bunch of objections and squabbling while Tacopina is making his motion for a directed verdict. I can picture it. I can picture prosecution objecting. I think this witness was I don't think it was the Friday. I think it was day 2. I think it was day 2, which would have been Tuesday. Was that last week? Tuesday the 28th of January, I think is when she testified. I might have clipped it separately. Let me see if I have a video. Okay. I have cross clipped here. And it says day 2, so it is from day 2. I don't think the 911 call was played in cross. Let me see if I have a timestamp. I usually timestamp stuff like that. Day 2. Or I guess we could watch it real quick. If I can scrub the timeline, if I can get to it, we can just watch it. We've got like 20 minutes before they come back. Day 2. It says 9. Oh, it's going to be 2 of me on the screen, you guys. But this is timestamped for 911 call is played. So as long as they don't argue for like 20 minutes before they're allowed to play it, we should be able to catch.
And they turned left into the back lot.
Oh.
Hi. I live in the apartment on the corner of Argyle and Selma in Hollywood. And there's been a shooting.
Did you see it or you just heard it?
Yes. No, like we watched it.
Okay, what did you see?
There were 4 men, and they were kind of fighting as they were walking along Argyle, and then they turned left on Selma. We heard yelling, and they started running, and they turned left into the back lot apartment for El Centro Apartments, and then someone pulled out, the guy in the black sweatshirt pulled out a gun, and he shot, and I think the guy who shot was a blue.
That's alright, let's focus on the guy with the handgun. Was he black, white, black, Asian?
He was black. They were all black.
Everyone put it close to that day.
He was wearing black, black hoodie.
All black.
I was on the 7th floor, so this is just what I can see from the picture.
Can you still know where you are, or do you know where he is?
No, they all ran away in different directions. 2 of them ran like towards the El Centro apartment.
Let's focus on the guy that had the handgun. You know which way he went?
I think he went to the left.
I do people, I saw all those.
Yeah. 3 went towards Hollywood Boulevard.
Alright, but I really want to focus on the guy that had the handgun. You said had the handgun. I want to know which way he went. In the direction of travel, did he go east, west, north, south? Or what apartment?
I think he went north.
North? Okay.
I think he went north towards Wine, but I'm not sure.
Okay.
That's where we kind of ran into 5 different times.
Okay. And do we know if anyone injured? Anyone found any medical assistance?
We're not sure. I saw someone go down, but there's a building in the way, and I'm not sure if they ran away.
Okay. And what's your name?
My name is Leah.
Leah. All right. And your phone number is
Yes.
All right. And just to confirm from where you are, you can't see anything from down. You can't see anything in any of the belongings at all.
No, I'm on the 7th floor, so there's a building that kind of blocks it.
Okay. All right. No problem. I'll go ahead and I'll stop it there. I'll go ahead and give us a call. Okay.
All right. Thank you.
Okay, so there is the 911 call. You guys want to go back and revisit that? That was day 2. And I know like sometimes my timestamps in the video descriptions are like probably overkill, but it is because the streams are like 8 hours long, so it ends up being a ton of different times to jump to. So my bad, they're so lengthy, but sometimes they're helpful, sometimes they're quick. Oh, and no problem, Lacey. And then Chloe, here's Chloe. Chloe says, guys, hit the thumbs up and enter to win Relly's crazy fashion collection. Includes wrinkled white tee with sweat marks, black jacket with uneven collar and scowl mask. Parentheses, pants/shoes optional. We never saw them. Get yours today. Now, what's hilarious about this is I was thinking, like, it'd be kind of cool to go back and pull, like, if there was a topic, right? Like, anytime Relly testified or any testimony from anybody about why I followed the other 3 friends, why after fight 1 I followed to area 2. And I was like, if I compile all these things, it's going to look like Relly was changing his mind on testimony within the same trial day period, because it's going to be hard to tell. It's different days, just because of that jacket that he wore each of the days. But at the same time, I don't think this is true of Relly, because I think he probably likes fashion, likes to dress. But I think there's an appreciation I have for people that have a capsule style wardrobe. It's probably better for the environment, low maintenance, get good quality pieces that last forever. But yeah, here, if you really want the limited edition Relly's crazy fashion collection, if you want to support him, show him some love, support his collection, he should start a line. So big thanks here to Chloe. Shauna, thank you for the 5 and also the $9.99 here. Thank you for supporting the channel. And if that's a thank you for the recap, you don't have to super chat for that. It's no problem at all. But big appreciation for both chats here with your support. Are you hanging out with us for the rest of the afternoon? I think it's going to be good. Let's see. I don't hear new movement over on Law and Crime yet. No. So no movement over here on Law and Crime just yet. Oh, he actually does have a clothing line. Oh my god. Yeah, that's the thing. Yeah, capsule style is funny, but not his intention. I don't think it was his intention either. Yeah, so Lacey Ann, there's a couple layers here, and this is why I think it's so interesting. So, especially with the way that the defense is approaching their defense strategy. So, he's charged under 245B, which is, assault with specifically semi-automatic firearm, which is classified as inherently deadly. Like, the jury doesn't need to decide if a semi-automatic firearm could cause deadly harm. It's just inherently defined that way. So, no longer a fact issue. But as far as the other elements, we've got to remember he's got 2 charges. So we've got these 2 different points in time, and the charges, one is attached to the parking garage, scene 1, and then the end scene, the ending when everything pops off, allegedly, scene 2. So 1 charge for each area / moment in time. And then you've got this theory coming in, and there's a justification for 245B, right? So if you can prove all the elements, he had this firearm, he touched or pointed or whatever at the defendant, or at the witness, all the elements are met, there's still a justification asked that the judge needs to give sua sponte if there's any evidence on the record sufficient evidence on the record supporting possible self-defense or defense of others. And I think we've gotten that evidence in the state's case in chief, but I expect we'll get more of that evidence when the defense is presenting their case in chief. So if the jury decides it was a semi-automatic firearm and not a starter gun, because that's throwing the wrench in this case, right? Now there's a fact issue of, was it a semi-automatic firearm or was it a starter gun? Because this would be a different charge. This would be 244.5. And can't be a lesser included of what's charged. Also, brandishing, not a lesser included of how he's charged, according to the bench notes. So, jury now can acquit him, even if they think all the elements are met on 245B, assault with a semi-automatic firearm. There can still be an acquittal if they feel like it was justified in self-defense and or defense of others. If they decide that it's a starter pistol, from my understanding, elements aren't met because there aren't other injuries, other elements in play. If it's not actually a semi-automatic firearm, that would establish the elements under 245B as charged. I imagine we're going to see Lewin fight to find some way to add a new charge to get this starter pistol in some type of way to convict him using a starter pistol under the less than lethal weapon statute. I feel like we're going to hear him cry about it. But I can't see how a judge would find that allowable, because that would have to have been alleged in the indictment. Otherwise it would be improper. So there's a lot. No, he is. So Lacey Ann, I actually think this would be very bad if he did this, because it would shrink his pathways to an acquittal. So if what you're suggesting here, he still has self-defense on the table, no matter what, no matter how this plays out. He still has a self-defense pathway to an acquittal, or defense of others pathway to acquittal. Because remember, Relly told us that Ills was petrified, right? So we have fear. Someone was in fear, petrified, while they were being harmed, right? So there could be enough evidence to warrant a defense of others justification. If Rocky were to take an affirmative defense, he would be saying that the defense has met their burden, that he doesn't dispute these other things. And it would simply be a matter of, do you think this thing was justified? But by not taking the affirmative defense, now the jury gets to decide, and they get to dispute, the defense gets to dispute the charges, the elements of 245B. So it just keeps their pathways to acquittal open. So, there you go, Lacey. There you go. That's why they kept the starter pistol a secret, and Lewin was pissed about it. Lewin was pissed. So there you go. And I don't know. The other issue is, like, guys, what if 12E gets up there? Because I think an important thing for 12E is going to be an opportunity to get in some things that maybe Rocky could testify to himself, but because we can get it in through a different witness, Rocky doesn't need to take the stand, which I think is a smart move. But what if 12E gets up there and says, Relly had a gun? What if he gets up there and says, Relly has a gun? Because now we have a whole explanation for this 911 caller. She doesn't know who was who. I think 12E's going to have some explosive testimony. I'm actually interested in seeing the cross of 12, because remember, since it'll be a defense witness, direct will be led by the defense attorneys, and then prosecution will do cross-examination. I think cross might be interesting because, 12E's kind of coming into this late in the game. Prosecution's going to be asking them questions for the first time. But if 12E's not used to testifying, prosecution could pull some interesting stuff out of him as well. I don't really know if it'll be anything that'll move the needle in their favor. But I think it's going to be very interesting. I'm also looking forward, I want to see Lydia Perez called to the stand. I just want to see it. I believe if they get through so when they get back from break, there's just under 3 hours left in the court day. They're going to do, I would imagine, motions for a directed verdict, and the prosecution gets to respond to that. Judges don't typically take a very long time to respond to these things. I know we just heard like a day apart decision with the Jackie Johnson case with the 2 directed verdicts. The directed verdict for 2 different counts. But typically, like when I watch trials, the directed verdict, the judge is like, say your piece, lets them speak for like 30 minutes, argue back for 30 minutes. All right, nope, moving on. And it's kind of more like, it feels like a formality. So if they get through that in a short window, I think 12E's starting today. So yeah, so this is, every time I see this name, I always want to go, Nicola, like the Ricola commercial. But why was Relly thrown to the ground? I don't know. Now that's something that was memorialized at the preliminary hearing. So I feel like he said that at the preliminary hearing, the dropped to the curb, dropped to the ground, that phrasing mirrored verbatim. Same thing. It was like a movie. That was also in this preliminary hearing article that Relly's aware of and shared back in 2023. The like a movie is something we heard verbatim when Relly took the stand in this trial. So I don't know if that's really how things went down, or if it's something that Relly said once when he was rereading to prep himself for the case. Figured he had to say again, but maybe we'll get some insight on that from 12E. So, that guy Nick says if Relly showed a pew-pew in his waistband or something, could explain why Rocky pulled a prop. Yeah, and things move quickly. Things move quickly. And it might also suggest, you know, like what if 12E gets up there and says he pulled out a knife because he saw this thing in the waistband, and that would explain why Relly is seeing him pull the knife but put it back away. Right? Because we have testimony from Relly, and he's given inconsistent descriptions of how this went down. But what we heard on the stand in this trial was that he saw the knife when 12E was putting it away. Right? The implication would be there, you know, if 12E gets on the stand and says, yeah, I had a pocket knife that I carry with me for incidents, and, you know, it looked like it was getting crazy. Relly was threatening Rocky. I was seeing this in his hand. So, you know, just in case, but Rocky ended up running away and I started following Rocky. So I ended up putting the knife away. Like, if we hear that, it's one of those things that lines up with what Relly mentioned, but it doesn't match the details around it. Now it becomes a credibility battle. And unless 12E gets up there and is just completely switching stories. And I think we're going to get some, you know, I don't really remember. There is a degree of reasonableness when a witness doesn't remember things. Or might say, like, you know, I'm not sure. That's reasonable. But what's not reasonable is when you're sure one moment and then you're suddenly not sure when it's time to speak about the same thing, but it's a different attorney asking you about it. So that's going to be the thing I'm looking for with 12E. And ultimately, yeah, Talk to Me, I Talk Back says the police messed up by not interviewing 12E, even the DA. They were able to, you know, they had this. Do you think the district attorney's office didn't look at these police interviews where Relly's sitting with them looking over the video and saying, oh, that's 12E there? I mean, both sides of the arm of the state could have had a light bulb moment where maybe we should find out who 12E is, reach out to interview him. I'm sure he's mentioned in some of these text messages. Like, there's no way, like, oh, we never knew who he was until January 20th, 2025. And so then we decided we're going to ask to interview him now. Just seems very incomplete. Very incomplete. Yep, and this, I think, is irrefutable, right? Micah says Relly was definitely tussling with ASAP Ills. I think the video is clear. And it was Relly himself that gave the characterization that Ills was petrified. Ills was a couple skips away from me. I go up to Ills and I grab him up. He's petrified. He was scared. Yeah, he was petrified. Like, all right, we hear you. We hear you loud and clear. Ills was here. You run up on him and he's scared of you. So I don't think that's a dispute there. Although I think it's important to underscore. And I think it's important for the defense to underscore, and also important if Ills isn't going to take the stand. I don't know if they're going to call him or not, but we could hear from 12E his perspective on what was going on in that moment. You know, Relly yoked Ills up. You know, there's reports that Ills' teeth got knocked out by Relly, which, I mean, I don't know. Could it be? Could it be? Could some type of weird marks be caused by something like that? And that's the thing, right? People are like, it could have been caused by the curb. It could have been caused by grabbing like a hoodie with the zipper. Could have been like pushing back and you scrape against a wall. Could have happened on another day, the day after that. But what if it happened from punching someone's like mouth, their teeth? So I don't know. And the idea of like Relly having a weapon or not, this is something that I like. If I was sitting there on the jury pool, if I was a juror, I've had this thought come into my mind on its own, right? And then Relly is clearly not willing to concede that he has firearms. We see him shooting. He says he doesn't know anything about firearms. We see him at a gun range. He wasn't at a gun range in LA. Oh, actually, I got to correct my testimony from Friday, now that I'm back on the stand. That was a fire range in LA on October 16th, 2021, 2.5 weeks before November 6th. Well, now, even if you swear you tell me that you're unarmed that day, I can't trust you. So I'm more inclined to think that if you tell me you're not doing something, that you are. So, I think I would be primed, my feet, the way, I take in the information from this case, and I'm positioned thinking the defense has a shot here. I'm already listening to hear 12E mention some type of reason that Relly was the aggressor. Maybe a weapon doesn't come into play, but maybe he'll say, it was actually Relly that was saying, I'll shoot you right now, I'll shoot you right now, I'll shoot you right now. Even if it was Rocky that at that point pulls out the starter pistol because someone else is saying, I'll shoot you right now. Right? Like, how that would turn a lot for me. Yeah, very, very long break. Because they combined that 15. They should be back any minute now, though. They're right at the time mark. Lucinda caught up with us because of this long break, so that's a good thing. Brad, good to see you. Brad says, y'all think Rocky will win the civil case? I don't know. Civil cases could go so differently, but I feel like there's so much inconsistency in what Relly has stated. I mean, I don't see the defamation case holding up, and maybe personal injury, like for the scrapes and emotional distress. I mean, maybe he'll get like some win over there if he did it today. If this is an acquittal, I think they're absolutely toast. Done. So, yeah, so Biff says Relly has a Staccato, a super high-end firearm company. And that's the thing, there's like these Instagram posts that haven't been brought in the trial, but you guys out there, if Young Forever's in here, Young sent them over. Instagram story posts where like he's showing through a bag, and like underneath a shirt in the bag, there's firearms in there. There's two, it looks like 2 handguns. So, yeah, straight up emotional damage is all that's on the table. Oh my gosh. Yeah, like all of this is just crazy. All of this is just crazy. And the thing is, Camille and Ben took over, or at least Camille did. Camille Vasquez took over the personal injury case from Brian Hurwitz and his partner. Like, that is, both of Relly's civil actions are under Camille Vasquez's wing. So, and I think the personal injury has, like a status hearing February 26th, maybe 25th. And the defamation case, the next date on the docket for status hearing 2 is July at some point. So he's definitely not going to get done with those before this verdict. So yeah, at least, and this is what has me sitting here. If I was a juror, I'd be sitting there like, why would you follow them? Why would you follow them? Why would you follow them? And what could be interesting is maybe the jury will decide for justification, right? Let's say they decide Rocky has a firearm, all these elements are met for both of the counts. I mean, what if they say first wasn't justified? It wasn't justified at the parking garage for him to have it out like going like this. He like pulls it up to like here, then puts it back behind his back. But he was justified when he pulled it out at the second point in time because Relly is clearly the aggressor. So there is room there, I think, for a compromise. I wouldn't, if you had me deliberating right now, I wouldn't be the one proposing that type of thing, but I wonder if a jury pool that's not me could get there. Let's see. Yeah, Tasha Red says it also could have happened when Relly found the shell casings. And we don't really have videos of that. We just have video. And that's the thing, like, do you guys think White Shirt was Relly? Or do you guys think White Shirt was Relly just hyped to say, yeah, I went back to the scene, that's me. And he was just hyped to claim this person because he wanted to have the video corroborate that he went back to pick up the shell casings there. Like, maybe in Relly's mind, when he's sitting in the police station watching these tapes, he knows he was saying he went back to get the shell casings, but knows he never physically went back. So he was an eager beaver to find something on camera that, like, no, see, I told you I went and got them. So, because there is kind of like a question here, right? Like, if this type of starter can produce casings, okay, that's explainable. If this starter can't produce casings, then we've got to deliberate on how we have 2 casings produced. If Relly went back to the scene, if Relly can claim he went back to the scene and that's him, and that person in the white t-shirt, to me, it doesn't look like he bends down, takes pictures, picks things up. Doesn't look like that's being done there. And I think he realized that, and that's why he wants to no longer say that that's him. I think it's very possible he never went back to the scene at all. And we don't know because the police didn't do a thorough job investigating the proper time frame. So, yeah, and this is the thing. And if it is him, I think this is, it's one of those things where it's like, there's doubt whether it is him or it isn't him, because he can't get it straight if it is him. And it seems like he wanted to say it was him until he was challenged on it. And then he was like, never mind, I made a mistake. And there were other lines of questioning where, with the right hinting and nudging, he seems like he needs to walk something back, and he does. I'd be like, oh, I was mistaken about that. So, we're back. We're back, guys.
Everybody going to do this again? All right, we're back on the record. We're all set with the jury. Right before we broke, we asked the court reporter to find out whether...
Muting us. All right, so they said something right before we broke. We asked the court reporter. So they're going back and looking at these questions. I think we're still going to get some attorney arguments. Gina, thanks for the 2. Says, never saw Rocky's arm raise above his waist. Right, and that's why I think it's very helpful that brandishing is not a lesser included offense. I'm sure we'll see John Lewin argue that it should be, but the bench notes for 245B say no, not a lesser included. But I think the jury could decide that that's enough. That could be enough to meet the elements. I think it's very interesting that we have a firearms instructor on the jury. So... Adela says this case sounds like it's taking place on a factory.
Objection, Your Honor. It assumes a fact, not an evidence. Overruled. Mr. Siegel then said it would just mean that they didn't have a video. I then said overruled. No speaking objection. Overruled. And then you said, Your Honor, can the jury? And I said, no editorializing by anybody. Ask another question, Mr. Persloman.
Your Honor, that was a comment that conveyed to the jury that there was potentially video that they didn't have. It's not just a speaking objection. Courts basically sustain the objection, and what it is...
No, I said overruled.
Whether it's...
All right, so what is it that you want? You are focusing on minutia.
Judge, what I want is I want the unethical conduct to stop.
Stop. Both of you knock it off.
Talking about from day one, Judge. I mean, that's...
Knock it off. Enough. Stop, Mr. Lewin.
What are we going to do, Judge?
The objection was overruled. You're focusing on minutia.
You mean a speaking objection where you work out something for the jury?
What do you want me to do? Tell me what you want me to do.
Well, Judge, you've instructed repeatedly that there's a difference between a speaking objection when you're trying to even communicate a legal reason. That's not even a legal reason. That's basically shouting out a fact to the jury. It is, Your Honor, we've had in this case time after time after time, and what happens is unfortunately the conduct doesn't result in any consequence. So, Your Honor, again, what I asked at the time was, I just want to report
when the comment was made, I wanted the court to say to the jury, that comment should not be made and you're disregarding it.
No, I'm not going to do that.
Well,
I'm not going to do it.
all right.
Both sides have been making speaking objections.
Judge, we have not one time in this case, both sides at points have made speaking objections where they've tried to clarify a point of law or say, here's why the question. We have not one time made a comment like that regarding evidence. And we're not in a vacuum, as the court is aware from conversations that have been had. I'm not making this point in a vacuum. The court knows exactly what I'm talking about, and so does the defense. And there's a point where we just had it. It's not right.
The jury's going to be told that a question by an attorney is not relevant. It only applies meaning to the answer. There was no answer to the question. This is minutia. This doesn't amount to anything. I don't want to take any more time about this. The jury is waiting outside. The jury can come in.
All right, now the jury's coming back in, you guys. What a hot mess. And Lewin is whining because he's acting like the defense is doing this thing that we would never do, but he just did the same thing with it was technically Mr. P, the other prosecutor. The question of, well, did the defense ask you for this thing so they could do their own DNA testing? No. Implying that because they didn't do something, it should be problematic.
I need response.
Hot mess.
That's necessary.
Hot mess.
Yeah, no, that's on my case.
Yeah, well, they said
We are back on the record. All parties, jurors, and counsel are present. Mr. Biraimah is on stand, and Mr. Lewin.
Thank you. So when we broke, right before we broke for lunch, you told the jurors about your background, education, and training in this area. And I believe you left off and you mentioned that in this case specifically, you were asked to conduct what's called a type and caliber analysis of 2 fired cartridge cases that you looked at in the lab. Is that an accurate summary?
Yes.
Okay. In order to illustrate some of the topics that you're going to be discussing today, did you create a PowerPoint presentation that addresses the type of exam that you did and illustrates the various terms that are going to come up throughout this examination?
I did.
Okay. Now, I'd ask to mark my next exhibit, but you need
43
with Mr. Biraimah's PowerPoint presentation. Can you see it on the screen?
This
let me turn on your little screen. Let me make it easier. So you don't have to constantly turn around.
Yes.
Is this the presentation that you created for this case?
It is.
I'm going to go forward to slide number 2. Can you tell the jurors what we see on this slide?
Sure. Well, in the course of this examination, there's a few different areas of basics that will, I think, help the jury understand the fundamentals of what we're talking about, and then actually the conclusions at the end of the examination. These topics are separated on this slide. They include firearm identification, cartridge components, pistol discharge, type and caliber determination, evidence features, ghost guns, and my ultimate findings.
Okay. We go forward to start with the first topic on your list, which was firearm identification. If you would tell the jurors what generally firearm identification is.
Yes, so within forensic science, there is a large discipline called tool mark identification. So this is simply the practice of looking at marks that are caused when a harder object impacts a softer object. Sometimes those marks can actually give us information about the objects involved. Firearm identification, what most people would call ballistic comparison, is really a subset of tool mark comparison, in which that tool is actually a firearm.
You talked about different types of tool marks. Can you discuss that just a little bit more for the jury? What it is that you're looking at when you do a tool mark identification examination?
Yes. Well, the tool is simply the harder of the two objects in forcible contact. The reason we use that word is because this is often performed using hand tools like chisels or bolt cutters. If they're used in many different types of incidents, property crimes and such, they can leave marks on items that they've come into contact with. Those types of marks vary. There's two different general types. The first is an impression. An impression is straightforward contact between the harder and softer object under pressure. The striation includes that contact, but it also includes lateral motion. So essentially, an impression is a dent, and a striation is a microscopic scrape mark.
Okay. Can you talk to the jurors how this relates specifically to firearms?
Yes. Well, the discharge of a gun releases immense pressures. It does so quickly that we often don't think about it. The pressure you use to actually inflate a tire is maybe on the order of 35 pounds per square inch. A 9mm Luger cartridge, when it discharges, releases pressures around 35,000 pounds per square inch, or PSI. These are just immense pressures, and they slam ammunition components into the gun. And that's the forcible contact that we're talking about during a firearm identification tool mark generation.
You talked about fire ammunition components. Would a cartridge case be, or a cartridge be, one of those ammunition components?
Yes, a cartridge case is part of a live round of ammunition or a cartridge. That's one of the types of components that we examine.
Okay. If you would, I want to talk in more detail about the cartridge specifically and its components. Go on to the next slide. Would you explain to the jury the cartridge?
Yes. So a lot of times people will say to fire a gun, you load it with bullets. That's not exactly true. What you need is a round of ammunition, also known as a cartridge. The top left image there, you see an actual photograph of a few cartridges. And in the larger portion of this diagram, there's a simplistic diagram of one round of ammunition. It has a few different parts. The first part is that cartridge case. It's a brass cup that essentially holds all the other components together. Jammed into the mouth of that cartridge case is the bullet. This is the actual projectile that's going to travel from the gun towards the target. Within the cartridge, you'll see some grayish material. This is the propellant or gunpowder. And at the very rear of the cartridge is the primer. This is a small metal cup. It contains some shock-sensitive explosive. When this primer is struck by a portion of the gun, called the firing pin, it explodes, causes the powder to burn very rapidly. At this point, the cartridge sort of functions like a champagne bottle being popped. The bullet is going to leave the cartridge like the cork from a champagne bottle. The cartridge case, that brass cup, is going to remain in the firearm at least for a period of time.
Okay. Moving on to the next slide. Can you explain to the jurors the different parts that we see here in slide number 10?
Yes, slide 11.
Sorry, 11, my apologies.
No problem. It essentially is just showing you another depiction of what we just spoke about. So here we have two live cartridges on the outside of this photograph. Each of those is ready to actually be loaded and fired. Just inward from those, you'll see two cartridges of the same types, which I've actually pulled apart. So here you can see at the bottom, there is the cartridge case, that gold-colored round item with the writing on it that's facing us. The primer is in the center of that. The grayish black powder material there is the propellant that's actually going to give the discharge its pressure. And at the very top of the center of the photo are two different bullets. These are typically going to be copper wrapped around a heavy lead core, and that's the projectile that travels through the barrel towards the target.
Okay. Now let me understand the components of the cartridge. I want you to explain to the jurors the discharge process, if you would. Let me get to the next slide. Can you describe for the jurors what we see here?
Right, so here we have a simplified diagram of a cartridge that's positioned within a semi-automatic pistol so that it can be fired. The cartridge is located in essentially a tube called the barrel. It holds that cartridge and it will guide the barrel, the bullet, as it exits the gun towards the target. This cartridge is in the unfired state and it's ready to discharge.
And you said this illustration specifically is of a semi-automatic handgun, correct?
Correct.
All right, I'm going to click it, and it will show us sort of the actions or what's happening within the gun at the time the trigger is pulled and the cartridge is fired, correct?
Correct.
Okay. Can you describe for the jurors what the action was or what we saw in the motion on that animation?
Yes, so the first cartridge has discharged. The propellant burned and the bullet went down the barrel towards the right side of the image. At that same time, that pressure is actually going to be harnessed by the mechanism within the gun. It will cause the top of the gun, it's called the slide, to recoil, to move to the rear. This is going to use some of that energy from the first cartridge that's fired in order to prepare the gun to be fired again by a second pull of the trigger.
Okay. Would you describe the kind of bluish tinted area that we see in the handle of the gun there?
Yes, so that's depicting what's called a magazine. This component will actually be inserted inside the grip of this type of firearm. Magazine holds rounds of ammunition, stores them within the gun until they're ready to be fired. Essentially it works like a Pez dispenser, if you're familiar with that, without the plastic head, so it's a box, it's got a spring in the bottom and it pushes the cartridges towards the top. When the first cartridge fires, The top of that gun reciprocates, as you saw it move. This allows the gun to first remove the extended cartridge case from the chamber where a live cartridge needs to be positioned to fire a second time. It reloads that chamber with the top cartridge that's in the magazine, and it also resets the internal mechanism of that gun. When we say that a gun is semi-automatic, that specifically means that every time you pull the trigger, one cartridge is fired. It's going to function like a Windex bottle. I can hold the trigger all day, no more ammunition is going to be expended. So that is semi-automatic, as opposed to full automatic would function like an aerosol can. I hold the trigger and it will continue firing until the source of ammunition is depleted.
When you talked about the extended cartridge, that's the piece of the cartridge case that's left in the gun after the bullet comes out for what would be essentially a fraction of a second, correct?
Yes, that's the cartridge case. That's the brass cup. It's depicted in gold color on these particular diagrams. And that is the part that will be extended and ejected from the chamber.
How does that happen? How does it eject out of the gun?
Again, this is one of the functions that the mechanism is doing when it harnesses that energy. After discharge, there's a small hook in the gun called an extractor. It's going to pull that cartridge case out of the chamber rearward from the barrel. It's going to hit another implement called the ejector. At that point, it's going to be flipped out of the gun. It essentially will appear like if you flipped a quarter as hard as you could towards your right shoulder. So that extended cartridge case will be cleared from the gun and remain in the vicinity typically.
And is that action that you just described consistent among all semi-automatic firearms?
Yes, to fire a semi-automatic gun, such as depicted here, more than once, you will have to clear the chamber of that expanded cartridge case. It's a necessity to fire multiple times.
We've covered this a couple of times, so if you would just briefly talk about what the distinction between that action would be versus a revolver.
So a revolver uses a different mechanism. You may have seen these in Western type movies. Rather than having a magazine and a single chamber, there's a part called a cylinder. This is a cylindrical component that can be loaded with a number of cartridges. That component will then be rotated, bringing each cartridge in line with the barrel one by one, so that each can be fired. After that cartridge is fired, the cartridge case in a revolver will remain in the chamber of that cylinder until it is manually extracted and ejected from the gun.
Okay. We move on to the barrel of the gun. Would you talk about what happens in the barrel when the gun is discharged?
Right, so this is the portion of the gun that's most interesting to a firearm examiner during discharge. So I just enlarged that tube, the barrel. The rear part, you can see it's specifically made to accept that cartridge. That's the chamber. The entire device runs off of pressure. So the rear of that barrel has to be closed off. This will be accomplished by a surface that's called the breech face. It's illustrated here in that bluish green color. In the center of that breech face, there is a hole or a channel that allows the firing pin to protrude and strike the cartridge and initiate the discharge.
Now, specifically with the examination you did in this case, would you agree that a lot of the information that you were looking at comes from that area around where the breech face, the aperture, and the firing pin are?
Yes, a great deal of the information for cartridge cases in general, and in this examination in particular, will come from that portion of the firearm.
Because it's important to this examination, would you just highlight with the pointer exactly where those three different features are? The breech face, the aperture, and the firing pin?
Sure. So the breech face is going to be the forward surface of this blue block. That's simplified for the purposes of the diagram. You'll see this channel. That's meant to depict an opening in this solid breech face. The very opening forward portion of that channel is called the firearm pin aperture. It's just the name we use for that hole, the opening. And depicted in orange, this simple cylindrical implement is the firing pin that will be propelled forward, strike the primer, and initiate discharge.
You said in your examination in this case, you looked at 2 of those fired cartridge cases, those brass cups, as you talked about, correct?
Correct.
You did not specifically evaluate any actual guns in your examination in this case, correct?
Correct.
So how is it that you were able to see any of the information that would come from the gun, meaning the breech face, the firing pin, or the aperture, if you didn't have a gun and all you had was that brass piece that was ejected from the gun?
Right, so again, this is an effect of those immense pressures and forces that are involved in discharge. Someone about my size stepped on a soda can. I'm exerting, I believe it's about 5 pounds per square inch. You can imagine that surface of the street could then cause dents into that soda can. Here we're talking about pressures in the order of 35,000 pounds per square inch. These are acting on surfaces of the cartridge case, which are not much harder or much different than you might find in the soda can. This allows just huge amounts of information to be imprinted into the material of the cartridge case, allowing type and caliber determinations to occur, giving it a job.
Okay. Look forward to the actual discharge process. Can you describe what we see on slide 19?
Sure, so it is depicted that firing pin coming forward, slamming into the primer, initiating discharge. Once that bullet has moved to the end of the tip of my finger, it is moving at the speed of a commercial jet, and it's rotating now at maybe 60,000 to 80,000 rotations per minute. So a great deal of energy has been released. The bullet's on its way out of the gun through the barrel, and pressure is slamming that cartridge case into the surfaces of the gun. This allows that firing pin to leave an impression. The firing pin aperture itself can be impressed into that primer with such a force that we can see the actual imprint, and also breech face markings. The small imperfections of that breech face can actually be impressed into the surface of the cartridge case, just as you would impress a fingerprint into a lump of clay.
Okay. This is an illustration that you have on in slide 19, correct?
Yes.
Did you put actual examples of these different components, the breech face, the apertures, in your presentation?
There are, yes, some exemplars. There's only one, I believe, that's related to this case. These images, such as the firearm you're seeing, are unrelated examples.
Okay. What specifically are you showing here in slide number 21?
So what you just saw was a gun that's slowly been disassembled to show you the internal parts that are going to be in contact with the cartridge during discharge. We're looking at the left side of the image. We're looking rearward at that breech face. This is the surface that will close off the back door of that barrel, the tube behind that live cartridge. The main area is tinted blue there. That is the breech face surface. You look towards the center, you'll see a dotted line. I just added that dotted line around that opening. That opening is the actual firing pin aperture. And within the opening, you'll see an orangish sort of elongated implement. That's the firing pin. On the right side of that diagram, you'll see an illustration of the types of marks that we'll talk about. The blue area, that circular area, is the primer. It's a soft metal where that explosion happens on the other side of it. Marks from the breech face can come over. You'll see that dotted line outlining the firing pin aperture, and an actual impression into the material from the firing pin striking and causing discharge.
Okay, you said the illustration or the animation of the gun slowly being taken apart. I'm going to just go back so we can follow what you were showing. It goes by a little quickly, so I'm going to play it again.
Sure, so the top is a slide and barrel. Now I've taken the slide and the barrel apart. Here we're looking at the slide, which has that breech face surface within it.
Okay. I'm going to go on to slide number 22. Would you describe what you're illustrating here?
So a typical firearm identification task will often include what we call an actual microscopic comparison. I'll use an instrument to look at the tool marks on two items such as cartridge cases with the aim of trying to determine if they are fired by the same particular source. You could come to an opinion that they were fired by the same gun, or an opinion that they were not fired by the same gun, meaning they've been eliminated. That information is typically most useful when there is a gun in evidence. So here we just sort of depicted that there's a firearm. Test fires from that firearm can be compared to the two evidence cartridge cases connected with the dotted lines down there. The cartridge cases depicted in different colors are sort of just indicating that sometimes the features of those actual marks will be sort of an apples and oranges situation. And we can tell, even without looking at the microscopic markings, that they were fired from different guns.
You said what's displayed up here would be an identification that you can make if you had a gun to actually compare the fired cartridge cases to, correct?
That's when it's most useful? Yes.
If you hypothetically had received a gun in this case to compare to the two fired cartridge cases, could you determine scientifically if that particular gun that was provided to you was the one that fired these cartridge cases?
I could perform a side-by-side microscopic comparison on a comparison microscope. If the marks are of sufficient quality, it may allow me to come to the opinion that, yes, the reason for the agreement of those marks is I'm of the opinion that they were fired in the same gun. Conversely, it could lead us to the opinion that they were not fired in the same gun.
That was my next question, was if you were provided, hypothetically, if you were provided a gun to compare to two fired cartridge cases, you could also definitively say, looking at these individual marks, that that gun was not used to fire those cartridge cases. Is that what you're saying? Is that correct?
Yes. There's identification, same gun. Elimination, they were not fired in the same gun. If there's any deficiencies with the items, we can just say inconclusive, meaning I can't give you any definitive.
Okay. And that's if you have a gun. But if you don't have a gun, what are you looking at? In a case like this, or what you would call a no-gun case?
Right. So you can perform that comparison with two cartridge cases collected in the same area. But again, it does not tend to give you much additional information. What we will tend to do, if you just had two items collected at a crime scene, for instance, is perform what's called a type and caliber determination. So here we would be trying to characterize or describe types of guns which we know to produce marks, such as those that we see on the evidence.
Okay. Which gets into the analysis that you did the type and caliber, correct?
Correct.
Okay. Let's talk about let's talk about caliber first, or how you do these types of analysis.
Right, so this is basically reiterating what I just discussed. So type and caliber, we're leaning towards trying to determine two different groups of information. First, the caliber, the specific type of ammunition, the size of ammunition that the unknown gun is intended to fire. And then we will actually look at the marks on the exhibit to see if we can begin to list some brands of firearms which we know to produce similar marks.
Okay, when you're looking at fired cartridge cases, is it difficult to determine what the caliber is?
Cartridge cases, it is not so difficult. They have a portion on the rear of the cartridge case surrounding that primer that typically has what we call a head stamp, meaning that the manufacturer has stamped in usually some identifying information about who made the cartridge, and also the caliber of firearm it's intended to be used with.
Okay. Moving on, can you describe the illustration you have here in slide 27?
Right, so this is just to get a sense of that type of caliber examination. Imagine that you have a clean kitchen floor and 30 seconds later you have a muddy footprint right in the middle of it. Something we're just instinctively going to do is look at the basic size of that footprint. At this point, we're probably going to narrow it down to some of your family members as opposed to others. You could look closer into that footprint, and if you see a particular design that is typical of a particular brand of shoe, this can further narrow sort of your list of suspects in your household. Type and caliber determination is essentially you're just doing that same process, but we're doing it using ammunition components, which is a little bit of a different exercise.
Yeah, different.
Just following your illustration of the muddy shoe print, are you saying that if you were to look at a muddy shoe print on the floor and see that it was a smaller size, you may eliminate that, oh, it was an adult that contributed to this footprint because it's too small to be an adult shoe, something like that?
Correct.
All right. And then if you have multiple children in your household, are you saying you could look at the pattern of the muddy footprint and say if my son wears Converse but my daughter wears Reeboks, that you could eliminate one just based on the pattern that you see in the mud?
Right, and you're using patterns that are common to other Converse shoes out there. You aren't linking it to one particular shoe, but you're able to sort out this list of limited suspects.
So if you have 3 kids and 2 of them were Converse and one of them wore Reeboks, you could eliminate the Reebok, but you wouldn't be able to distinguish between the 2 Converse. Is that kind of what you're saying?
Right. You've narrowed it to 2 potential culprits and eliminated one.
Okay. Let's go on to talking about caliber with cartridges.
Can't wait for Recross.
Okay, so caliber is another term that people pick up from movies and TV, but...
All right, and remember, or if you haven't heard it yet, there is a firearms instructor on the jury. So that means she teaches courses. I don't know specifically on what. Maybe like concealed carry. I don't know exactly. An instructor, not an expert witness, but someone that deals with firearms. Now, I wonder if they're familiar with stuff like this, where, you know, just because we can look at a Converse print and tell that it was a Converse, or we look at an aspen tree and we know it's an aspen because it's an aspen. What they're trying to compare with the shoe print comparison is if it's a Converse print, it's a Converse. We might not know who was wearing it, but if we end up saying it's a size 9 Converse and this person also has a size 9 Converse, it's a pretty good link. But here what they're going to be able to tell us about this caliber match is this shell casing is 9 caliber, and based on the markings, this markings could be consistent with a Glock 43 firing it. But that doesn't mean that another make couldn't have fired it. For their ballistics report, from my understanding, it's not constrained to just one type, make and model gun. So, like, I feel like the shoe print thing is quite misleading. But, again, we'll get to cross.
It has a specific meaning. So, if you were to pick up a flashlight in one aisle of a store and a battery in another aisle, you're going to select the proper compatible items based on that size system. For instance, you're going to pick a AA battery It allows you to match up the right battery with the right flashlight.
Billy had 5
Caliber is a similar system for ammunition. It's a matchmaking system that allows us to put the right ammunition into the right type of firearm. So saying a gun is of a particular caliber is like saying a battery is of a AA size.
Okay. Going on, are there common calibers that you see in your laboratory?
Yes, there are hundreds in existence, but most of the work that we actually see day to day will come from a relatively small grouping, maybe 20 to 24 different calibers.
This is actually very helpful for the defense. Most of the different cases, unrelated cases, all the cases that we look at, it's just, about 24 different calibers that we deal with. So most casings come from a limited pool of calibers. Which means what? More people could be the source. More things could be the source of the same thing.
That are commonly encountered in a crime.
Talk about caliber and then talk about type. What do you mean when you say type in a type and caliber analysis?
Right, so it's kind of a vague term, but what we mean by type is that even when we're looking at these marks, even very simple implements like that firing pin are very carefully designed. That specific design may be common to a group of firearms. So by examining the imprint of particular features, we can begin to associate a mark with a group of firearm brands which we know to produce similar implements.
Can you describe the different, well, describe first what a class characteristic is and then what the different class characteristics are when you're talking about cartridge cases.
So a class characteristic is a feature which is going to be common not just to one item, but to a class or a group of items of a similar design. So a particular shape of firing pin may be common to firearm brands X, Y, and Z. This group of X, Y, and Z is a smaller, more restricted group of the potential brands out there. When we do a type and caliber analysis, we're using these features. We call them class characteristics. When looking at a cartridge case, some of the most important class characteristics will be the caliber, the shape of that firing pin aperture, as well as the shape of the firing pin itself.
And again, the aperture is the hole that's in the breech face, correct?
Yes, it's like the donut hole in that breech face, and that actual shape can be impressed onto the discharge cartridge case.
And the firing pin is the piece that strikes the primer that, as it strikes it, it also leaves an imprint of the shape of the firing pin?
That's correct.
Okay. Can you talk about the class characteristics you see up here?
So this is just sort of illustrating that process of narrowing our candidates. So we begin with the caliber. At the bottom left, this is just an image of a cartridge from the laboratory. You'll see at the center that circle is the primer, and you'll see writing impressed into the outside of that primer. That's called a headstand. It's placed there by the cartridge manufacturer. And simply by reading this headstand, also comparing the basic dimensions of that cartridge case, we can determine the caliber of the cartridge. So this particular one is a caliber called 9mm Luger.
Okay, the next class characteristic?
Again, to describe that hypothetical firing pin aperture, this is a laboratory gun. We're looking at that breech face. The dark circle in the center is that hole, the firing pin aperture. The firing pin is going to protrude from that hole upon discharge. And the shape of that hole may vary. Some of the shapes that we commonly run into would be round, which is pretty generic. A rectangular shape or sometimes even a teardrop shaped aperture.
Now, when you talk about caliber, to the right of the word caliber there's 5 boxes that each have a number and some letters below it. Are those common calibers of cartridge cases that you see?
Right, so this is just illustrating a hypothetical, but these are 5 different common calibers.
Guys, I'm pretty sure it's been about an hour and a half, because he was on the stand for like 15 minutes before the break, that this guy's been up here and we haven't gotten to the casings in question. Have some mercy, Judge. Make this move along.
They usually have a very specific name that can be shortened and placed onto a cartridge headstand.
So a fire cartridge that you'll see will have a caliber associated to it, correct?
Yes.
And then it will have the aperture shape, which will be is more than likely to be one of those 3 shapes that you have listed up there, correct?
Very commonly, yes.
Okay. Sorry. Can you describe what you're showing with this next illustration when it comes to the aperture shapes?
Yes, so at the bottom of this illustration, we have images of 3 different cartridge cases, and these have accepted that imprint of the aperture shape. So at the right-hand side of that image, you'll see a dotted line outlining a circular aperture. In the center, the dotted line is outlining that rectangular shape aperture. And at the left side of the image, you'll see the dotted line that's actually in a teardrop-shaped configuration. So these are just examples of the different shapes that we'll be assessing.
And each one of those 3 is a different example, just showing the different shapes that you can see in 3 different guns, correct?
Yes.
Okay. The last class characteristic you talked about was the firing pin shape. Can you describe that to the jury?
Sure. In the bottom right, this is actually a magnified image of a firing pin. It's about the size of the tip of a ballpoint pen. This particular one is round or hemispherical. It's a very common shape of a firing pin. That round outline will then be imprinted into the cartridge that firing pin discharges. Again, there are different types that are commonly found to be manufactured by different brands. These again would be round, rectangular, and teardrop shaped. The aperture and firing pin shape do not have to match. So these different combinations give different classes their distinctive features.
So I just want to put a finer point on that. Just because the aperture of a firearm is round does not necessarily mean that the firing pin itself is also round. It can be a different shape.
Correct. It's up to the manufacturer, and they can combine those as they see fit.
Okay. All right. And then do you have examples of what those different firing pins looks like when you look at them in the laboratory?
Yes. So these are the same images. Here at the center, you'll see a depressed area that is then outlined with a solid yellow shape. So at the right side, you'll see that the outline of the actual firing pin that was pressed into the surface is round. In the center, it is rectangular. We may also call this elliptical. And on the left-hand side is a more distinctive shape, that actual teardrop shape that can be caused by the firing pin itself.
Okay. Go on now. You said you actually did an examination in this case of 2 fired cartridge cases, correct?
Correct.
When you are assigned to do this type of analysis, a type and caliber analysis on fired cartridge cases, what's the first step that you take in the laboratory?
First step is to obtain the evidence. It's going to be actually stored with the property system. I'll go check out that evidence, bring it up, log it into our computer system, and perform an inventory of the evidence package.
In order to check the item out of property, how is it that you do that? Is there some number associated with it?
Yes, each investigation at LAPD receives a number. This has been called for most of my career a DR number. I think it means Division of Records number. This is simply a number that identifies a particular investigation. Evidence that's collected associated with that investigation will be filed under that DR.
The jury's awake. Brianna walked in during this testimony.
06-18784.
May I refer to my notes?
Yes.
Thank you. Yes, 2106-18783.
All right. When you went to property division, did you obtain the envelope that we see here that was previously marked People's 32? And let me bring that up there. Bring it to you if you need to inspect the envelope yourself.
Thank you. Yes, this is the envelope that I received.
Okay, and how is it that you recall that this was the specific envelope you received?
It bears the DR number as well as the number 1, meaning it is item number 1 booked to that DR number. On the back side of the envelope, it has my initials, my stylized initials, my serial number, as well as the date that I opened the package.
Okay, I see it. What I have frozen up on the screen there, is that the front side of the envelope?
Yes.
And putting up the back side, are these the initials that you were referring to?
Yes.
All right. Take out the smaller envelope. I'm going to show you the back side of the smaller envelope.
Finally getting to the casings, guys.
You approach the tapes and screen and let me know, but did you
A lot of tape.
receive this smaller envelope as well when you did your examination?
Yes, it bears my stylized initials and information.
Are they up here just below the tape?
Yes, that's where I marked the envelope when I opened it.
Okay. Then lastly, we take the 2 items out of the smaller envelope. Up here. You can approach with these, you tell us that these are the fired cartridge cases that you examined in this case.
There never was a chain of custody anyway, Nick. This all started with Relly. Chloe's out here like a paper boy.
Yes, their external features match the features that I documented. And there are also engravings on the inside of the actual cartridge case. When I receive evidence, I will engrave it with the item number, portion of that DR number, my initials, and serial number inside the mouth of the case where it will not obscure the others.
So that you know later that they're the same ones in the package.
Yes.
Okay, I'm going to put them back. Smaller envelope. Back in the larger envelope are People's 32. So after you received that envelope and those specific cartridge cases, what's the next step that you take in your examination process?
So the next step is going to be filling out some worksheets with the basic observations and features that are observable on those items. Both of these were booked as item 1, so I did designate one of the 2 as item 1A, the other as 1B. Then I documented the material and general features that we will systematically do in the opening stages of an examination.
Okay, and then the next step after documentation, what would you do?
So that point would just be to sort of classify those actual markings that were observed, the aperture shape, the firing pin shape, and these are just outlined in preparation for the interpretation part of the actual analysis.
Okay, so you talked about in your prior testimony looking for those 3 class characteristics, the aperture shape, the firing pin shape, and the caliber, correct?
Yes, among others, but these are the most prominent and useful.
Okay. So is that what you're talking about when you look at them in the laboratory? You're documenting each one of those class characteristics?
Yes.
All right. So we're going to go back to your presentation here. Now you're going to start talking about the specifics of this case, correct?
Correct.
All right. Let's start with slide 40. Can you describe for the jury what we see here?
Yes, so the photo at the right side of this this slide is a digital image that is from the computer database system. This was, it's called Leavin, N-I-V-I-N. This was taken before my actual analysis, but it's a good depiction of what I was looking at. In this picture, I've got the numbers 1, 2, and 3 there. So first, I've categorized the actual caliber. It is a 9 Luger caliber cartridge. Looking at the imprint on this of the aperture, I classified that as teardrop shaped. Looking closer into that actual depression in the primer, I classified the shape of the firing pin as also being teardrop shaped. So in the bottom left, there's a simple diagram outlining those features that I observed.
Okay. All right, let's go on to the next area. If you would describe sort of the value of the class characteristics that you observed, that information you just talked about.
Correct. So now I'm beginning the interpretation stage of the examination. That first stage, here illustrated on the first line next to the one, is the determination of caliber. That was 9mm Luger. This is very common. In our lab, it's the most common caliber that we run into. So while that is interesting, it narrows our pool of candidate firearms to some extent. It's still a very common feature. Down at line 2, I'm then going to move to begin to interpret what does the teardrop shaped aperture mean. How does that allow me to further restrict the list of candidate sources?
Okay. Let's move on then. If you would talk about after you document those 3 features, those 3 class characteristics, what's the next step that you took?
So at this stage, it becomes a bit of a research project. I'm using literature from my field in order to get the broadest list of known candidate sources with a teardrop-shaped firing pin aperture. The left side here is depicted just a couple of articles that I used. These are from the Journal of the Association of Firearm and Toolmark Examiners. This is a peer-reviewed journal that's been in print since 1968, I believe. A few of these articles started me down that path. There is also an electronic forum that's operated by AFTE. It's available to AFTE members, AFTE, Association of Firearm and Toolmark Examiners. This is an electronic exchange for professional examiners in a members area of the AFTE website. It allows them to interact and exchange information about new observations that they have with casework. And this is more responsive than the actual particles. We can disseminate information quicker by those means.
And these were the sources you used to kind of determine how big the pool was of potential candidates to compare to those three features you talked about.
Correct. I'm just looking for a list of suspect guns, if you will, brands which we know to include just that one feature, the teardrop-shaped firing pin aperture.
Okay. So it was specific to the firing pin aperture?
Correct.
All right, let's move on. What was the next step you took?
The next resource I used is called the Class Characteristics Matrix. This is a developing database, also operated by AFTI. It allows me to just, you may enter different features, such as caliber and firing pin aperture shape. I did so.
Hold on. Why did it get quiet? Why did it get quiet? Hold on, we're going to back out. We'll get the volume back up.
In order to try to broaden that list of potential makes known to the community to produce teardrop-shaped firing pin apertures.
Okay. After looking at those resources, what did you determine was the potential list of firearm manufacturers that could have contributed to that aperture?
Right. So from all the manufacturers operating, the list that is known to me as a result of consulting these sources comes down to just a list of about 5 different manufacturers. So we've narrowed that candidate group considerably just using that one feature. These images there are logos or images depicting those 5 sources.
Okay, so you went from 9mm, very common source, to now whittling it down to 5 manufacturers, just with the aperture shape, correct?
That's correct.
Okay. If you would talk about the kind of next step in your research project.
So moving from the aperture now to the actual firing pin. At this point, it becomes a little more challenging because the firing pin that I'm looking at in this case just happens to be quite distinctive. Fortunately, several months before the occurrence date of this case, I initiated a project where I collected samples from firearms that were coming through the firearm unit. We regularly test fire pistols that come into LAPD custody to be entered into the Leavin database. I collected 229 different firearms examples, and these are specifically what we call ghost guns. It's a new sort of phenomena of firearms. By examining the samples from those this sample set, I was able to locate a few species that actually exhibited the firing pin consistent with the one that I observed in this case.
The teardrop shape, correct?
Teardrop shaped firing pin, correct.
Okay. And when you add that class characteristic to your analysis, so now you've gone from caliber, you've narrowed some out with the aperture shape, and now you've added in those that have the same aperture shape and this unique firing pin shape. What were you left with?
Right, so I'm left with the logo there you see on the left is not an actual manufacturer, it's just representing what we call ghost guns. So there's one particular aftermarket slide which is common to a particular frame size of ghost gun. That particular product exhibited the firing pin shape that I observed on the evidence. It also has some compatibility with frames that are produced by Glock.
Okay. Before we talk about ghost guns, you mentioned Leavin. Would you describe for the jurors what that is and how you used it specifically in this case?
Sure. We may be more familiar with DNA databases. Samples from a crime scene may go into a database. Samples from suspects will also go into the database. The computer will attempt to match samples and potential suspects. We have a similar database in firearm identification. This is called NIBIN, National Integrated Ballistics Information Network. So when we have a group of evidence cartridge cases, such as the ones in this case, we can enter it into the system and attempt to look for potential matches among tens of thousands of candidates that are in that system. At the conclusion of my examination, I took the actual items that were...
All right, guys, rate the NIBIN logo on a scale of 1 to 10 for graphics design. They've got the ammunition working out with those eyes and the dots there. What do you think? What do you think of this NIBIN logo on screen?
Previously imaged into the NIBIN system and had them correlated again. This means those images of our evidence were searched against the database again in order to see if I could find any other makes of firearms depicting that particular firing pin shape.
You described using the AFI resources, or the resources from your association of other tool market examiners. Would NIBIN essentially have been kind of like a double check to your research that you did on the AFI resources?
Right, so the AFI resources, I'm trying to expand my list of possible candidates. I expanded that list, and those resources also told me what types of firing pins I expected to see. I didn't just take that at face value. I went, looked through NIBIN in order to attempt to confirm whether those resources were accurate. According to the samples that I looked at on this database, they were as advertised or published in those resources. Finally, I used NIBIN again as a second sort of double check, putting our actual evidence in and seeing if there are any other brands I'm unaware of that had similar marks.
Now let's talk about ghost guns. You used that term a couple times. If you would describe what a ghost gun is.
Sure. Well, this slide sort of depicts the, I guess, mainstream way of manufacturing and distributing firearms. So they're typically made by a licensed manufacturer, shipped to a retailer that has a federal firearms license, and they're sold to us in public from that retailer. So that is how typical guns are distributed. I say guns of typical manufacturer as opposed to the species that are commonly referred to as ghost guns.
Okay, moving on to that. Can you describe what you are illustrating here?
Right, so the ghost gun species uses a frame. That is the portion you're going to grip. This is the part that needs to be serialized and controlled if it is manufactured and shipped to you, the consumer. Ghost guns use a product that is an incomplete frame. It requires you as the consumer to make just a few adjustments, drill a few holes in order to make that frame operational. You can order these over the internet. You can also order what's depicted there. The frame here is in that pink color. You're also going to need the other firing components, such as the slide and the barrel. These can also be ordered online. Then, using simple hand tools, as most of us would have in our garage, these aftermarket parts can be assembled and to produce a functional gun. Now, this gun does not have a serial number in that state, because when it was shipped, when the frame was shipped from that manufacturer, it was shipped in an unfinished condition, which did not require it to have a serial number. This is where the term ghost gun, I think, has taken hold, because it does not have that serial number that's known to law enforcement.
You talked about three parts of the gun, and you said the pink part that you have illustrated up there is the frame. What are the other two parts? The gray rectangular shape on the top and the kind of orangish cylindrical piece underneath the pink part.
These are the main other components. Okay, so the pink part is that frame.
Yeah, I say let's talk about this because now on the outside, we are aware of posts that RiRi made years ago to his Instagram stories post where he has guns in a bag. He has 2 different handguns in, I don't know if he was traveling or whatever, but they're like under a shirt and he like lifts up and you can see them in the bag. But we had testimony today that back in 2021 when the detectives looked, they didn't see any firearms registered in RiRi's name. But he was clearly in possession of some, according to his own Instagram stories that we've seen out here. What we're seeing at trial is this guy now talking about these ghost guns, but we also know that the weapons they found, any firearms they found at Rocky's house, they were all legally registered, either to himself or to his manager. So I think this is a great point. Teresa's saying, so you're saying the man who has registered guns in his name went out and also got a ghost gun. Could be possible, right? But very interesting when you have the star witness talking about, I don't know anything about firearms. I only got a firearm after this incident. Then we find out that that's not true.
That orange tubular shaped item is the barrel. That is where you load the cartridge, and that's where the bullets actually get to travel, go towards the target. The gray object at the top of this image, that's the slide. It contains the breech face and the mechanism associated with the firing pin. Marks on the cartridge case are primarily coming from that component, the slide component of the firearm.
And are you illustrating that you can essentially purchase these individual pieces separately? So you could just buy a frame, you just wanted the frame?
Correct. You could buy the kit that can be used to produce a frame, and then the other components can be purchased separately from various retailers.
Okay. If you already have a working firearm, but you want to exchange a piece like the slide or the frame, can you do that by removing a piece and then adding an aftermarket piece?
Yes, you can. Just like my car has a license plate, it's licensed. I can change the rims on my car. I can buy aftermarket ones and slap it on there. That's what we're essentially allowed to do with these components of the gun outside of the frame itself.
Okay. I think you already described they can be assembled using hand tools. What are you illustrating here in slide number 5?
So this just illustrates a couple actual products that are out there for privately made firearms is one of the terms the slang is goes with. These products show some tooling that can be used to actually complete the manufacture and make the kit, which is sold into a functional frame that can be joined with a aftermarket slide and used as firearms.
You said there's 2 brands that are illustrated up there. What are the 2 brands?
These are 2 very common brands. One is at the bottom center is Polymer 80 with the P80 logo. There is another brand, the firearm is marketed as an SS80, and that's depicted in the top right portion of the slide.
Okay. All right, moving on. Would you discuss kind of the manufacture or the features of some of these ghost guns?
Right, so this image is depicting the fact that these kits are produced to mimic a typical gun that's already in mainstream production. So there are 2 actual models here that are listed there. On the left-hand side, there's a SS80 is one. There's a PF9SS. That's another. These 2 particular ghost gun frames are compatible with a particular model of Glock, and that Glock is called a Glock 43. So they are made to be sort of imitation frames of that Glock, and they're compatible with those aftermarket parts which are also compatible with that particular model of mainstream manufactured Glock pistol.
So when you were first explaining to us how, or kind of the origins of what a ghost gun is, you contrasted that to a gun that came from a licensed manufacturer. Am I stating that correctly?
Yes.
Would the Glock 43 being produced by the Glock Firearm Company, would that be what you're talking about as being produced by a mainstream licensed manufacturer?
Yes.
And the ones that you have listed here on the left, the Polymer 80 EF9SS and the Glock SOR SS80, would those be the ghost gun versions of a Glock 43?
Correct. These are the privately made firearm or ghost gun versions of the frame of a Glock 43.
Made to mimic a Glock 43?
Yes.
Okay. All right. What are you illustrating here?
So here it showed one set of aftermarket parts just illustrated there. The markings I found on these evidence items can be linked to a particular aftermarket slide. This particular aftermarket slide is known to be compatible with a few models of firearm frames. These include the Glock 43, 43X, on the left-hand side that's depicted by that dark black colored frame. On the right-hand side, the pink frame is representing the ghost gun equivalents of that Glock frame, which may be marketed as the SS80 or PF9SS.
In your explanation just now, you said the evidence items that you examined. Are you talking about these cartridge cases that were item 1 in that exhibit People's 32?
That's right.
Okay. And you're saying that the class characteristics that you saw on these cartridge cases, those 3 characteristics, that it was 9mm, that it had a teardrop-shaped aperture, and a teardrop-shaped firing pin impression, those are the characteristics you were using to narrow it down to these 4 types of firearms?
Yes, that grouping of class characteristics is known to me through those resources. I've only been able to associate it with this one particular aftermarket slide. And this aftermarket slide is compatible just with a few styles of guns. The known brands and models are listed there.
Those 4, right?
Yes.
Okay. Well, let's talk about your finding, or the conclusion to your analysis. Have you summarized your conclusion on this slide, People's 59? Go back to.
Yes. Final conclusion. What you're not going to find in the report, I cannot say this configuration only comes from brand X. What we know is that after some considerable research, I can give you the list of candidates that we know to be consistent with these items. While these are consistent, we cannot really say that these are the only ones which will ever be manufactured with those general features. Due to that, the qualifying term, but not limited to, always appears in type and caliber findings, such as the ones I've produced.
So why is it, again, that you put that qualifying statement in your analysis? Because, correct me if I'm wrong, but you stated 9mm is a very common caliber, correct?
Yes.
But at the end of your type and caliber analysis, you really narrowed it down to those 3 features were only really typical of 4 different firearms that you have seen come through your laboratory, through your research on the AFI resources, and cross-comparing that with Leavin. Am I stating that accurately?
Yes. Based on the research that I've described, I have only encountered empirical evidence showing me that this grouping of class characteristics exists as a consequence of that particular aftermarket slide. That's all the information that I could determine after some relatively considerable evidence.
But you don't limit it to just those 4 firearms, fair to say?
Correct. You can't state that it's those 4 and only those 4, because these class characteristics are voluntarily chosen by the manufacturers. They can change. It's also possible that there are other items out there that we have not run into. Any research material I use is finite. So for that reason, we include that qualifying mark to be overt.
But after your research in this area, you narrowed it to 4 that you, those 4 different firearms were the only that you could find that had those 3 class characteristics among them, correct?
Objection has an answer.
That's it. Thank you, Your Honor. That's correct. I'm only aware of the aftermarket product that's compatible with those 4 models.
Okay, that's all I have, Your Honor.
All right, we'll take a 15-minute break.
Right,
folks.
break
Please be
and then
outside
cross,
before the
so-
doors at, let's make it 3:20. Please don't discuss the case.
I mean, the last 2 minutes were like the important part, if you ask me. Like, we can't say it's from a specific candidate. We have to qualify it because we don't know. So, and I'm a little bit confused between like, so are they trying to create a pathway where it could have been a Glock 43 or it could have been some like aftermarket ghost gun that they put together that was capable of, you know, using a Glock 43 mag. So there's 2 options where this mag that was found in Rocky's home that the manager is going to testify that it was actually his, and it's confirmed that he did have another registered firearm in the house. Lewin had a registered firearm in Rocky's house in April of 2022. Like, is that just creating another pathway? So if there's like 10 possibilities, 2 of those possibilities could be something that we could very barely tie back to something we found 6 months later. A magazine, not a gun that we tested and fired something through to see if the markings would be similar. And we got to all of that in the last 2 minutes. And this was like, what, like an hour and 40 minutes of this guy being on the stand. So I think cross should be short and to the point. I don't think it's just going to be 1 or 2 questions. I think it'll be, for certain, it'll be relatively short compared to how long that was drawn out. But I think we're going to get some questions, you know, did the district attorney provide XYZ for you to look at? Different questions. Yeah, and this is the other thing too. Don't forget, you guys, the jury also might be doubting that Relly's injuries were caused by this at all, right? And will they come to the conclusion that the firearm, if they think it's real, does that meet all the elements as charged? Because brandishing isn't enough. They can't charge a lesser offense of brandishing. And I don't know, like, Relly was kind of wishy-washy on the first parking garage area. Like, he had a previous statement where he said he felt it in his stomach. Pause. He felt Rocky push the firearm up against his stomach during the first part. He said that in a prior statement, but when he was testifying, he didn't say that. He didn't say the same story. So, I don't know. I don't know. Whatever it is, it's a hot mess. It's a hot mess. Micah says bring in a medical expert for the knuckle scratch. And that's the thing, you know, like if they decide, because there could be a lesser included that goes back with the jury for just assault. But right now, like an aggravated first-degree felony assault, if they want to send a lesser included of like some type of felony assault back without the firearm attached to it, then the jury would need to meet other elements, right? With the presence of a firearm, you don't need to have the element proven of risk of serious harm or death, because the firearm is defined as something inherently deadly. But if you send back a lesser included of assault with like a felony assault that still has injuries that need to be more than scrapes and bruises, simple assault, elements, injuries are consistent with scrapes, superficial bruises, things like that. You don't have that evidence either. So if we take away the firearm, I don't think a felony assault is on the table to go back as a lesser included. So, and that's the thing. Why PCOM chic? I mean, if we get 12E, if we get, like, what if Lydia comes up there? I think Joe, and I'll admit it's judgmental of me to say so, but we're hearing that Lydia is an escort. There's a lot of money. Relly can't be clear with us on whether or not he has money or not. After this fallout, he lost all his business, but then he still has money and he's fine. Well, if he's doing a type of business venture with Lydia, Lydia's giving him like $2,400 cash. I mean, it might be more believable to think that he is the one that has a ghost weapon, a ghost gun. For him to have a gun at this point, since the detective told us that he didn't have anything registered to his name, it would have to be something unregistered. So, it is judgy, but it just seems like the scenario might warrant someone having an unregistered firearm for protection. So, yeah, where is Relly's hospital report? I don't know, but I mean, I don't think it's all that necessary. Obviously, the prosecution didn't feel the need to bring someone in to introduce the full hospital report. So, and the jury can consider that. The jury can consider, well, you didn't actually, state didn't want you to hear that stuff. Also, big shout out here. I have loved, if you guys haven't been paying attention in the chat, if you guys have been just listening, Chloe has been doing, like, someone said it's like QVC shopping. She's got it down. She's got the clothing line. She says, just dropped ASAP Relly friendship bracelets, 2 slogans available. Tried to kill me, and I'm gonna be itch. Come in scabby brown or paper cut red. Get yours today. There you go. There you go. Shout out to friendship bracelets. You ever do that? You ever have like a friendship bracelet or like the necklaces that has one half and then another half, and then you guys aren't friends anymore? It's like, what do you do? What do you do? Yeah, it was $24K cash. That's coming from Joe's questioning, which isn't supposed to be evidence, but the idea's out there, the vision's there. I picked up what Joe was putting down. So, oh my goodness. Alright, so I'm going to rely on the chat a little bit for some of the firearm stuff. I'll rely on you guys for the conversation because I'm not an expert there, and this didn't... Again, I really think the last 5 minutes of that were what was relevant to the evidence available in this case, and I don't see how it's supposed to move the needle, and we're about to be on cross. But Joe Schmo says this whole ghost gun nonsense is nuts. The mag was from a Glock 43 X, which will not fit in a G43. They don't make ghost guns in G43 yet. So I don't know about any of this, but like this is interesting to me. And I wonder if we're going to get this crossed. So like this whole thing is interesting, and even if it was like a G43 mag that's in the house, so they're saying that at some point Rocky could have had access to a magazine that could be used in a Glock 43. Even if this firearms expert, this forensics guy, when he did his type and caliber analysis, even if he said it had to have come from a Glock 43, I don't think that would be enough for me because a Glock 43 is one of the most popular selling firearms. So the amount of places that casings that were without a doubt fired through a Glock 43, any Glock 43, but only could be fired through a Glock 43, it would still be so many options. And on top of that, I mean, that's not what he found. He said that there could be, what did he give a number? he couldn't give a specific, he couldn't narrow it down to one specific make or model of firearm. He couldn't even narrow it down to one specific manufacturer. So, I mean, like, the pool of options is just, it's like a diner menu. Like, he didn't really do much to constrain. I actually thought it would be more constrained. Like, it'd have to be a Glock 43 and maybe one other sister model. And we didn't get there. We didn't get there. Let's see. Yeah, I don't know if they're still representing the case. I mean, I don't see any filings, but I surely will be looking. Again, the next hearing for the personal injury is set for February 25th or 26th. So I'll be checking the docket for updates on that one. And I'll download whatever's filed in. We can read about it, see what goes on. And by then we should have a verdict in this trial, an outcome. Also, oh, are we? Thank you. All right, so we should be caught up with live. Thank you. Is it X or Etches? And let's see. Gina just says, "Child, I'm tired." Yeah. I mean, I think this will be a little bit quicker, and then maybe they'll squeeze out the motion for directed verdict before the end of the day. If John Lewin is arguing back against the motion for directed verdict, we might have to start the morning with the rest of that. But, oh my goodness. Let's see. We've also got Cap 1 saying, "I did research. Prop guns doesn't strike a bullet the same as a real one. I hope Rocky Team can prove this." Now, they're supposed to be calling an expert, and they're also supposed to be calling a Mr. Phillips as a witness. I believe Mr. Phillips, it could be an and or situation, but it seemed like he either procured a starter gun for Rocky and or modified it. So if he modified it to make it a starter gun, it could have at one point been an operational firearm. I think there are situations where, you know, prop guns can still leave markings on the casings. And what I thought, thank you for the super chat, by the way, and the food for thought. What I thought was interesting is in the chat, David and Calvin both said, David said, without a microscope, you can see those markings don't match. There were the two rounds on the two casings on the screen. Calvin said, looks like they were fired from two different firing pins. So this makes it extra interesting because, like, if that's the case, were these fired at different points in time? Like, because can you imagine that? Imagine Relly thinks he's firing at a shooting range, and there's some casings kind of like plopping over. Like, imagine you get two similar loaner guns, and the person in like the little cube cubby thing next to you firing something similar, but they're two separate objects. And he just goes, the casings like plop like this, and he just picks up two that look the same, but one was really fired from the guy next door or girl next door, right? So there's a possibility if this was originating from a gun range, I could foresee how someone could get casings fired by a similar model, same make and model, but technically different individual firearm. Right? So very interesting food for thought from the chat here. So big thank you to Cap1, also to David and Calvin, because, you know, this is foreign to me. I'm just trying to take it in and process it. And again, I still think when it comes down to it, if we can't say this came from a very narrow pool of possible firearms, and then we only have a magazine over here that had a different make and model ammunition in it anyway, the dots, to connect those dots is too far of a reach. With a highly unreliable witness with motive for money, right? Maybe I'd feel differently if this didn't look like a setup for 30 other reasons. 30 million other reasons. Now, Nick Starro says, did you see Fani Willis's Grift Gala flyer? Is there a new one? I did try to look, but my Twitter is very flooded, and I saw an update. Quick update here if I can pull it up before. I did see this, so I don't think it's what Nick's getting at here. So my bad, but it seems like House Judiciary Committee is seeking testimony and documents from Fulton County DA employees. So I'm assuming this is still in relation to, the denial, the FOIA requests, the public records requests. They're not letting up on that. Maybe it's something else, but saw that update real quick. As far as the Griff Gala flyer, I know she was like doing one before when she was supposed to testify, and then she didn't show up. So that would not surprise me. Thank you, Nick. Thank you also for your commentary in the chat on the science behind this analysis, this tool mark analysis here. Okay. I will look for it. Yeah, Sly said Relly said 4 shots were fired. Why did he only recover 2 shells? And that's what's interesting, because we heard the detective volunteered on his own. Well, not really. The prosecution was trying to, like, if you're the one that got shot and you know where someone was standing when they shot at you, shell casings don't go as far as bullets typically fly, right? So I think the prosecution was trying to do some cleanup work, mitigate some of the inconsistent testimony from Relly by asking about shell casings and how they fall. How far away do they fall from where they're ejected? So we had the Detective Flores on the stand doing the, I fired and they fall on my shoulder. And he's pointing that they kind of like fall around you and close. I think the prosecution's goal there was to explain whatever. Now, we have 2 problems. He thought he was shot 4 or 5 times, which they're relying on the audio now to just say he was mistaken with his count. But what's a bigger deal for me is this idea that Relly kept saying he fired straight down. And I get that a bullet fired pretty close to pavement, you've got ricochet, right? It doesn't mean that it's going to be shot straight down and stay there, stop moving as soon as it hits the pavement. But there's no defects, there's no damages, there's no bullets nearby. You only find the 2 casings, and he's shooting straight down. 7 officers don't find anything. Seems like this is a nicer neighborhood, so something about it just doesn't seem reasonable. I don't think he found the casings just because casings don't bounce very far and he knows where they would have been, because the police also looked at that same area. So, all right, hold on, we'll get there. Let me get this flyer real quick. Can I open it in a different window? Save it? What? Is this for real? A mistress of ceremonies? This can't be real. Are you sure this is real? Why would they call it this? Is that like a... What? I don't think this is real, Nick. If this is real, this is crazy. Why would they call it... Mistress to me has negative connotations. Oh my goodness. Oh, and now I broke it. Oh my gosh.
All right, just to let you know, folks, we're going to start at 10 o'clock. 10, not 10:30. So back on the record, all parties, jurors, and counsel are present. Mr. Siegel, Georgia, thank you.
Siegel's arguing. Motion for directed verdict. Let's go, Siegel.
Yes.
Oh, cross. Never mind.
Good afternoon.
I'm lost.
Good afternoon. You're employed, you said, as an analyst by the Los Angeles Police Department.
I'm sorry?
You're employed as an analyst by the Los Angeles Police Department. Is that right?
That's correct.
Okay. And specifically, you work as a criminalist in the department's firearms analysis unit?
Yes, I have for 20 years. Technically, my assignment has just recently changed. But yes, I operated as a criminalist in that unit during this examination.
What's your assignment now?
The toxicology laboratory?
Okay. Which obviously has nothing to do with ballistics.
Correct.
Okay. But in your prior role in ballistics, you were asked to examine the 2 9mm shell casings that we've been talking about, right?
Yes.
Okay. And you prepared a report containing your opinion regarding that analysis, right?
Correct.
And you finalized that report on January 8, 2024?
May I refer to the report?
Please.
Thank you. Yes, the technical and administrative reviews were completed on January 8th, 2020.
More than a year ago?
Yes, 1 year ago.
Okay. Are you aware that your report was only provided to Defense Counsel, meaning us, 2 weeks ago on January 23rd of this year?
Objection, Your Honor. Irrelevant.
Sustained.
Let me ask you this then. When did you provide your report to either the detectives or prosecutors in this case?
Once it was signed off, I would email it to the requesting officer, so that should have occurred in January of last year. I don't know the date that I actually emailed.
Okay. Would it have been signed off on by, let me see if I see the name here, someone with the name, last name Harbison?
Correct.
And who is that?
This is another Crim 3 in the Criminalist 3 in the Firearm Analysis.
And what's that person's full name?
Amanda Harbison.
Is she a supervisor of yours?
No, she is another technical lead. We have 4 details in the Firearm Analysis Unit. She is a Criminalist 3 technical lead in one of the other details.
Okay. And she signed off on this report after you on January 8th, 2024?
That's correct.
So it would have been around that time that it was provided to the detectives in this case. Is that fair to say?
Yes, it's my habit and custom. As soon as I get it back, just go ahead and email it out before I submit the case package for filing.
Are they getting into Brady?
Now, you were asked by Mr. Preslomic on direct if you evaluated any actual guns in this case, and you said, no, you did not do that. Is that right?
That's correct.
Right. You also did not examine those 2 shell casings to specifically determine if they would discharge from any particular magazine. Is that right?
The cartridge cases
Yes.
were not compared for cycling marks to a particular magazine. That's correct.
Okay. And as a criminalist, you're certainly aware that there is, if you made a reference to this now, a forensic evaluation available to determine whether shell casings were fired from a specific magazine. Is that right?
They aren't fired from a magazine. So what we're talking about is a cycling mark. This means just basically based on the fact that a live round can be pushed through the magazine into the gun. It's possible for marks to be distributed onto it without the discharge pressures, but it's not a typical examination that we do on a daily basis.
Right.
Your Honor, I'd like to launch an objection to get approach.
No. Your Honor,
It just goes to a
state
floor
the
two.
objection.
It goes to a floor 2 of the court previously.
You can't say it in open court, Your Honor. You need to do it outside.
Yeah, this, we did cover this. So this is off limits. I do recall now. This is off limits. No.
Let me continue. No. So, in firearms analysis, class characteristics are general features shared by a group of firearms which are used to try to narrow down possible firearms that could have possibly fired a bullet. Is that fair to say?
Yes.
Okay. And those class characteristics do not identify a specific gun. Is that right?
Correct. As the name sort of implies, they indicate a class, a group of guns that may share a particular feature.
Right. And in contrast, individual characteristics, why don't you tell us, what are individual characteristics?
So individual characteristics are unintentional flaws that actually are created when the firearm is manufactured, also as it wears or corrodes over time. These microscopic flaws are pretty amazing because we can actually take guns off the assembly line and distinguish marks from guns even when they're manufactured one after the other. So these are individual characteristics that we would use in a traditional, I guess, microscopic comparison.
Thank you. So based on that, then, is it correct to say that class characteristics place an item within a category, general category, while individual characteristics can uniquely identify a specific item? Is that right?
That is how we intend to use them. Yes, the individual characteristics can be used to form an opinion of common origin, meaning that the examiner has determined it's their opinion. They agree because they were fired in the same manner.
Right. And in this case, you didn't look at individual characteristics, right? You just limited your analysis to class characteristics. Is that right?
That's correct. For type and caliber analysis, that's the procedure.
Right. We looked at those class characteristics to try to narrow down the possible firearms that could have possibly fired these two shell cases. Is that right?
We're looking for evidence of known guns that produce similar marks, and we attempt to produce that list because it can be advantageous.
Advantageous how?
It can eliminate whole groups of guns, especially calibers. There's, as I testified, there's a great number of calibers out there. We can immediately sort of push those off the table as potential sources. At the same time, we can generate a list that may be of interest should a gun of that make come across an investigator's desk. It should sort of let them know that it's possibly useful to pursue additional examination in laboratory.
And what you just said was that you do this examination to eliminate, your words, potential sources for the cartridges, right?
The class characteristics will eliminate a great deal of sources out there. Even our most common set of class characteristics are still eliminating huge numbers of guns.
Sure. And the purpose of eliminating those potential sources responsible for possibly firing a shell casing or a cartridge is to leave open other potential sources from which those shell casings derive. Is that fair to say?
Could you repeat that? I think I lost it.
Sure. You're eliminating potential sources for the shell casings, right?
Sources that are apples and oranges, don't have the same class characteristics, they will be eliminated.
So that's correct. My question is correct, yes?
That's correct.
Okay. And the reason you're eliminating those potential sources is to leave open the possibility of other potential sources from which the shell casings came.
Yeah, logically, that's correct.
Right, okay. Now, what you did was that you looked at the shell casings and you determined that they exhibited these general class characteristics, the ones you talked about. Is that right?
Yes, there are cartridge cases. I don't think we're going to mistake what you mean, but yes.
Okay. You understand that when I'm referring to shell casings, what they've been referred to throughout this trial, I'm referring to cartridge cases. Do you understand that?
Yes.
Okay. It is okay if I continue to refer to the shell cases?
Please, I don't think it creates any misunderstanding.
Thank you. And you determined that the class characteristics that you saw were consistent with having been the shell casings discharging a number of different aftermarket firearm slides. Is that right?
They are known to have come from a particular style of aftermarket slide made for a particular size frame.
Well, in your report, you noted that the shell casings, this is page 1, exhibit, these are your words, characteristics typical of aftermarket slides for a series of subcompact pistol frames. Is that right?
That's right.
Right. And then you identified a number of potential frames that were consistent with the characteristics that you saw. Is that right?
The frames don't create the characteristics. So the frames are compatible with the slides, which I know to be consistent with the characteristics.
Appreciate you saying that. Thank you for clearing that up.
Yep, he
and
does.
To be clear then, you're not comparing the characteristics with firearms themselves. It's the aftermarket firearm slides that you're using for comparison purposes. Is that right?
Yeah, I'm sorry, one more time.
Sure. You're looking at these class characteristics and determining that they are consistent not with actual firearms themselves, but with the particular part of the firearm, the aftermarket firearm slide. Is that right?
The slide of the gun is where these marks originate.
Right.
So that's what we can associate or evaluate.
Right. I think you just clarified, not the frame itself, but the slide that goes on top of the frame.
Yeah, that's effective.
All right. And in particular, with regard to the class characteristics, you observed that the shell casings in this case have a teardrop-shaped firing pin aperture. Is that right?
That is correct.
Okay. And the firing pin aperture, you spoke to this, right? It's really sort of just it's a hole in the breech face of the slide where that firing pin passes through. Is that right?
Yes.
Okay. And you also observed that the shell casings have a firing pin impression which is also shaped like a teardrop. Is that right?
Correct.
And you said that the firing pin impression also has a metal injection mold seam. Is that right?
It appears to have a linear mark that we associate with that particular manufacturing process, yes.
Okay. And just dealing with that first then, the metal injection mold, and that's simply just a line left in the firing pin from the manufacturing process. Is that right?
Correct.
Okay. And the firing pin impression, we spoke to this, that's just a mark that's left on the primer of the firing cartridge when the firing pin strikes it in the back, right?
Yes.
Okay. Now, after making your observations of the shell casings, you searched, you alluded to this, various databases for categories of I guess, firearms and firearm slides that exhibit those general characteristics. Is that right?
That's correct.
Okay. And in particular, you searched, what is it, the AFTI website, class characteristic matrix, that was called?
The class characteristic matrix, yes, is a search tool on the AFTI website.
Okay, and the AFTI, AFTA, that's just the Association of Firearm and Tool Mark Examiners, right?
That's correct.
Okay. Now, you looked at that database, or rather, you looked at, in addition to the AFTI database, you looked at the database within your own firearms analysis unit, and that's the NIDA. Is that right?
Yes.
Okay. And in addition to those databases, you also searched the firearms analysis units, your own units, those done collection of 229 discharge cartridges. Is that right?
Yes, cartridge cases. Correct.
Now, I think we spoke of this, but after conducting your search in the databases and making your observations, you rendered an opinion that the class characteristics that you observed on the two shell casings were seen in certain aftermarket slides for firearms frames, firearm frames, which included the Polymer 80 model PF9SS. Is that one of them?
That is.
The Glock model SS80. Is that right?
Yes.
The Glock model 43, right?
Correct.
And the Glock model 43X. Is that right?
That's correct.
Okay. Now, is it fair to say that this process that you talked about, looking at firing pin apertures, firing pin impressions, and determining whether they look like, in this case, teardrops or D-shapes or semicircles, it involves some level of subjectivity?
Yes.
Right. And in fact, that's why sometimes multiple people have to make determinations regarding how a firing pin impression or firing pin aperture should be characterized, right?
No.
No. Okay.
Amanda.
So in determining whether or not, you just said this, determining whether the firing pin impression or the aperture looks like one type of shape or another, if it fits into a hemisphere, I think that's one type of D-shape, excuse me, one type of firing pin aperture, right? Hemisphere, is that one?
Hemispherical is the more accurate term for something I just call round.
Round, okay. Is there a semi-hemisphere?
I don't know that term. No, there's one that is sort of a modified hemispherical shape that has sort of a beveled edge on one side, but it's not really called semi-hemispherical. It's been referred to as a D-shaped firing pin.
Okay. So in making the assessment, I think you said this already, there is some level of subjectivity.
To looking at shapes?
No, to determining what the shape is, right? In other words, these firing pins aren't standardized, right? You have how many different manufacturers making these firing pins? They're not going to be one particular shape, right?
They all make firing pins, yes.
Right.
And they
Different shapes.
use a range of different shapes.
Right, essentially broad range of shapes, right?
At least 3.
Okay. And in making the assessment whether or not a firing pin is one shape or another, you said this already, there is some level of subjectivity to this, right?
Yes, to looking at shapes.
And in that regard, that level of subjectivity doesn't just apply to you, but to the people who enter information in the databases that you rely upon, right? When they're entering information into the computer system, the same level of subjectivity that would apply to you would apply to them, right?
Sure.
Okay. Now, you identified these 4 pistol frames that would be consistent with the class characteristics that you observed, but you'd agree that those are not the only ones having aftermarket slides exhibiting the characteristics that you observed, right?
Not exactly. So the marks are known to come from particular size of aftermarket slide. That slide is compatible with these 4 frames that I know. That was what is meant by the report and notes.
Your report expressly states that the 2 shell casings exhibit characteristics typical of aftermarket slides for a series of subcompact pistol frames, including the phrase we saw on the screen there, but not limited to the 4 that you identified, right?
Correct.
Okay. Now, your analysis relies on the databases that you use for comparison purposes, correct?
For reference purposes, it's not a side-by-side comparison of marks. Yes.
I understand. But now, obviously, certain firearm slides, or let me just back up on this. I want to make sure the record's clear. In order for you to make or render an opinion, you're relying upon databases, right?
Published information, yes. One database is what I would call it, that class characteristic matrix. That's a searchable database.
Right. That's the AFTI, correct?
That is housed on the AFTI website. Yeah, that's one of their tools.
Right.
Correct.
And you use that tool to enter in search parameters, I guess, the firing pin aperture of a teardrop shape that you saw, and it generated a list of potential firearm slides that match that characteristic. Is that right?
That use the same shape.
Right.
Yes.
Okay. And you'd agree that the databases that you looked at are still being developed, right?
The class characteristic matrix is definitely a newer one. I would call it a developing database. Yes.
And to be clear, the list of firearms generated from your search are not all inclusive of the firearms consistent with the class characteristics that you observed. Is that right?
It can't be considered all-inclusive because it's based on finite reference information.
Right.
It includes all the ones that we're aware of. It is possible that there are, always possible there's facts we are unaware of.
Right. And obviously, certain firearm slides or class characteristics are not contained in your databases, they wouldn't be available for reference purposes, right?
Yes.
Right. In fact, you testified on direct that there are other possible items you didn't locate which are compatible with the shell cases, right?
There are other possible items.
Your words. Did you say that on direct?
I don't recall exactly, but you're talking about candidate sources that use this style of class characteristics. Is that what the testimony was about?
It's your testimony. Can you tell me, or you don't recall?
I don't.
Okay. So, would you agree that there are other possible firearm slides or firearms?
Objection to the word possibly, Your Honor, in the court's prior ruling.
Overruled.
Would you agree that there are other possible or potential, your words?
Potential is a better word.
Fine. Potential firearm slides or firearms that you did not locate which are compatible with the shell cases?
That's what I attempted to look for. I looked for them because they could be out there.
Right. And if they're not in your database, you would locate them, right?
They're not in the physical exhibits that we have in the house. And what was great is that I collected those and then 2 years later double checked against all the guns that have come into LAPD custody over that period. And either of those groups that are bookending the actual incident date came back with no other candidates that actually had that firearm.
So when you say you examine them, are you talking about the database? Are you talking about your collection of ghost guns? Is that what you're talking about?
The exhibits that I collected from the test firing of ghost guns, the physical exhibits that, yes, are actually in the laboratory, that's one set of data.
Right, that's the 229 ghost guns that you have, right?
Yes.
Okay. How many different makes of aftermarket slides exist?
There are dozens of manufacturers. They are pretty hard to track.
Right. Dozens of manufacturers. Could there be hundreds?
It's possible.
Right. And each of these manufacturers can make how many different aftermarket slides? Do you know? How many different types?
How many actual units they can produce?
No, types.
Types per manufacturer.
You don't know, do you?
No, they tend not to actually mark these components, so it is very difficult to track.
Right. And because you don't know how many different makes of aftermarket slides exist, you would know how many different makes of aftermarket slides specifically have a teardrop firing, an aperture, and a teardrop shaped firing. You couldn't know that, right?
Again, we treat it as an aggregate brand, okay? Because we don't know who's actually making them. I try to cast a wide net and look at all the products I can get my hands on that they've made. And I only was able to find one select species that was congruent with the others.
Right, based on what you can get your hands on, right?
Based on the intake into the Los Angeles Police Department, as well as that database, which is constantly growing. Correct, the NIDA database. It's constantly being fed.
Sure. And there's a reason that's still developing, right? Because you're looking for more information.
The developing one is the class characteristics matrix that is on the FD website.
Right.
I call that developing because typically we use a database of bullet rifling, and that's got like 15,000 exhibits in that database. It's been around for decades. That's a pretty robust database. This class characteristics database on that website that applies to cartridge cases is developing. So I used it to broaden candidates I might want to look at.
This is not how he was talking on direct. His face is all... I was using it to broaden. Like, his face is, like, contorting on the right side in a way I do not remember from direct.
But not as a resource that I would consider all inclusive at this stage.
Judge is ready for another question. Oh, a note. An assist from Tacopina. Whisper, whisper. Oh, and a pat on the back. Siegel's doing a good job, according to Tac.
Now, with regard to these aftermarket slides that have a teardrop firing pin aperture and a teardrop shaped firing pin, how many of them, let me rephrase that, how many firearms are there that are in existence right now, types of firearms, that are compatible with aftermarket slides with a teardrop firing pin aperture and a teardrop shaped firing pin? Can you give a definitive answer?
I can give an approximate based on my experience here in our flow of firearms into the LAPD. Is that sufficient?
And you would give an approximate answer without knowing all the different types of aftermarket slides that exist? You can give an approximate answer?
I can give an approximate based on how many in this group that we see relative to the total amount of guns that come into the unit.
Be the most common.
But those would be only the guns that are logged into your database. If they're not in there, you can't use them for reference purposes, right?
Those are guns that come through Leavin on a daily basis. So it is part of our daily business just to have these guns that are handguns will be input into the system every day.
Would you agree that Glock's a very popular firearm manufacturer?
I would.
Would it make sense that you find many Glocks in your database because of that?
Yes.
Including Glocks with aftermarket slides?
They do come through the unit. Aftermarket slides, sometimes on lock frames, overwhelmingly more common on the unserialized frames we call ghost frames.
By the way, is there any Glock firearms in existence in the United States now?
Objection relevance.
Rule. Oh, Block 43s.
Block 43s. Thank you.
In the United States.
Tens of thousands.
Sorry. No.
If not more.
Block 43Xs? Yeah.
No. In terms of our intake?
No, in the United States, at present. Because your intake doesn't intake every single firearm in the United States. How many exist in the United States? If you know, you don't?
I don't, in the United States.
Okay. How about the Polymer 80 model PF9 SS ghost gun frames? Now, how many exist in the United States?
No.
How about Glock's model SS80 ghost gun frames? Now, how many of those exist in the United States?
No.
Now, in addition to the ones we just named, the PF9SS, the SS80, the Glock 43, and the Glock 43X, your database search revealed other firearms with a teardrop firing pin aperture. Isn't that right?
Yes, as well as the published literature. Yes.
Right, such as Smith & Wesson, right?
Yes.
Mossberg, MC1SC, right?
I'd have to verify that model. It sounds correct.
Ruger?
Okay. How about other Glock Generation 5 pistols? Did you find that when you did search?
For the teardrop shaped firing pin aperture.
Sure.
Not the firing pin
The
itself.
firing pin aperture.
Yes.
In fact, when you did your search, that was the term that you entered in the query. You were looking specifically for just firing pin apertures with a teardrop, right?
That's for that one particular, the AFD class characteristics matrix. That is the only feature that I entered. So that's only going to restrict based on the aperture.
The answer to my question was yes. That's what you looked for, right?
That's where I wanted to be clear.
Okay, thank you. And you agree that that teardrop firing pin aperture has also been found on a Taurus firearm, right?
Yes.
Right. Specifically the Taurus GX4, right?
Again, that model sounds correct. I can check my notes.
Oh boy.
If you want, just so it's clear, it's on page 8 of your report, if you want to see it.
Yes, I'll returned a page of my case package.
It's the fifth result on the page.
Why specifically a Taurus GX4?
Yes, the Taurus model with the teardrop aperture that I'm aware of is a model GX4.
Now, as you said, you observed on the two shell casings this teardrop-shaped firing pin impression. Is that right?
That's correct.
And you'd agree that the Glock 43 exhibits class characteristics which include a D-shaped firing pin impression, right?
Yes.
Likewise, the Glock 43X exhibits class characteristics which include a D-shaped firing pin impression, right?
The Glock manufactured slides. That's correct. They have a different shape firing pin impression than the one that I observed.
Right. The teardrop shape is distinct from the D shape.
Yes, very much so.
So to be clear, the Glock 43 and the Glock 43X do not depict teardrop firing pin impressions that are even remotely similar to the shell casings that you examined. Is that right?
That's correct. It is the aftermarket slide, which is compatible with those two frames that you just listed.
Right. Not the Glock
That aftermarket slide does produce those models.
Right. But you didn't connect it to a Glock 43 or Glock 43X that you said are typically sold here in the United States, right?
That's correct. The standard manufactured Glocks don't match.
Okay. So in other words, the shell casings you recover are inconsistent with the class characteristics of Glock 43 and Glock 43X firearms, right?
These slides manufactured by Glock and sold. That is the part that does not match. The slides that are aftermarket, which are consistent, are compatible with the Glock 43 and the Glock 43X.
And the slides that are sold by Glock for the 43 and 43X are not compatible, right? The Glocks themselves, I'm not talking about aftermarket slides. I'm talking about Glock. You go to the store, you want to buy a Glock that's sold from Glock. Glock 43, Glock 43X. It's not your those shell casings did not come from a Glock 43 or 43X, did they?
They did not come from a slide that is manufactured by Glock.
That's what I'm asking.
Such as I'm aware of. When I say compatible, we are talking about the compatibility of a slide and the frame. So the frame is manufactured by Glock. The slide manufactured by Glock, they're compatible, they can work together. The slide manufactured by Glock does not, however, produce these models.
And for that matter, most of the polymer 80 model PF9SS and Glock Store model SS80 samples that you looked at in your post-gun collection exhibited a D-shaped firing pin. Is that right?
Yes, it's a smaller group of those ghost guns that actually have this particular slide in my collection.
And in fact, in your collection of those 229 ghost guns, only 2 Glock Store model SS80 samples exhibited both the teardrop firing pin aperture and the teardrop firing pin impression. Only 2 of them, right?
Yes, it's rare.
Yeah. So most of the PF9SS and SS80 ghost gun samples that you looked at were not consistent with the class characteristics you observed in the shell cases, right?
Yes, that's correct.
By the way, despite your analysis, just so it's clear, I'm going to throw that. Mr. Biraimah, the same marks that you observed and testified on the 2 FC 9mm shell cases could have been made at a firing range, right?
Yeah.
Yes, I don't know where they were discharged.
Thank you very much. I have no concern.
Oh, they're gonna call a witness that's got this.
All right, let me, before you do that, let me see you all at the sidebar. I have a...
Wow. It's like...
Initially off.
All right, so it sounds like we're going to get into motions later. The judge just said initially off, and then the camera can come back on. So we're going to get more from the attorneys. Well, maybe we'll get redirect. I don't know. But Siegel, applaud for Siegel. I like that kind of lawyering. We ended on the note of, firing range, firing range, firing range. And that could just be an earworm, but that could be an effective earworm. However, I really think they've got something. They've got something else. We're going to have to wait and see. But why were we asking so many questions about this Taurus GX4 specifically? I really think they're going to go for it. They're going to go for it. So it seems to me, super layperson on this subject matter here, but standard Glock 43 and Glock 43X would not produce markings consistent with this teardrop shape that's on the shell casings. However, I feel like when it was direct, we kind of got to that, but it wasn't accentuated. It wasn't underscored. Because why would the prosecution underscore that? But the defense now brought that to the surface, repeated it multiple times, got the witness to repeat it, and also I think the witness seemed reluctant to just say yes, that this would be inconsistent, this wouldn't be the type of marking that could be produced by a Glock 43 or a Glock 43X. So, to me, for you to tee that up, lay that down, get this guy to keep trying to do this reach and say, but if the slide was replaced, if it was a ghost gun, if the slide was replaced, it could be consistent with something that the slide might leave on the casings. Now we're getting into could be territory. And then you finish it off with, what about something from a firing range? I don't know. As a layperson, this to me seems very, very good. I think this is very, very good. And I'm enjoying seeing this attorney at the stand. Let's see. Lisa says the judge is probably standing on his head now with this line of questioning. Yeah, Lacey Ann says, why the F would Rocky buy a Glock and change the slide? I mean, I guess possible, right? But should we be reaching so far into the goodie bag to find, the less probable thing when seems like we have other explanations that make more sense? My opinion. Sabata says, Sir, you are here to testify to the truth, not on behalf of one side or the other. Even though called by one side, the jury can see you wriggle, sir. Yeah. Lacey Ann, I really feel like they have a witness. And I really think they're going for it. It's not just the starter pistol seems like an explanation of what Rocky was carrying. And it's not that he's touching somebody with an inherently deadly weapon. That's to clear up the assault elements. But now you're giving the jury something to explain why these casings are there, and they're doing it very, very well. And it's the state's witness. If we might get redirect, but since this is supposed to be the state's last witness, let's do an exercise, chat. If this case was kosher, if the things lined up, what witnesses would you have expected the state to call in their case in chief if this wasn't so messy? There's a lot of people they didn't call. So let's do an exercise, chat. In the meantime, while you guys are, catching up, brainstorming, thinking of your answers on what witnesses the state could have called if they wanted to substantiate their story, their theory of the case. Yep, Nick says that's all they needed from him, pinned him down to a specific answer. I don't know if the judge is it depends on how long they argue here at the bench or whatever they're doing. Maybe they're not actually arguing. Yeah, Lacey Ann, I think that too. That's what was shot at the shooting range. I mean, I'm pretty sure when you go to the range, you have to fill out what model you're renting from the facility. All right, we got Recross. Redirect.
Have you seen the combination of class characteristics that you saw in this case from any gun that did not have an aftermarket slot?
No.
And I know you said it, but if you can answer, what size frame is it that slide would be compatible?
I've seen these marks from an aftermarket slide, which is compatible with a Glock 43, Glock 43X, as well as 2 ghost gun frames, the SSE and the PF9SS. These are the frames that I'm aware of.
Are those size frames, the size that's compatible with a 43 and 43X, are those common frames that you see in your lab?
They are relatively uncommon.
Can you explain that to the jury at all?
So based on my background experience, as well as some of the facts and figures that I sort of curate as a trainer in type and caliber with LAPD, I'd be comfortable stating that we see these guns in the flow of guns that come into the unit at a range, we're talking around 1%. Definitely, I'd be very comfortable saying they're in the low single-digit percent range for how often we see them in the flow of guns into our unit.
And the class characteristics that you're talking about, are you observing shapes on the back of the fire cartridge cases, correct?
That is what a class characteristic is, yes.
In counsel's questioning, he asked you if there was subjectivity in that determination of what the shape is on the back of the cartridge case.
He did.
What is the subjectivity in that determination?
Anytime we look through a microscope, we look through a telescope, we are perceiving information. This is a standard way of performing science. We will attempt to try and make sure that we are repeatable, reproducible in these observations. We document them very well, take photographs, and at the end of the day, they are in better condition when I'm done than when I started. They can be re-examined again. So there is subjectivity in determining what's a square, what's a circle, for me as well as for my kids. But here in the laboratory, we have procedures that we can use to assure that there's quality results in that subjective determination.
Was that a hard determination for you to make, to determine that the aperture impression on those fire cartridge cases was a teardrop shape?
No.
Was it a difficult determination for you to make to say that the shape of the firing pin impression on those fire cartridge cases was also a teardrop shape?
No.
You have what, 19 years of experience in the firearm analysis unit?
Correct.
Is making that determination something that even a newer analyst could do with relative ease?
Objection, Your Honor. We have a grounds also for your speculation. As phrased.
It's a basic determination in our first week of cartridge case comparison training. You should be able to do this.
Okay. With the database searches that you conducted, you said that the class characteristics database on the AFI website was a developing database, correct?
That's correct.
Is Leavin, is that a national database?
It is.
Used throughout the country?
It's used throughout the country, I believe possibly internationally, and it's been used over the course of my entire career.
A large database?
Yes.
Okay. I don't, sure. Last thing I wanted to cover was counsel asked you questions about other guns that were listed in your report or manufacturers that used a teardrop aperture. He specifically mentioned the Mossberg and the Taurus GX4. Are you following what I'm asking about?
Yes.
Those were firearms that you observed had the teardrop aperture, correct?
That's correct.
But did those firearms also have the teardrop firing pin impression?
No, the firing pin on those firearms is drastically different.
So can you say that those guns were not, could not have been the guns that fired these cartridge cases because the class characteristics do not match.
Okay, we don't perform a one-to-one elimination over just digital images. The class characteristics I see there, if I had those in the laboratory, they would constitute a elimination. They're not from the same source.
Because the shapes are totally different.
That's correct.
Okay.
Can't actually eliminate it.
Anything? Steve? Your Honor. All right, Mr. Biraimah, thank you very much. You are excused.
Thank you, Your Honor.
Your Honor, there's no further witnesses from the people subject to the admission of our exhibits that we will address.
All right, we'll deal with that tomorrow morning, so the defense should be prepared to present evidence tomorrow at 10 o'clock. Before you leave, I want to mention something to you. You heard Mr. Biraimah say that he did not do any analysis of the shell casings that were found, or Mr. Ephron said he found. He didn't, Mr. Biraimah did not do an analysis of those casings to the magazine that was recovered at Mr. Mayor's house about 6 to 7 months later. For legal reasons that do not matter to you, about 2 weeks ago, I advised both sides that an analysis of the casings and the magazines need not be done. Okay? All right, please don't discuss the case among yourselves or anybody else. Hold on. Remember, 10 o'clock tomorrow, we're going to resume. Again, please keep an open mind. Do not look at anything online or in print media regarding this case.
Your Honor, there should be in that amount of court did not say that therefore they're not judges.
No, I gave the what I wanted the jury to know. All right, folks, see you tomorrow at 10 o'clock.
He wanted a stricter instruction. He doesn't want... Now, this is interesting to me because prosecution, John Lewin is taking issue with the instruction not including don't speculate why they didn't do a physical analysis of the casings. But they're the ones that ended on that note of how he didn't look at the physical casings. So why would you highlight that if you know it's problematic for you? Yeah, and honestly, him highlighting it's just highlighting it more. No, it can be presented, but it's
all right, seriously, what did you want to say?
From the digital photos.
The court did not state the end of it. It could not consider that evidence not be tested. In other words, you told the jury,
He's whining.
Either both parties that they couldn't test it. You didn't tell the jury, so you cannot consider that, etc. In other words, they got an explanation but no explanation. They might, I'm not saying that they won't on their own decide that because the court said that they won't consider it, but there wasn't an explanation. That's all. I thought the court was admonished for it.
I'm sorry, what did you ask? What should have been told them?
So, no, just adding the last part of it. So you told them, at my instruction, that evidence was not to be tested. But they were not told the next part of it. For that reason, you are not in any way consider that as part of the evidence.
They've been told time and time again that their decision in this case can be based only on the evidence that is within the universe of this crime. I don't think it's necessary to say that.
Your Honor, the last thing for us, we just want on the record, it's our understanding
No, just jump.
That the court has had us indicate who the next witness is going to be. We just want to have the defense indicate what the order of their witnesses are going to be as well.
I've already told them that.
Who's first on the record?
So you want it on the record? So don't ask me off the record if you want it on the record. Mel Phillips.
Say again?
12.
That's 12?
Yes.
All right, and assuming we get through 12, who would be after?
Who will? 11.
All right.
We'll be 11.
I just say one thing. I mean, it's just a constant barrage. You gave an admonition. You said, I told them 2 weeks ago not to test. That doesn't speak to the time before 2 weeks ago. So the jury can infer anything they want before the 2 weeks ago.
Okay.
So if they can infer, so an instruction that they can't infer.
Both sides are entitled to argue reasonable inferences from the evidence. All right, does anybody have anything else before we recess?
No, sir.
Thank you. All right, remember folks, 10 o'clock.
We've got 12B and 11.
Or do you want to have them email us if they have any problems, and then we can take it up if we need to?
Yeah, I don't, all of these exhibits, I know no reason why these exhibits are not being used. I don't think it's going to be an issue.
Oh my goodness. Yeah, just ridiculous, just ridiculous. So, I mean, the whole kerfuffle there is the type and caliber expert that we got from the state, and also whoever the defense calls. They weren't doing a physical analysis of the casings. Like, they're not getting like a millimeter depth of the markings or anything like that. They're just looking at that digital photo, the same ones that we saw on the screen. So it's already subjective, but there's an extra layer of subjectivity. Judge gave an instruction on that neither side is looking at the physical, they're not doing a physical analysis. So there might be a directed verdict motion, maybe not, but it seems like we're getting 12E. Tacopina expects to get through 12E tomorrow and get Lewin on the stand. So that's going to be interesting. I think it's important for them to get Lewin on the stand because Levin's going to testify about this magazine that was found, and also ownership of his own Glock that the magazine, in theory, belongs to. And I think it'd be helpful for them to get to that before the weekend, right? Tomorrow's going to be Friday, no court for 2 days, and it might be helpful to have this punchline when we just had this type and caliber analysis introduced to the jury today. He told the jury to be back at 10 tomorrow. I don't know if they'll start at 10 or 10:30 Pacific. If they're going to start at 10, the stream will be 1 p.m. Eastern, 10 Pacific. I'll start on time. But I've heard him say 10, get here at 10. That way they're there and present to be able to start at 12:30. But we'll go live when court goes live tomorrow. We might have a separate stream tomorrow morning for the status hearing for YSL, for the YSL 2. We might be able to get the replay in. Law and Crime cannot televise, cannot stream Diamante Kendrick's probation revocation hearing live, but they can record it and upload it after. So if that's up there in time, we can watch it before the Rocky trial starts tomorrow. If not, we'll watch it on lunch break since they're so long. And Courtney Clenny, if there's a Courtney Clenny televised, a streamed hearing tomorrow, we can check that out too because it's a motion to compel the deposition testimony of a prosecutor. So, Tacopina's fuss at the end there seemed like he just wanted to state his record, pissed off at John Lewin. Because the judge was like, I know. So, also big thank you here. Taco Tuesday became a member and said in the chat, I know I'm a little crazy, but you're welcome here, Taco Tuesday. I think you're a fan favorite here. People love your name. Lots of feedback on your car as well, the car in your picture. So thanks for becoming a member. You're absolutely welcome here. We are glad you are here. Let's see. Gina also said, never saw Rocky's arm raise above his waist. And I think this is going to be so interesting if the jurors are now inclined. There's reasons that they could believe he had a starter gun. We're going to start getting into evidence from Lewin that shows that that magazine probably didn't have anything to do with what Rocky was carrying on him that night, which would help support the idea of it not being an actual firearm. It's fighting back against the state's theory that because this magazine was in Rocky's house, therefore Rocky had Glock 43 or Glock 43X on him on November 6th, right? And we're getting some distance between that, which is a far away connection to make anyway. Yes, so YP Kamshik, isn't Taco doing his own research on this ballistics report, this type and category analysis? Yes, they will have their own expert, and that's going to be closer in the jury's mind, I would think, than this. So, heck yeah, we can do Doug Weinstein's going to be on Justice Served, so we can set up a redirect and take a trip over there. Say hey to Linda, to Michael, and of course to the Honorable Doug Weinstein. That'll be a good time. Guys, I gotta do my sponsorship plug before. Actually, wait, one more thing. Chris, I think I screamed, hey, Chris, over the mic, but let me do this properly. It is great to see you, Chris. You don't get to pop in that often these days. In the chat, you say why. You say, hey, cat and chat, working and lurking. So hope you are doing well. It's been great to see you. A little bit boring, but important testimony today, because one of the issues at heart is, you know, these two shell casings, where did they come from? And could they have come from the thing that Rocky was carrying? Is it believable that Rocky was carrying a starter arm? Is it believable that he was carrying a semi-automatic? Where are we going to go? So super, super important. Touche says, time flies when you're having fun. Best chat around. Now, I appreciate this, but I think everyone felt like time was dragging today with this witness. So it's hilarious you say that. I don't know if the chat will necessarily agree that time was flying, but I'm glad you think so. And look at that, chat. Touche says you guys are the best. Says you guys are the best. Also, our exercise here. You guys are wondering, the state rested, but they could have called Lydia. They didn't. They could have called Relly's business partner. They didn't. They could have called, you guys said a few other people. They could have called a bunch of people and they just didn't do it. So, oops. I mean, really, if they wanted to, they could have called Relly, but he didn't want to speak to them, so they probably thought it was safer for the defense to call him. Because you can't really call someone and say, like, you didn't want to be here, but I'm the one that called you. It would be kind of a little confusing. But yeah, so yeah, call Rihanna to the stand. Just do it. Just do it. But with that being said, we're going to end with our sponsor. You know, I'm sponsored now, you guys, by Relly's Reliable Brass Knuckles. We've got Chloe with the great pitch here. You know, she's our advertising person in the chat. She's writing all the script copy. She says, hit the thumbs up and get your very own Relly Reliable Brass Knuckles. It's great for punching walls or stopping bullets. $19.99 plus $30 million shipping and handling. There's payment plans available, but they're limited in supply, so you want to get them before they're gone. We get the extra fist to close it out. Hilarious on the $30 million. And this is so QVC, right? They'll do the $19.99 price, and then the shipping and handling is like, that's where it seems like they make their money. So this is so good. Detail to detail, Chloe. You guys show Chloe some love in the chat. Thank you so much, Chloe, for your continued support and all the laughs. And I'm going to set up the redirect, but if someone else is streaming right now, I'll try to see who I see pop up. We can shout them out as well. So this will automatically take us over to Doug Weinstein's guest appearance over on Justice Served. So you don't need to do anything. YouTube will carry you over there automatically. But if you want to go somewhere else, I'm going to look and see what's suggested. But the chat's going to give us some suggestions as well. So let me get to this redirect here. I could have done this in advance, but let's see. Justice Served. Oh, I see. Potentially criminal is recovering today, day 8. So especially if you join late and want to catch all of this testimony, that's a great place to go. Let me get Justice Served's link because it's not. Let me try Justice Served TV, one word. Oh, they don't allow me to redirect to them, you guys. So I'm switch that. It's not going to automatically carry us over to that. We're going to have to drop the link in the chat, or you guys can search Justice Served TV and you can find their channel. Doug's going to be popping on over there. And we'll go over, we'll do potentially criminal for the recap here on day 8. And then I want to check, is Flesh of the Gods going to be live later tonight? Save that. No, potentially criminal knows a lot more about firearms than me, so you firearms people have a great conversation over there. I don't mean to not understand you guys. I try to follow you guys. It's just not, I'm slower at picking up on it. But if you enjoy having conversations about firearms analysis, I think you'll love, there will be more people that know guns over there than me. So Potentially Criminal would be a great time because he's a criminal defense attorney, used to be a prosecutor, knows firearms, and so does a good portion of his chat. Let's see, Justice Served. Where's their stream for today? I'm getting their old streams. All right, and Doug is on right now, so what I'm dropping in the chat is a link over to Doug on Justice Served. So you'll have to click this if you want to get yourself over there. But hit that subscribe button so you know they have tons of great guests, including Doug on all the time. See you guys. I'm going to hop into both chats. See you guys somewhere. And see you tomorrow. Probably early for one of these other hearings. And then we'll go live when ASAP Rocky goes live. Nick Starro also says, watch my recap tomorrow morning if you need curses and growls at the Toolmark guy. Yep, that's right. I can imagine you like screaming at your screen watching this today. So also check out Nick Starro, you guys. That's definitely, if you like my deep sighs, you might like some Viking growls and grunts at the screen. You guys all have a good one though. Thanks for hanging out. See you somewhere else tonight or maybe tomorrow. Bye guys.